Thank you, ladies and gentlemen. You may have a seat. All right, at this time, I'll call upon the attorney for Mr. Whitaker for her opening statement.
Thank you, Honor. May it please the court.
Yes.
Counsel, Mr. Whitaker. On January 15th of 2020, Charles McCormick was shot in a strip mall by a lone gunman. There will be no question about that. You will watch the videotape. There will also be no question whatsoever. Leroy Whitaker did not pull that trigger. Leroy Whitaker had nothing to do with the death of Charles McCormick. That's what the evidence will show. You're gonna watch a video of Charles McCormick being chased down and shot. The shooter, the lone gunman in that video is not Leroy Whitaker. So how are we here? Why are we here? In this room, everything changes. See, before we come into this room, the state of Florida has the absolute power, the choice, the prerogative to charge or not charge whoever they want. But once we come in here to our Hall of Justice, they must prove their allegations. They must prove their allegations with actual, credible evidence. And I urge you to write right now in the notebooks that were provided to you a little topic I suggest to you. Evidence of Leroy Whitaker's participation in this murder. And ladies and gentlemen, there's going to be one thing and only one thing at the very end of all the testimony, everything that you're going to be presented. It's going to be one name only, Dominique Barner. That's it. That is it. The state star witness of which their house of cards in their allegations against Mr. Whitaker will collapse. Dominique Barner, an admitted two-time killer, paid for, self-proclaimed, paid for assassin. Dominique Barner will waltz into this courtroom and he will try to fill the blatant holes in the state's case. Their star witness will explain to you, well, you know, on January 15th, the Jacksonville Sheriff's Office hauls me in. See, I don't just have tattoos on my arms. I have 1993 strapped right on my arm. Pretty distinctive. And Barbara Buckley did describe that in detail. And so the Jacksonville Sheriff's Office was able to put together a photo spread within hours of Barbara Buckley's home being invaded by Dominique Barner. And lo and behold, she was, in no uncertain terms, you're gonna meet her. She's gonna tell you all. Dominique Barner sure scared me. Dominique Barner came into my home. Dominique Barner choked me out. Dominique Barner got me to the point where I just kind of finally faked passing out and sat on my couch and then ultimately smoked a cigarette. Dominique Barner was caught. And to hear the state of Florida talk about Dominique Barner, one might think, one might assume, Dominique Barner must have walked in on January 15th and said, oh, I need to tell all my sins. Oh, I need to confess. But that's not what the evidence is going to show. What you're going to learn is that Dominique Barner came in on January 15th and he told just enough about himself to get him off his case. So let him go. He's still in jail, but he's not charged with murder yet. But then you're going to hear, as the murders pile up, see, there's this pesky second murder that you'll hear Dominique Barner was in part of, has admitted to premeditating, has admitted to pleading to that charge of a whole separate case where a truly innocent bystander gets killed. Because unfortunately, Dominique Barner misses who he was really gunning for. Interestingly enough, you will ultimately hear Abdul Robinson Sr., also part of that murder, also pled to that separate murder. But as those charges started piling up, Dominique Barner realized, I need to do what I do. I'll cooperate. See, by the time that Leroy Whitaker and Dominique Barner started spending any time together, Dominique Barner had already gotten his first cooperation against somebody completely different out of the way. Because that's what he does. Abdul Robinson Sr., same thing. Abdul Robinson Sr. has been cooperating since before Leroy Whitaker was born. That's what the evidence will show. But Dominique Barner will be the one and only piece of evidence the state will even attempt to convince you that Leroy Whitaker had any part in the death of Charles McCormick. The evidence will not be there. You're going to hear from Barbara Buckley, and I'll tell you up front, I think you'll like her. She's feisty. No one pulls anything over her eyes. And she's going to walk in and she's going to honestly talk to you about that morning. How it was just a normal morning, how she sees two people in her house, and she says in very colorful language, "Get the hell out of my house!" Dominique Barner didn't accept that, and then was violent with her. And because of that, she was able, in no uncertain terms, with confidence, with 1993 emblazoned on his arm, she picks him out. Dominique Barner did that. The second person, the other person in her home, she can't identify. What will the state try to rely on? Dominique Barner. Dominique Barner and Abdul Robinson Sr. have learned the system. They've learned what to say and how to say it. I urge you, listen carefully as they describe their cooperation agreements. For the two murders that Dominique Barner will tell you in no uncertain terms that he thought about, that he wanted to happen, he put into action, and did commit the murder for two human beings being gone. What does he look forward to? Well, he has every hope and expectation of walking amongst us again in 20 short years. No mandatory life imprisonment for Dominique Barner. Dominique Barner, by singing the company line, can look forward to 20 years. That's the state evidence. You're going to hear from DNA experts. And I urge you right now, as I remember from jury selection, some of you had done 23andMe, Ancestry.com. I urge you to listen carefully. You're going to hear words like, well, this unknown profile, well, it's consistent with perhaps Mr. Whitaker, and provide computations to try to explain that to you. It is not, I submit to you, and you'll ultimately evaluate for yourselves, like what was revealed for each of you when you did 23andMe and Ancestry.com.
Objection, Judge.
In the ground. I'll sustain that objection.
You're going to hear and see from FBI agent Mr. Corley. And he's going to actually map out for you different phone numbers, and he'll tell you up front, these are approximations of where these phones might have been communicating with towers. And it'll be a lot of convoluted radio waves, all that kind of thing. But he'll try to tell you where he believes these phones were in general terms in Jacksonville. What he won't be able to tell you is who was using those phones or when. And you'll have to listen carefully, and I urge you to do so, for all of the testimony in regards to whose phone is who, and how in the world do we know that person is using it. One thing you'll learn from Agent Corley as well as Jacksonville Sheriff's Office is that oftentimes they'll get phone records for a month or maybe even 2 months and go through the phones to determine who are these people talking to. Just as a way, an investigative tool, if you will, to determine who's actually using these phones. Ultimately, no such evidence will be presented like that in this case, as will there be many things that you will wonder about, but will not be presented. Why? Because the evidence doesn't exist. At the close of all the evidence, after you carefully and critically analyze it, you will realize the state of Florida is on a quest for conviction. They will do so on a house of cards of Dominique Barner, the two-time murderer, paid-for assassin. And at the close of all the evidence, you will ask, you will suggest and demand that you render the only verdicts that will be appropriate based on the evidence you receive. And those are verdicts of not guilty for Leroy Whitaker. Thank you.
All right, thank you, Ms. Schlax. All right, at this time then I'm going to ask Mr. Whitaker's jury to have a step back into your jury room while we bring out Mr. Robinson's jury for his opening, and then we'll bring you out here just as soon as we can. Thank you, ladies and gentlemen.
Okay, y'all, so just so y'all know, there are two separate juries in this trial. One jury is for Queso, the other jury is for Scotty. Why? Because Scotty has slightly different charges than Queso does. Scotty has a home invasion, and it comes from the time where after the murder, they allege that they go on a run, they separate, and Scotty and Butter end up in a woman's house to hide. And they allege that they hold that woman hostage in her home and then require that she drops them off at whatever location. Because of that, they don't want to inflame the jury. So they've got two separate
And
juries.
Ms. Kowalski, you need to have the podium turned around facing that.
So we're going to listen to the defense for Queso now. That was just Scotty's defense. We're going to listen to the defense for Queso. Just as another reminder, too, this was aired on yesterday. And so after this, we will jump over to today's feed.
My name is Tara Kawas, and I, along with Christopher DeCos, we have the honor and privilege of representing Hakeem Robinson. Now, the government just got up here and told you that they're going to prove to you, beyond and to the exclusion of all reasonable doubt, that Hakeem Robinson is the person who shot and killed Charles McCormick on January 15th of 2020. For members of the jury, they are not going to be able to do that, because Hakeem Robinson is innocent. And you are going to be able to see that for yourselves, that there is no way that Hakeem Robinson is the person that shot and killed Charles McCormick. In order to try and prove their case, they're going to ask you to do something that I've never seen before. They're going to ask you to not believe your eyes. They are going to ask you to ignore what you see right in front of you. Because as the government just told you, there is a video recording of this homicide, and you're going to be able to see it, and you're going to be able to watch it. You are going to see a person, someone, covered from head, or whatever's on top of his head, to toe, completely covered, chase down Charles McCormick in broad daylight and shoot him to death. And this was done in front of a bunch of witnesses. And the most important question in this case is going to be, who is the shooter? Who is the shooter? Members of the jury, that is the shooter. That is a still shot from the video that you will get. You will be presented with this during the course of this trial. And what these prosecutors are going to ask you to do is to find that Hakeem Robinson, who's clearly well above 6 feet tall and a heavier set person, and was like that 5 years ago, is that person. And it's not just that. They are going to ask you to ignore the descriptions given by each and every person that saw the shooter live. And members of the jury, these witnesses, each and every one of them are going to give you a description somewhere between 5'5" and 5'11". The other description they're going to give you, each of these witnesses that saw this person, slim, slender, thinner. And all those witnesses, they're going to ask you, the government, these unbiased civilian witnesses, discredit them. Don't believe them. They were wrong. The witnesses that they're going to ask you to believe are the ones who are actually involved in this murder. That's right. One by one, they are going to be walking them in here, some of them through that back door. Each one of them, hoping and praying to get some benefit from them. The people that hold all of the power to charge someone, to arrest someone, to drop charges. Them. All of these people are going to point the finger and go, the shooter is Hakeem. They are not going to present you one piece of reliable, direct evidence that definitively proves that Hakeem Robinson is a shooter. It's just going to be based on the lies of the people who actually committed this murder. This, members of the jury, is Hakeem Robinson. Stand up, Hakeem. He is a young, aspiring, talented musician who 5 years ago was wrenched from his family, his life, and his promising career. All because the government refused to look at literally what is right in front of them. And this is why I've asked Hakeem Robinson to stand up in front of you right now, members of the jury. Because you may not have taken too much notice over the past 3 days. Each and every time you walked into the courtroom and you left and we stood up, you didn't realize at that time how important it was to take a look at how tall Hakeem Robinson is and how big he is. But it is going to be the focal point of this trial. Because once you watch that video in the entirety, and then you look at what is standing right in front of you, and you're going to get pictures and stuff around the time that this took place. He hasn't changed, despite what Mr. Cooper is telling you. He is the same. There will be no doubt in your mind that he is not the person that shot and killed Charles McCormick. So how do we get here? You can have a seat, Hakeem. How do we get here where a clearly innocent person is being accused of a crime that he did not commit? And it boils down to perception versus reality. Because you're going to see that Hakeem Robinson, he wasn't arrested until 9 months after the murder. And none of them realized how big he is until he was arrested. But by that time, instead of admitting to the mistake that they made and pulling back and doing an investigation to find out who really did it, they doubled down. And they started to build their case and their witnesses around the idea and the belief that it was Hakeem Robinson that was the shooter. Now, 5 years ago, January 15th, 2020, right on the brink of the world shutting down, right before the COVID-19 virus, Charles McCormick woke up in the morning, headed to Employment Express Agency on Merrill Road to follow up with getting a job. Little did he know that a man named Dominique Barno, and I'm going to say this name for the first time, I'm not sure why the state didn't mention this to you, and his friend Chris Brown had been stalking Charles McCormick that day. Dominique Barno is the one who was checking his Instagram account to see if he was in town that day. Dominique Barno is the one who pulled up his address on the court clerk's website to find out where he lived. He is the one that then tried to track him down and kill him that morning. You will hear that the reason Dominique Barno decided that he wanted to have Charles McCormick killed was all because of a song that he didn't like the lyrics to. The whole story that Mr. Cooper failed to mention to you, members of the jury, is that Mr. Barno will just tell you, I just didn't like that he was singing something he didn't know about. That's the reason why Charles McCormick is dead. And this man, members of the jury, Dominique Barno, the man who planned and orchestrated the murder of Charles McCormick, is going to be the government's star witness in this case. That is the person who they cut it.
Sorry, fixing the feed. I don't know what. I just kind of blacked out for a second.
More important, you are going to hear that he took the stand in another case and lied in a hearing in front of a judge. And he's going to tell you the reason he did that, because he wanted the defendant to go free so he could kill him himself. That is their star witness who they're going to ask you to believe. This man was caught red-handed within 24 hours of the murder of Charles McCormick. And months go by of him denying his involvement. And when he realized that who they thought the shooter was, Hakeem Robinson, he pounced on it. He was like, this is how I'm going to get out of here. He decided he was going to lie to the government to get what he wanted, which is the hope of freedom. All he had to do and all he had to say was that Hakeem Robinson is the person behind that mask. And in exchange, I know Mr. Cooper was saying, oh, he's facing life, and that the judge hasn't sentenced him yet. But members of the jury, he's going to tell you the reasons he's doing this, because before this, he was facing mandatory life in prison. He would have died in prison. And in exchange for pointing the finger at Hakeem Robinson, he is hoping to get out in 20 years. Mind you, he's already served 5 of it. So in 15 years, he is hoping to go free. And Dominique Barno, not going to be the only one. Another witness that they are going to put on this witness stand and ask you to believe, a man by the name of Abdul Robinson Sr., AKA Blue. Now, Mr. Cooper got up here and told you that this man is Hakeem's father, his biological father, but the whole truth is, members of the jury, he's just Hakeem's DNA contributor. The truth is, he has 9 other children by 5 different women that we know about. He has probably fathered a significant percentage of the men or women in Duval County. He was never involved in Hakeem's early life and only came around when Hakeem started to become a little recognized, a little famous with his music, and he started to make some real money. He actually tried to become Hakeem's manager. As you will learn in this trial, in 2020, Hakeem was a local celebrity. He was a rap musician. And you're going to see that it was Blue is going to do what he's doing in this case. He uses people, and he was trying to use Hakeem. He is using the prosecutors in this case to get out of the 2 murder cases that we know that he have committed. He, just like Dominique Barno, was caught red-handed in this case. He is the person that Dominique Barno called for help to pick him and Leroy Whitaker up after they had broken into Barbara Buckley's home. But what you're also going to hear, members of the jury, and what is most important, this is not the first time that Dominique Barno and Blue have done this. That's right. Dominique Barno and Blue are co-defendants in a completely separate homicide case. They're co-defendants in that case, and they're co-defendants in this case. And you're going to learn that Blue, this ain't his first time cooperating with law enforcement. He's done that before. So he has experience. He knows that when he's in trouble and he is caught, if I say what the government wants to hear, I get out. He's done it before, and he's going to do it again in this courtroom. And what's more troubling with Blue, members of the jury, in exchange for his testimony in this case, he is hoping to get 76 months. 76 months. He's already served 60. So in less than 2 years, he is hoping to be back on the streets of Duval County. Now, Mr. Cooper just got up there and said the testimony against Hakeem being involved in this murder is going to be corroborated by reliable evidence. It is not. None of the credible, reliable evidence that he's going to bring in here says that Hakeem Robinson is the guy in that picture. Another one of the witnesses that they're going to bring in front of you, another one that was in that little diagram that they showed, Torrigan Williams. And this is even worse, members of the jury, because their own lead detective is going to tell you they've known for 5 years that Torrigan Williams was involved in this homicide. Dominique Barlow, years ago, told them Torrigan Williams was involved, but he gets a full pass. He's not walking through that door. He's walking through that door. Never been arrested, full-blown immunity for his testimony in this case. And you wonder, wait, why would that happen 5 years later? Well, that's because Torrigan Williams last year got arrested for trafficking in meth. That's the first time he decided to come forward and go, hey, wait a second, I'm in trouble. Prosecutors, I think I have information that you might want. And by this time, members of the jury, 4 years have passed, and this case was plastered all over the internet for anyone to look up and see what they needed to find out about what they needed to say. After he decided to give a statement against Hakeem Robinson, what do? They drop his state case. Dismissed, no action. Then the federal government decided to pick up his case. And Mr. Williams, as they call him to testify, is going to tell you, well, I'm hoping that the feds are going to be a little lenient on me because I am helping in this homicide case. Not one of their witnesses, members of the jury, that take the stand, that tried to point the finger at Hakeem Robinson, not one of them are unbiased. Each one of them that are going to walk in here have some angle. They either are trying to help themselves, to get themselves out of their trouble with the government, or something for a loved one. Each one of them that points the finger in some way, shape, or form to Hakeem Robinson is hoping to get something, and not something small, freedom. But members of the jury, what Mr. DeCoste and I are going to ask you to do is to listen to the reliable, credible witnesses in this case. Because what you will see that all the reliable witnesses say was that actually the shooter, they actually saw them with his own eyes, as I told you before. Slim, slender, 5'8" to 5'11". Some of them say 5'5" to 5'8". Notice that not once, when Mr. Cooper was giving his opening statement, did he give you a description. I'm having to tell you that. And I'm talking about not just civilians, I'm talking about trained police officers. We'll talk about Officer Collins, the one who took chase. You notice when Mr. Cooper was talking to you? Oh, well, you know, he was far away. He was jumping the fence and didn't get a good look. He's getting you guys ready to make excuses for why the description does not match Hakeem Robinson, and not even close. Officer Collins is a trained police officer, been doing this for 20 years, knows how to give information like that so that other people, other officers who are listening, he knows to give reliable information. He may come up in here now, 5 years later, and try to backpedal, members of the jury. Not sure, I don't remember. But you remember what he said at the time. That's the most reliable. Before everyone realized that the descriptions, wait, they don't match. And it's not just him. It's not just Officer Collins. You're going to hear from Officer Graham, another one who saw the shooter in this case. You know what his description was? 21-year veteran with the Jacksonville Sheriff's Office, 5'8" to 5'10". Now, those are just the officers. Next, we're going to talk about the civilian witnesses. You're going to hear from Victor Krueger. Mr. Cooper mentioned him. He's the guy with the dash cam in his vehicle, the person that was probably the closest to the shooting, who, and he's right, by happenstance, just happened to have this video recording on his dash cam when this happened. But what did you not hear in the state's opening statement? Mr. Krueger gave a description. You want to know what that description was? 5'10" to 5'11", and he was thin. Clearly not Hakeem Robinson. Not the only one. Javaris Roberts, who worked in the Hibet Sports in that strip mall, described the shooter as 5'8" to 5'9", on the skinnier side. Then we've got Aber Ahmad, a woman who was in her garage having coffee in the morning, sees someone matching the shooter's description, jump a fence and walk right in front of her. She describes him as shorter than 6 feet. But the most important one, Renada Boston. If you recall when Mr. Cooper was talking, he mentioned that the shooter ran through some woods and came out on the other side, and that magically Natalie Gant was there to pick up the shooter because she knew where he was. He didn't mention what Renata Boston described the shooter to look at, because she saw him come out of the woods. Slim build, 5'8" to 5'9", between 160 to 170 pounds. That is not even close to Hakeem Robinson. Multiple independent civilian witnesses, multiple police officers, all describing someone that could not possibly be Hakeem Robinson. And all their testimony, all of them, the ones whose testimony isn't bought with a promise of freedom, they're all consistent. It's clearly not him. The only eyewitnesses that will say that the shooter is Hakeem are the ones who have cut deals with the government. And they're not going to just present these eyewitnesses to you. As Mr. Cooper said, they're going to present all this other stuff. But take a close look at the details of what they present to you. Because not one piece of that evidence is going to be direct evidence that Hakeem Robinson is the shooter. Let's start with the cell phone evidence, because it's going to be a lot. All the records that they're going to produce to you, all the cell phone records that definitively show 100% Dominique Barna using his phone, Leroy Whitaker using his phone, Abdul Robinson Jr. using his phone, Abdul Robinson Sr. using his phone. All of them are communicating with each other. You know whose phone isn't being used? Or they don't have a record of being used at all? Hakeem Robinson. Mr. Cooper just got up here and told you that he's going to try to put a phone in the possession of Hakeem Robinson, a phone number that begins with 478. You know whose phone that's registered to? Abdul Robinson Sr., aka Blue's former dead best friend. That phone is registered to his father, not to him. And you're going to see that that phone the day before was pinging in the same place that his father was. They're going to try to make you think and connect that phone to Hakeem Robinson, and they will be unable to do so. Next up, fingerprints and DNA. They're going to try to present you with DNA and fingerprint evidence trying to put Hakeem in that car on that day. But members of the jury, their own expert will tell you, their experts are going to tell you, we have no idea when that DNA was left there, or how. We have no idea how that fingerprint, when or where it got there. All that proves to you, members of the jury, is Hakeem Robinson knows Leroy Whitaker. They're cousins. They hang out together. That's a fact that we're not disputing. And what did Mr. Cooper fail to tell you? That DNA was found on a t-shirt that was in the car. It's not just Hakeem Robinson's DNA. The expert is going to tell you that it's mixed up with 3 other people that I don't know who it is that's on that shirt. Then they're going to tell you that, well, I'm going to tell you that the evidence will show that a man's DNA was found in that car. That's going to say, I don't know how my DNA got in there, but it's there. Someone that is completely disassociated with this case. All that's going to prove, members of the jury, is that Hakeem Robinson, Leroy Whitaker, Torgon Williams, they're all friends and that they know each other. He told you that car was had been reported stolen for 2 months. They had been all in and out of that car. That DNA and that fingerprint does not place him in the car on the day of the murder. You're going to hear about all of the DNA that they have been unable to identify or match with someone else. But members of the jury, what I do want you to know is, even though Hakeem hung out with all these guys and he grew up with them and stuff, Hakeem was different. because he was making it. Charles McCormick, they said he put out that song. He didn't put out a song. I mean, no one knew about that song. I mean, he tried to release it. He wasn't on the level of Hakeem Robinson, AKA, you're going to hear this name a lot throughout the course of the trial, Queso. And what you're going to hear, members of the jury, which is going to be very important. 4 days before the murder of Charles McCormick, Hakeem Robinson was signed to a record label that gave him a $40,000 advance. 4 days before. He was making it, he was leaving, he was doing his music. All of these people, though, they wanted to be around him. They wanted to share in his fame. But Hakeem cannot be put in this just because he hung around with the wrong people and was friends with them. He is not responsible for what they did in their free time. And even the government, I thought the government would agree that you cannot convict someone by association. And that is true, members of the jury. Guilty by association has no place in this courtroom. Mr. Cooper also mentioned something about a social media post. But members of the jury, when you view these pieces of evidence, please take them into context. He said it happened right after he made this post, 7 days after he made this post, okay? And it's all assumption and speculation with the phrase that he used. He is trying to say that that is somehow a confession. That post didn't say, hey, I killed Charles McCormick. He's going to ask you to imply that when he mentioned that had something to do with the murder that happened before that he had nothing to do with. But members of the jury, what we are going to ask, and this is what I'm just going to ask, we are at the beginning of this case. You haven't heard any of the evidence or seen any of the evidence yet. All I ask of you, each of you, is to please just pay close attention and really listen. Because when you strip away all the evidence that isn't either bought with money or the promise of freedom, the truth is going to be staring you right in your face. Focus on the credible, reliable, unbiased testimony from the witnesses, coupled with what you can see right in front of them. More importantly, your common sense. Because that is what you will need to see the truth in this case, because it is not him, members of the jury. Mr. Cooper talked about the fact that this case is going to be a puzzle and that you'll be able to see a picture at the end. But I'm going to tell you this, members of the jury. If one piece of that puzzle doesn't fit, it is not guilty. Do not shave the pieces of those puzzles to try to force it to fit. Because when you look, you are going to see the description does not match Hakeem Robinson, not even close. Now, members of the jury, there is a reason why the framers of the Constitution, this country's Constitution, ensured that the government would not have too much control over the freedom of the citizens they are meant to protect. And that was by giving the final word, not to the court, not to the state, but to you. People are innately flawed in that they sometimes can't see the truth when it's staring them right in front of their face, or they can't admit it when they've made a mistake. You are 12 members of this community, 15 members of this community, who have promised to look at this case through fresh eyes. That is all we beg of you, to objectively look at the evidence that is presented to you in this case. Because when you listen to all the credible, reliable evidence in this case, it's only going to prove to you one thing. Hakeem Robinson is innocent. Find him not guilty. Thank you.
All right, thank you, Ms. Kawas. All right, I'm going to allow the court reporter to reposition. We will then bring in jury from Mr. Whitaker, and we are going to hear from the state's first witness today, and then we'll be recessing for the day. So just so you know the schedule, that's what we will be doing. All right, Mr. Krueger, so if you'll come forward and be sworn.
Raise your right hand.
All right, sir, and the witness seat is going to be right there. Please be sure to speak loudly and clearly into the microphone and state. You may proceed.
Thank you. Would you please state and spell your name for the record?
Victor R. Krueger Jr., Victor Krueger.
Can you pull that microphone up to your mouth, Mr. Krueger? Thank you, sir.
Victor R. Krueger Jr., Victor Krueger.
And Mr. Krueger, do you currently live in Jacksonville?
I do.
What area of town?
Arlington,
And how long have you lived here in Jacksonville?
since '94.
Are you currently retired?
I am.
And when did you retire?
2017.
What type of work did you do before you retired?
Computers. I worked for CSX and was a computer architect.
Are you familiar with the shopping center located at 7001 Merrill Road?
I am.
And that's here in Duval County?
Yes.
And did you go to that shopping plaza on January 15th of 2020?
I did.
And what was the reason that you went to that location?
I have a UPS box for handling mail. So the UPS store there, I'd gone to pick up mail.
And what type of vehicle were you in when you went to the shopping plaza?
2007 Dodge Ram Mega Cab, 1500,
Does it have a lift on it?
4 inches.
So that makes it sit up 4 inches higher than a regular?
Correct. It came from the factory that way.
Okay. Was anyone else with you when you went to the UPS store?
No.
And do you recall where you parked?
Behind the UPS store and directly facing the employment office, which was at the end of the storefronts in the back.
And by employment office, do you mean express employment?
Yes.
What did you do after you got there?
Got out of the truck, went into the UPS store, got mail, and then came back out, had gotten in the truck, and had opened a couple pieces of mail, bills, just to see what they were, then turned on the car.
And what happened after you did that?
Right about the time I started the truck, I heard the first shot. I wasn't quite sure what it was. I had music going on the stereo. But I looked around and saw a young gentleman running, and maybe a second or two right behind him, another gentleman chasing him with a rifle, firing at him, and eventually hit him, or he tripped, and ended up shooting him multiple times while he lay on the ground.
The person that was being chased, did you see where he came from?
He had come out of the employment office.
Now, when this shooting took place, was there anything that obstructed your view?
No.
How close would you estimate you were to the person being chased and the person chasing him?
I'd say they're about 20 feet off to my left.
Did they run across where you were parked?
Yeah, so it's kind of a little to the right of the employment office, but right on the edge of it. So out of the corner of my eye, he came running past, and I saw, then turned and saw the other one. So that distance between the chaser and chasee was about 15-20 feet, and then he was being chased down the promenade.
Do you recall approximately how many gunshots you heard?
My estimate would be 12, but between 10 and 15.
Did all of this happen fairly quickly?
Yes.
After the shooting stopped, the person that chased the other person and shot them, what did they do?
They came running back. The car that I didn't see them exit the car, but they came back to a Nissan that had come racing up to my left, almost hit my truck because I was pulling out, and he jumped in that Nissan.
And what did you do at that point?
At that point, I had pulled up farther, was actually perpendicular to the other side of the employment office, and I was kind of rolling forward, just kind of watching on my back window. They took off down the Publix shopping lane, and I chased after them.
Prior to chasing after them, when you were in that area where you just pulled up and you saw the Nissan coming up, did you see anyone else outside in that immediate area?
Not in the immediate area, no.
Would you consider yourself to have been the closest person outside in that immediate area?
Yes.
And what was the purpose of you trying to follow after that Nissan Altima?
Ultimately hoping to catch the license plate of the Nissan. More than that, I don't know whether I thought through what I was doing.
Prior to the Nissan taking off, did you see what side of the car the shooter got back into?
Passenger side, front.
Were you able to see clearly into the Nissan?
No, it was very heavily tinted with windows.
Do you recall what the shooter was wearing?
Sort of like a tracksuit, hoodie, just very baggy. And it just really covered up, so there wasn't really much I could see of the shooter.
Were you ever able to see the shooter's face?
No.
Could you tell anything about the shooter? Could you tell what color the person was?
As I was driving past the employment office and kind of watching the shooter come back, had a mask on, but I could see around the eyes. Definitely was a black individual.
Could you make any determination as to whether it was a male or a female?
It was baggy enough, I would say just by the movement. I would say it was probably a male, but I really couldn't tell any physical features. Like I said, the jumpsuit was very baggy.
What type of firearm did you see?
It was a rifle with an extended magazine.
Did you have a dash cam in your vehicle?
I did.
Where was that equipped?
I was on the front windshield, up high on the windshield to the right of the rear view mirror.
Did you have to turn that dash cam on in order for it to record?
No. I do have to, it's not wired into the battery, but I do, whenever I leave the house, I plug it into a cigarette lighter, so until I unplug it, it stays running.
So even when you got to the shopping plaza, parked, and went to UPS, was that dash cam still recording?
Yes.
And approximately how far did you follow the Nissan after it took off?
Well, as I was going down the Publix, had a police officer pull up beside me, wave him in front of me, and I followed them to the exit of the Publix shopping center. They exited onto Merrill. At that point, I couldn't exit safely because of oncoming traffic, so I waited. Eventually got onto Merrill and went downtown where they had gone, but I never caught up to them at that point, turned around and went back to wait for police and paramedics and all.
And when the police showed up, did you tell them that you had a dash cam in your vehicle?
I did.
And did you allow officers to view that video and download it?
They downloaded it, yes.
Now, on your dash cam, does it include the date and time of the video?
No, because of the fact that I'm always unplugging it and it's losing power. It'll just read whatever the default date is.
Okay, so not necessarily the accurate date and time, but it still records. Okay. Your Honor, may I approach the witness?
Yes.
Is it
Showing you what's going to mark your identification as State's Exhibit 8E. Can you take a moment and see if you recognize that disc, sir?
That's the one that you had me sign.
And is this a recording of that dash cam video?
It is.
Fair and accurate as to what was recorded on January 15, 2020?
Yes, sir.
Your Honor, this time I would ask to move what's been marked as State's Exhibit 8E into evidence in both cases.
All right, is there any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
Okay, then without objection, State's Exhibit 8E will be moved into evidence. The State's Exhibit, do you want the numbers as listed on your exhibit list?
Yes, Judge.
Okay, number 187.
And Your Honor, may I publish that?
Yes, you may. And while you're setting that up, let me just tell the jurors that any and all items of evidence that are moved into the trials of each of the respective defendants are going to be sent back with you into the jury rooms for your use during deliberations if you wish to see or observe these things again. So this isn't the only time that you will be seeing the state's evidence, or any evidence for that matter.
that comment, that's the car right there. Was that you speaking?
Yes.
And so was that the vehicle that the officer got behind?
It was.
Okay. And do you recall where that vehicle was parked if you saw it prior to the shooting?
I didn't see it prior to the shooting, but it would have been off to my left 3 or 4 spaces. Didn't really notice it until I was pulling out and they came roaring up to the curb where they would have picked up the gentleman that had shot the other gentleman.
And based on being present at the time, do you have any estimate as to what the height of the shooter would have been just based on your position?
I'd say 5'10", 5'11", less than 6.
But pretty close to, based on 5'10" to 5'11"?
Yeah.
Okay. Judge, that's all the questions I have.
Okay, cross-exam for Mr. Whitaker.
Good evening, sir. How are you doing?
I'm doing well. Yourself?
Good. You mentioned that this is a strip mall you go to fairly regularly?
Yes.
Okay. And in this strip mall, there's a Publix, correct?
Correct.
And a Bailey's, I think it's now Choose Gymnasium,
Yes.
and even like a medical office, like a Baptist outpatient.
Yeah, that was, in front of that is where the young gentleman was actually killed.
Okay. And obviously, we could see from your dash cam video, there's a lot of cars, there's a lot of people out there, correct?
Yeah.
Okay. You mentioned you were not able to see into the inside of this silver car, correct?
That's correct.
And as you, I know you may have watched it now multiple times, but as you were watching it that day on January 15th, could you tell it was a Nissan Altima?
Yes.
Okay. But you were not able to see how many people were in that car,
No.
one way or the other, correct?
It would have to be 2 at least.
Okay.
The driver and the gentleman who got in the passenger side.
Because logic would dictate the shooter that we see in your video isn't driving that car, right?
Correct.
And your testimony is that you watch that silver car go closer to the shooter to pick the shooter up, right?
Yes.
And that's where you get the very logical assumption there had to be at least 2 people in that car, correct?
Yes, ma'am.
But other than that, you have no information.
No.
Okay. And you certainly only saw one lone gunman, correct?
Correct.
One shooter, correct?
Correct.
And you didn't hear any kind of words before the first shot, correct?
No, ma'am.
You didn't hear any kind of words throughout the entire dash cam video, correct?
Correct.
Besides your own proclamation trying to make sure that the officer saw, hey, that's the car that was involved, right?
Yes.
Okay. I don't have anything further. Thank you, sir.
Okay, thank you. Cross for Mr. Robinson.
Please, Your Honor. Good evening, Mr. Krueger.
Hello?
You consider yourself precise, correct?
As precise as I can be, yes.
You own an esports team.
I do.
You were a computer architect for a number of years.
I was.
You're precise in your work
I hope so.
and in your words, right?
Yes.
No. The distance between you and this shooter is about the same distance between me at this podium and you in that seat, correct?
About, yeah.
Give or take a few feet.
Yes, sir.
You were wearing your glasses that day,
Yes, sir.
and you got a look at the shooter. You saw the shooter.
I saw the shooter in
Correct.
the sense that I saw the individual in a tracksuit, but I did not see identifying anything that I could identify him with.
Now, you're a big guy yourself, right?
Yes, sir.
6'4", 230?
Yes, sir.
Your Honor, if the witness may please stand and if I could approach.
Okay. All right. Let me see, court reporter and counsel at sidebar. You can have a seat, Mr. Krueger, while we do this.
So this is going to be the end of this
Right
case,
this
and we are
side.
going to jump over
Yes,
to
y'all can come
today's
up. It's
speech,
only,
and we are
I can't find the white noise on here.
up to speed.
To see if you could identify a particular individual.
And is that it from the state?
Judge, it is for the first two witnesses. I think defense counsel was discussing the last, Officer Collins, and we can address that before he testifies.
Okay, he's not the next witness right now? Okay, then let's wait and address that before he testifies. Anything on behalf of Mr. Whitaker? Anything else on behalf of Mr. Robinson? Okay.
Checking in with Officer Graham to see if there's any update with that. That is the sole witness that we have not been able to track down.
Okay. Any update on any efforts to track Officer Graham down?
I have not. When we go back, I can check to see if anyone else has gotten a message at the office. I know we've been calling, we've been leaving messages, reaching out. I know defense counsel sent an email, I'm sure, as well. So I'll check when we go back to the office.
Okay. All right, thank you.
Your Honor, then the question of, and again, I just am bringing it up now to avoid the situation later, Miss Ahmad, who's in Jordan. The hope would be to have her testify via Zoom.
Right?
I don't know, the last that we spoke, the state had a little bit more information than I did, because the husband wouldn't even tell us where she was. I don't know if he'd be more inclined to communicate with them or with the defense. We have spoken to him, myself and Ms. Kawas have, but we haven't gotten a confirmation. She has effectively been served through him, but she is out of the country. I think it can be worked out. I just wanted to share with the court where it's at.
Okay, thank you. All right, then if there's nothing else and if all sides are ready, let me just remind those in the gallery observing to please be sure your electronic devices are turned off, please, so that we have no interruptions in the middle of the proceedings. Then with that, we'll go ahead and bring Mr. Whitaker's jury out and Mr. Robinson's jury out.
I'm not sure, but I just wanted to put on the record because I did see a few news clips yesterday evening, throughout the evening, and some of them had some very damaging information on them. For example, gang-related shooting, and one that explicitly said that Hakeem Robinson has another murder case. So I don't know if the court just can say, just if anyone has to be sure they have.
My plan is to ask each and every day when they return whether they have talked to anybody, anyone's approached them, and what, if any, news media they may have seen or heard. So I will be doing that every day, not to worry.
Thank you, Judge.
Just for a second. No, I'm not ready to do that. Just for the defense.
No hands raised. Has anyone attempted to talk to you about this case, either as you left court yesterday, arrived at court this morning, or any time in between? If so, please raise your hand. All right, and I see no hands raised either. And have you all talked to anyone about the facts and details of this case that you have heard or seen yesterday? If so, please raise your hand. All right, and I see everyone nodding in the negative. All right, thank you, ladies and gentlemen. We'll await for Mr. Whitaker's jury to come in, and then we will get started with the state's case in chief. Thank you so much.
Your Honor, jury nine.
Please raise your hand. All right, and for the record, I see no hands raised. Whether leaving yesterday or arriving today or any time in between, has anyone attempted to speak to you about this case, approached you to talk about any information about this case? If so, please raise your hand. All right, and for the record, I see no hands raised. And have any of you had conversations with other people, friends, family, or otherwise, about anything about this case? If so, please raise your hand. All right, and I see no hands raised. All right, and for juror 40, or who used to be 40, I see we've provided you with your assisted listening device. Are you able to hear me, sir? Okay, thank you so much. All right, then if nothing else, we may continue with trial and state. You may call your next witness.
Call Tasha Saunders.
Ms. Saunders, please.
Would you please state and spell your name for the record?
My name is Tasha Saunders. That's capital T-A-C-H-I-T-A. Last name is Saunders, S-A-U-N-D-E-R-S.
Ms. Saunders, do you live in Jacksonville?
I do.
And approximately how long have you lived in Jacksonville?
I've been here 20 years.
And do you have any children?
I do.
How many?
3.
And are they all currently in college?
They are
And what do you do for a living today?
medical sales.
And how long have you been in sales?
25 years.
Now, at some point, did you stop working in that field?
I did.
And approximately when was that?
2017.
And what did you do in 2017?
I invested in a franchise, a staffing agency.
And what was the name of that staffing agency?
Express Employment.
And where was your location of Express Employment located?
Merrill Road, 7001 Merrill Road.
And that's here in Duval County, Florida?
Yes.
Now, what type of business was Express Employment?
It's an employment agency, a staffing agency.
So did you essentially assist companies with finding employees?
Yes.
I'm showing you what's in evidence of State's Exhibit 2. You recognize this photograph, ma'am?
Yes.
And is that your business at the top to the next, I guess, on the right-hand side of that plaza?
Correct.
And were you working at that location the morning of January 15th, 2020?
Yes, I was.
Now, were you by yourself that morning?
No, I had one other employee there.
Okay. And do you recall who that was?
Yes. Melanie Coleman.
And did a person named Charles McCormick come to your business that morning?
Yes.
Did you personally know Charles before he came in that day?
Yes.
And how did you know him?
A family friend.
Now, why was Charles coming to your business that morning?
For an employment opportunity.
Had he already been interviewed for a job?
Yes, he had.
Right. Had he been selected for a job?
Yes, he had.
And so what was the primary reason for coming in again that morning?
He was coming in to get the details of the assignment that he was going to.
Now, when Charles came into your business that morning, did you see him and talk to him?
I did.
And what were you inquiring about?
Just congratulating him and getting him prepared to go for the assignment.
What was his demeanor like that morning?
He was excited and happy just to be selected and an opportunity to kind of get a fresh start on his work.
Do you recall approximately what time he came in to Express Employment on January 15th of 2020?
Not specific, it's on the sign-in sheet.
And that sign-in sheet, did you provide that to the Jacksonville Sheriff's Office?
Yes, they took it.
If you were to see that sign-in sheet, would that refresh your memory as to what time he came in?
It should be noted on there.
May I approach the witness, Judge?
Yes.
Showing you what's in evidence of State's Exhibit 198. Can you take a moment and look at that, see if that refreshes your memory?
Yes, this is our sign-in sheet.
And what time did Charles McCormick come in your business on January 15th, 2020?
Approximately 10:08, he signed in.
After Charles met with the recruiter in your office, was he given anything?
He was given the details of his assignment.
And what was that? Was that paperwork? Was it?
Yes, it was paper in an envelope so that he would be able to have the details of where he was going and what he was going to do.
And once he got all of that information, was it time for him to leave?
Yes,
Before he left, did you see him again?
I did.
And can you explain kind of where in the business you were located and where you saw and spoke to Charles before he left?
So before he left, I had walked up to the front of the office and walked him to the front door as I stood at my receptionist desk.
Did you stay at that desk before and as he walked out?
I was there, yeah.
Did you have any blinds on your windows or the doors of that business?
Yes, there are blinds on the windows.
Were they open?
They were open.
From where you were standing, could you clearly see outside into the parking lot area?
Yes.
Now, when Charles walked out your front door, where was he going?
He was going to his car.
And as he was walking outside, can you tell us what happened next, what you saw?
As he was leaving out the door, there was an individual approaching, and as he proceeded to walk off of the sidewalk, he recognized someone coming towards him. He looked back and turned and started to take off running.
And in what direction was Charles running?
So from facing outward of my business, he ran to the left on the side of the building, down the sidewalk.
Before getting to the sidewalk, did he come back towards your front door at all?
He had to come that way to run to the side of the building.
And were you still standing up there at your desk?
I was.
Did you see anyone else pursuing him?
I did.
And did you recall what that person was wearing?
They had on dark, covered. They were covered. Their face and their head was covered.
Did they have anything in their hands?
They did. They had a weapon, a gun, a large gun.
When Charles was running back in your direction, did you actually see him?
I did.
Did he appear to see you?
Mm-hmm.
Is that a yes?
Yes.
And why do you say that?
Because he looked back towards the office. He knew that was only one entrance into my building.
And is that when he then kind of ran around the side?
Ran around the side of the building.
Could you tell the person that was chasing him, even though they were covered, could you tell what color that person was?
Yes, you can tell they were a dark-skinned person. Brown-skinned person.
Brown-skinned person. Okay. Could you tell whether or not that person was male or female?
It appears they are male. Mm-hmm.
And could you tell anything about their hair, for example?
It was covered. It wasn't a low cut or anything. You can tell it was covered, but it was hair.
Did you get a clear view of the person's face?
No, it was covered.
Was the person with the gun chasing Charles, was that person, would you consider them short or tall?
To me, they were tall.
How tall are you?
I'm about 5'5".
Was the person with the gun a lot taller than you?
To me, yeah.
What about compared to Charles as they both ran by you?
I can't give an exact number how much taller they were, but it seems taller.
Yeah, and I'm not asking for a number in terms of height, but could you tell if the shooter was taller or shorter than Charles?
He seemed taller than Charles. Mm-hmm.
Did you see exactly where Charles made it when he was running?
He made it right to the corner of my office, and within a panel or so on the side of my office is where he laid.
Did you see or hear any gunshots?
Yes.
Do you recall if you heard one shot or more than one shot?
Multiple shots.
What happened when you started hearing the gunshots?
I dropped down, told the people sitting in my lobby to get down, and I snatched the phone off of the receptionist's desk.
Now, call 911?
I did.
You recall, did this all happen very, very quickly?
Yes.
I'm going to publish what is already in evidence as State's Exhibit 185, which is your 911 call.
We need help. They're shooting 7001 Merrill Road. He's running across the parking lot with a shotgun.
Okay, ma'am. Okay, who's shooting, ma'am? Give me a
I don't know,
description.
the gentleman, he has a black mask on. He has on a skull cap. He's running across the parking lot, 7001. I'm at Express Employment.
Okay, ma'am, slow down, slow down. Okay, he has on a black mask. What color shirt and pants?
God, ma'am, he has on a... No, hey.
Ma'am,
please.
ma'am.
He has on a black mask,
Uh-huh.
a skull cap, running, tall, thin, black male.
Okay.
Oh, Jesus.
And did he shoot anybody?
Girl, where's Charles? Was it Charles? They shot through my door, my window. They shot Charles McCormick.
Okay, ma'am, somebody's been shot, ma'am?
Did they shoot him? Do y'all see him? Yes, he's down on the ground. His name is Charles McCormick. I know who he is, ma'am. Please
Okay, ma'am, so listen to me. I got everybody coming to you, ma'am. I need some questions. I need you to help me, ma'am, okay?
Oh, my
Listen to me.
Oh, shoot.
Ma'am, listen to me, okay? Listen to me. Where has he been shot at? We need all this information, ma'am.
He's in the parking lot, ma'am.
The guy that's been shot, is he in the parking lot?
Parking lot.
Is he black, white, Hispanic?
Black young male. His name is Charles McCormick. McCormick.
And you don't know where he's been shot at?
No, I don't know. I'm in the building. He was running. He just left out of my business for a job. And as soon as he came out, somebody started shooting at him, and he ran, and he's in the parking lot.
And you said, what was his name again?
His name is Charles McCormick. Guys, where is he at? Do y'all see him? Ma'am, go to my office and look out the window, please. He's over here. He's on the sidewalk?
And what's your last name? Ma'am, listen to me. We got everybody. Ma'am, listen to me, okay? We got everybody coming to you, lights and sirens, ma'am. I need you to be my eyes for me, okay?
Listen, he's on the ground, on the sidewalk, and he's not moving. My building.
Okay, ma'am, I got fire and rescue coming for him. He's laying on the ground, correct?
Yes. Oh, my God. Oh, my God.
Okay, so the guy that was doing the shooting, where is he at? He left?
I don't know where he is. He's ran. Yes, I got my phone. I'm calling her now.
And which direction did you see him leave running in?
Yes, I saw him running.
Which way?
They ran towards the Bailey's gym. They ran west of me. Tell them. Mel, look out there. Look at him. Take a picture. Just use your phone. Take a picture, Mel. Take a picture. Use your phone. Take a picture. Take a picture. Just take a picture.
Okay. And you said the guy came in to get a job?
Yeah. Charles McCormick. I'm a staffing agent.
Okay.
He came in for his interview.
Okay.
Got a job. He was walking out for his job assignment. As soon as he walked out the door, this guy started shooting at him in the parking lot with a mask on. He started running. He ran on the side of my building, on the sidewalk, and the guy shot him. It's like a shotgun. He's down on the sidewalk. He's not moving. What else do you need to know right now? I have bullet holes all in my window right now.
Okay, ma'am. We got everybody coming to you, okay?
Okay. Okay, ma'am. Nobody. I got it.
Okay. All right. We got somebody that's out there with the victim. Okay, and what's your last name, ma'am?
Saunders. Saunders.
Miss Saunders, give me your phone number.
904-800-2933.
All right.
Mel,
We got everybody in right out there.
Of him out on the sidewalk. Take a picture through the glass.
All right.
Saunders. On that 911 call, could you hear any gunshots?
I didn't hear anymore.
Or did you make that call after the shooting stopped?
Yes.
After you got off the 911 call, did you go outside?
I did.
Did you approach where Charles was?
I did.
About how close would you say you got to him?
All the way to him.
And what did you see?
His leg was separated and half his face was gone. His teeth were on the sidewalk.
Did anyone else come outside to try and check on him?
Yes, there's a medical office next door to me, and one of the staffers were out there as well as he tried to cover his face.
You need a minute?
Excuse me?
You need a minute? Now, Ms. Saunders, I do want to show you what's in evidence of State's Exhibit 187. It's a clip from a dash cam, and you have seen that, is that correct?
Yes.
Ms. Saunders, when Charles was standing at the front door, well, was that Charles McCormick? that came
Yes.
out? When he was standing there, were you just inside that door speaking to him?
Yes.
Do you recall what the last thing was you told him?
Do good. Have a good day.
And is that where you remain, just inside that front door?
Yes.
No further questions, Judge.
All right, thank you. Cross on behalf of Mr. Whitaker.
Good morning, ma'am.
Morning.
I'm sorry for your loss. You were close friends with the McCormick family, correct?
I know them very well.
You are good friends with Mr. McCormick's grandmother as well as his aunt?
Yes.
You did not see where the shooter came from, did you?
Just across the parking lot.
But you didn't see him get out of a car or walk up? And you also did not see where he went after he completed the
I
shooting?
did not.
Because by that time, you were crouched down yourself, ma'am, right?
Yes.
Your Honor, I don't have any further questions. Thank you for your.
All right, cross on behalf of Mr. Robinson.
Thank you, Your Honor.
Good morning, Ms. Saunders.
Morning.
How are you doing?
Good, how are you?
Okay. I just have a few questions for you.
Okay.
Okay, so you were inside the store when you first heard the gunshots, right?
Yes.
Okay. And it was out the corner of your eye that you saw the shooter, right? And did you notice him right before the shot started or when the shot started?
It happened so quick.
Within seconds, right?
Yes.
And of course, you didn't know this was going to happen, so you're not knowing to pay attention, right?
Correct.
But you did see the shooter.
I did.
Okay. Now, I know when Mr. Cooper was asking you questions, you described him as tall, right?
Correct.
But you also had a view of basically whether he was fat or skinny, right?
Correct.
And you previously testified that you described him as slim,
And yes.
right? Now, he was also well covered, right? From top to bottom.
Yes.
And you would agree with me that he had a hoodie over the top of his head,
He was covered.
covered. Now, you'd also agree that the hoodie didn't appear to sit directly flat on the person's head, right?
Correct.
It appeared that it wasn't the normal crane of his head, it was something is underneath.
Correct.
You couldn't see it though, so you wouldn't know if it was hair or something else, like a cap or something like that.
Correct.
Okay. And when you realized what was going on, you immediately dropped to the ground.
I did.
And there were other people in your place of business, right?
Yes.
You yelled to them to get down as well too.
Yes.
All right. And then, as we heard, you immediately called 911. How soon was it that law enforcement was able to get there?
I don't know, it seems long, but I'm not sure how long.
All right, but when they realized that you had an interaction with the person who had passed away, who was killed, they interviewed you, right?
They did.
Okay. And you would agree with me that at the time, when they're interviewing you, right when this happened, your memory of what you saw and all of that would be fresher than it is 5 years later.
Absolutely.
Okay. And the police, of course, took a detailed description from you, right, at that time?
So did what I told them, yes.
Okay. Chris? Okay, just a few more questions. All right, now, you said you're 5'5", right?
Yes,
And when Mr. Cooper asked you questions, you described the shooter as being tall.
yes,
Okay, now, 5'5" isn't that tall, right?
correct.
All right. And you would agree with me that tall to you would be anywhere between 5'8" and 6 feet, right?
Correct.
All right. Anything above 6 feet to you would be very tall.
It would be.
Okay, and you described the shooter as being tall.
Correct.
All right. All right. Thank you so much, Ms. Saunders, for answering my questions. Have a good day.
Thank you. Is there any redirect?
No, Judge.
May this witness be excused?
Yes, ma'am.
All right, thank you, Ms. Saunders. You're excused and free to go. All right, State, you may call your next witness.
Judge, we call Barbara Buckley.
All right, Ms. Buckley, please. All right, Ms. Buckley, if you'll come forward and be sworn. All right, ma'am, if you'll have a seat right there in the witness seat, and be sure to speak loudly, clearly, and closely into that microphone. Thank you, ma'am.
May it please the court?
Yes.
Would you please state your name and spell it for the court reporter?
It's Barbara Buckley. Last name is spelled Buckley.
Yes, ma'am. Now, Ms. Buckley, are you married?
Yes,
Okay. And do you have any children?
yes,
How many children do you have?
two. Two natural and several honoraries.
Yes, ma'am. Can you tell the jury how old you were back in January of 2020?
8,
And today I see you're wearing glasses. Were you also wearing glasses back in January of 2020?
I've worn them since 4th grade.
Were you working back in January of 2020?
Yes,
Where were you working at that time?
Dollar General.
And what about your husband? Was he working?
Yes,
Where was he working?
same company.
Different location?
Yes,
What hours was your husband typically working back at that time?
he normally would work 5 in the morning until 3 or 4 in the afternoon.
Did you work different hours?
Yes,
Would you work later in the afternoon and then into the evening?
yes,
And back in January of 2020, where were you living? What was your address?
1033 Townsend Boulevard.
And that's here in Duval County, Florida?
Yes,
And were you scheduled to work that afternoon?
yes,
Do you recall around what time you were planning on being at work?
3 o'clock.
Had your husband gone to work that morning already?
Yes,
After your husband went to work, were you the only person in your home?
me and 3 cats.
Yes, ma'am. Ms. Buckley, I'm going to show you a photograph that's in evidence as State's Exhibit 108. Do you recognize that photograph, ma'am?
Yes,
All right. And what is that a photograph of?
my house.
And then also 109, is that your home as well?
Yes,
How many bedrooms did your house have?
3,
What about bathrooms?
2.5.
Did anyone besides you and your husband live in your home at that time?
No.
Now, prior to getting ready for work that morning on January 15th of 2020, did you speak to anyone?
I was on the phone with a friend of mine.
Was that something you typically did before going to work?
Yes.
Did you have a landline in the house?
No.
So you were using a cell phone?
Yes.
And what kind of cell phone did you have?
An Android.
Now, do you recall the name of the friend that you were talking to?
Kim Leva.
And after you finished talking to your friend, what did you do?
I got off the phone with her because I had drank too much coffee while we were on the phone, and I had to go to the bathroom.
Okay. And where in your house was the bathroom located that you were using?
Right straight down the hallway.
To show you what's in evidence of State's Exhibit 121 and 122. What are we looking at in State's 121, ma'am?
That's the standing in the doorway, and I was seated right by that lamp that's turned on.
Is this the front door of your home?
Yes.
And then State's Exhibit 122, can you tell us what we're looking at in that photograph?
Right, all the way down on the end, that doorway that you see against the back wall, that's the bathroom.
So State's Exhibit 128, the door at the top of this
The
photo.
right of that picture.
And let's go to 130. The door that's cracked to the left, is that for the bathroom?
Yes.
And then State's 131, is that bathroom?
Yes.
Now, when you came out of your bathroom that morning, what happened?
I walked out of the bathroom, and I saw that the front bedroom door was closed, and free cats, they like to chase each other, so I thought one of them had pushed the door shut. So I went to push the door open, and I saw 2 black men standing in my house.
And what did you do when you saw those 2 individuals?
Excuse the language, I told him, I said, "Oh, hell no, get the F out." And then I proceeded to walk down the hallway to the front door, opened the front door for him, and held the sliding door and said, "Get the fuck out of my house." And they were like, "You don't understand, you don't understand." I said, "I understand that you don't belong here, you don't live here, you need to get the F out of my house now." And I kept trying to plead for him to leave the house.
These 2 individuals, did you know either one of them?
No,
Did either of them have permission to be in your home?
no,
Ever been around them at any other point in your life?
no.
Okay. What happened when you made it to the front door?
When I realized they weren't leaving, I was going to try to take off, and one of them grabbed me by the one arm, and so there's an iron railing right by my door, and I grabbed that with my other hand, and I was trying to yell help, which is kind of useless in my neighborhood because all my neighbors work during the day. And the other one came out and was hitting my arm to try to get me to break loose of my grip because I kind of had a death grip on the railing. And then the 2 of them ended up pulling me back inside the door where we fell.
So both individuals put hands on you and helped together pull?
Both pulled me in, yeah. One I called Tattoo Dude had me by my one arm, and then the Squirrely Dude was the one who was, kind of chopping at my hand to get me to break loose.
And so you use 2 descriptions, one tattoo dude and one squirrely dude.
Mm-hmm.
Is that a yes?
I'm sorry?
Is that a yes?
Yes.
And is that how, in your mind, you distinguish between the 2 individuals?
Yes.
And was tattoo dude, do you attribute that description because he had tattoos?
Once I identified him that way because after the whole kerfuffle at the front door, and we went into the living room, he sat down. I don't remember if he pushed his sleeves up or if he took the jacket off that he had on, but I saw his tattoo.
Now, do you recall what the tattoo looked like?
It was a number, and it was Big numbers, 1993 on his arm,
Is that the upper arm, lower arm, forearm?
lower arm, between the elbow and the wrist.
Yes, ma'am. Now, do you recall what either one of these individuals was wearing when they came into your home?
Tattoo dude was definitely dressed better than the other guy. He was wearing a tracksuit it was a dark tracksuit with red tennis shoes. And Squirrely dude had what I classify Dollar General gray sweatpants and just a basic Dollar General type hoodie, dark hoodie on.
Do you remember anything about their hairstyles, if you could see it?
Not for Squirrely dude, because he pulled the hoodie right up over as soon as he saw me. He pulled it up, so I couldn't really get a good look at him at all. But Tattoo dude, when he sat down, he had little nubbies, like he was thinking about growing dreads, but hadn't decided yet. And but they were very neat in appearance, and he had a little goatee. But that was the only thing I really remember.
Could you tell approximately what age they appeared to be?
I'm sorry.
Could you tell approximately what age these two people appeared to be?
I guessed them to be early to mid-20s.
And do you recall anything about their height? How tall do you think they were in comparison?
Seemed to be my height, so they're about 5'5", 5'6".
After you were pulled back inside by Tattoo Dude and Squirrely Dude, you said you fell on the floor?
Mm-hmm, yeah. The Tattoo dude ended up he was on top of me, and he was kind of like holding me like right at the collarbone. And the only thing I could think of was like, this isn't going to end this way type thing. So I just kind of like brought my knee up to push him off.
Okay.
And I think I kind of hit him a little because he seemed to be a little out of breath when he rolled over. And I sat up, and I told him I need a cigarette. And he's like, no, you don't. And he's trying to hold my arm down, and I just kind of lifted him off. But he was saying that he called for the other dude. He's like, bro, come here. And Squirrely Dude came out, and he's like, do you want me to hurt her? And he said, no, just watch her. And so then they were trying to convince me that I didn't understand. And Squirrely Dude pulls out his phone. He's like, I've got it on video. They attacked us. I said, I don't want to see that. I want nothing to do with that. I want you out of my house. And then they were both like trying. You don't understand. I said, the only thing I understand is if what you're saying is true, then you need to call the cops. You need to either way, you need to leave. And at that point, I think I got up and went to have a cigarette.
And what room of the home did you go to?
The living room.
And is that where you remained?
Yes.
And when you were in your living room, did you have a cell phone?
When I went to the bathroom, the cell phone was sitting on the arm of the couch. But when I sat down on the couch, Tattoo Dude came in and sat down. And that's when I saw that he had my cell phone, and he put it back in his pocket again. And then he called for the other dude. He's like, bro, I need some water. So I told him that there was a bottle of water in the fridge, and he went and got one of those for him. And then Tattoo Dude drank the water after he finished drinking it. He crushed it and put the empty in his pocket.
Now, after that happened, while you're still in your living room, did you have an alarm system or anything in your home that you could trigger?
Yes, but unfortunately I could not push it because where Tattoo Dude was sitting, it was right next to the console.
And did Tattoo Dude pretty much stay with you in that room?
Yes.
What about the other person you described as Squirrely Dude?
Squirrely Dude went back into the front bedroom, which I'm assuming that he was looking out the window because he was on this phone the whole time because Tattoo Dude kept asking. He's like, dude, where's he at? Where's he at? Got to get out of here. You know,
Tattoo dude was asking
yeah,
squirrely dude.
yeah.
And also, just to be clear, which one of the two asked
Sorry.
which one of the two was asking the other if they wanted to hurt
Tattoo
you?
dude was asking squirrely dude.
I'm sorry, I backed up for a moment. When you said you were pulled into the house, you kind of brought your knee up and hit tattoo dude, is that right?
Yes.
And was it squirrely dude that asked tattoo dude if they needed to hurt you?
Yes.
That was squirrely dude saying that.
Yes.
Okay. Now, approximately how long were you in your home with these two people?
It seemed a heck of a lot longer than it really was. But, I mean, I don't know the time frame of when they first got there. I know I was watching Blue Bloods on TV. And one show ended and another one started, but I don't know
Would this have been,
the time frame.
sorry, okay. Would that have been late morning when that show was on?
Yeah, it would have been somewhere between, I probably turned it over around, 10:30, something like that, is when I put it on that channel.
Okay, and then that show ended and another one started while they were
Yeah.
in the house? Okay. And that show is typically an hour long?
Yes.
Now, that front bedroom that you said Squirrely Dude kept going back to, what can you see from that front bedroom?
The front, basically the whole street of Townsend.
Did you see that individual that you refer to as Squirrely Dude doing anything with his phone?
I didn't see that much of him at all. I mean, other than, the couple times that Tattoo Dude would call him out.
When he came out, was Squirrely
Yeah,
Dude?
he would come out of the front bedroom.
Okay, and what was he doing at that point?
Well, he was still on the phone.
So could you hear it if he was talking to someone? Not the conversation necessarily, but was he using?
No, he was,
Sorry.
I mean, he was talking very softly, so I didn't know. I did not hear any conversation.
But when he was talking, did he have his phone in his hand?
Yes.
You indicated at one point earlier, kind of faked.
Hmm?
I think you indicated at some point while they were holding you and you're in the living room, you kind of faked, like going to sleep or some sort of
I
attack.
can't hear you.
While you were on the couch in the living room, did you fake going to sleep or doing something to try and
And expedite their leaving? Yes. Because I have asthma, and over the years, I know what an asthma attack feels like. I know what happens to me when I do it. So I started telling Tattoo Dude, I'm like, something's not right. I'm not feeling good. I said, you guys got to go. You got to go. And he's like, oh, you're fine. You're fine. I said, no, I'm really not feeling good. I'm not feeling good. And I started to basically like hyperventilate, and then I kind of like laid down sideways on the couch with my hand hanging down so that, and made it sound like I was having some sort of an attack. And I kind of saw like, kept a sliver of my eye open so I could see when they were actually going to leave type thing, see what was going to happen. And Tattoo Dude got really panicky at that point and called for Squirrely Dude to come out. He's like, and I heard him say, something's not right. We got to get out of here. And then at some point, I don't remember when, but Tattoo Dude went to the hall bathroom and used the restroom, and then went in the master bedroom and changed clothes. And then when he came out, he told Squirrely Dude to go in and change too.
so did both of those individuals take clothing from your home?
Yes.
Do you recall what type of clothing they took from?
Tattoo Dude was wearing sleep pants that had the Mountain Dew theme on them, and that my husband got for Christmas, and his Permante's Brothers t-shirt. And then He had grabbed a pair of old New Balance tennis shoes out of the closet too. And then Squirrely Dude, he just changed into another pair of sleep pants that were, in the bedroom. And he took the hoodie off, so he had a white muscle shirt on.
When he took the hoodie off, were you able to clearly see his face?
No,
And why not?
because I didn't have my glasses on and I was kind of squinting and I can't see distance.
After they took those clothes and changed, assuming without your permission, you didn't have permission to take the clothes?
No,
What did they do?
they were standing by the front door looking out, and then Squirrely Dude's like, he's here, and then they both left, and as soon as they shut the front door, I jumped up, locked it, and I looked out the window briefly enough to see and get in the car, and then the car leave.
Now, could you make out the color or anything about the type of vehicle that they got into?
I could tell that it was a Charger-style car, and that it was a reddish-orange color, the exact color I can, or the exact make, model, no, I can't. It's just a Charger-style type vehicle.
And was that car in your driveway?
Yes, they pulled into the driveway.
Which way did it go?
It backed up and then went down Townsend towards the expressway.
And what did you do after the car left?
I went and hit the alarm button on the self-control panel. I knew he had my phone, so I had to grab a piece of paper that had my friend's phone number on. And then I ran out the door to try to find a neighbor home.
And were you able to find anyone?
A couple doors down, I saw a lady bringing in her Christmas decorations, and I hollered at her, I need help, I need help. And at that point, she was coming towards me, and I still didn't really know what had gone on prior, and all of a sudden, news reporter Elizabeth Pace came over, and she actually helped pick me up. And then when I realized there was an officer, I'm like, I need him. And I pointed to the officer who was down by the car, and they're like, what's going on? I said, 2 guys just broke into my house. They just left. So Miss Pace walked me down to the officer, and he told me that he was going to call it in, but I need to call 911 and then to go back to my house. And
Did you call 911?
Elizabeth did, and so did my neighbor.
And were you able to get on one of their phones to speak to the 911 operator?
The neighbor's phone, yes. Mm-hmm.
And after speaking to 911, did you remain at your home?
Yes, they told me to stay there.
And eventually, did officers or detectives show up to your house to speak
Lots
to you?
of officers showed up.
Okay. Did you tell them what happened?
Yes, I did.
And did you give them a physical description of both individuals?
Yes, I did.
And did that include the tattoos on Tattoo Dude?
Yes.
As well as a clothing description?
Yes.
Now, the clothing that they wore when they entered your home, did they take that clothing with them when they
Yes.
left?
They wrapped it in a blanket that I had laying on my bed.
Now, after giving officers the descriptions, later on January 15th, 2020, same day, were you shown a photo spread to see if you could identify a particular individual?
Later that evening,
And when you were shown that photo spread, there were multiple photos?
mm-hmm.
Is that a yes?
Yes,
All right. And were you able to identify anyone?
yes,
All right. And did you identify that person by actually signing the photograph?
yes, I did.
Your Honor, may I briefly approach the witness?
Yes.
Showing you what's in evidence that State's Exhibit 201. Do you recognize this as that photo spread that was shown on January 15th, 2020 to you?
Yes,
And this photograph, is that your signature?
yes,
And which Which of the two individuals did you identify?
Tattoo dude.
Showing you what's in evidence at State's Exhibit 125, do you recognize that photograph?
That's the front bedroom.
Is that the front bedroom that the tattoo dude and squirrely dude were inside?
Yes.
And State's 126, is that same room?
Yeah, that's standing in the room.
State's 110, is that the front door of your home?
Yes, it is.
And where is the metal railing that you had to grab onto?
It's alongside that black line that's alongside next to the planter.
You can actually, if you touch the screen with your finger, you'll be able to put a circle around it.
It's right there.
And State's Exhibit 121, is that the front room where you went and had to have a seat for the entire time they were in there?
Yes.
Where in State's 123 were you seated? And I want to show you what's in evidence as State's 191. You see this on your screen, ma'am?
Yes.
That vehicle that just drove by, do you recognize that vehicle?
Yes.
All right. And how do you recognize that vehicle?
That's the one that pulled up in my driveway.
And this is State's Exhibit 186, your 911 call.
911 on a recorded line. Two people that held you in your house, you know, were they black, white, or Hispanic?
They were black males.
Do you know what color shirt either of them had on?
When they initially came in, they were, they changed clothes. They got my husband's clothes.
You know what, the last time you saw them, what color shirt either of them had on?
What one of them is wearing, the one that's got a mustache is wearing plaid sleep pants with a gray Kamani Brothers t-shirt. The other one's wearing a white muscle shirt and black Mountain Dew sleep shorts with gray tennis shoes. They're carrying their other clothes.
You said, what color were the pants with the white tank top?
It's Mountain Dew theme. It's their black background with Mountain Dew all over them.
Which direction were they headed the last time you saw them? Do you know?
They jumped into a red. I thought it was a Charger, but the officer who's working the traffic into up the street says it's got two doors. He says probably a Challenger, but they jumped into a red one of those, or reddish color, and then headed down towards Arlington, downtown and towards Arlington Expressway.
Did either of them have any weapons on them?
Not that I could see. The one definitely did not. The one who kept his he had a black hoodie that he kept trying to keep around his face. I couldn't tell anything that he had.
How long ago did this occur?
They found him in my house at 10:30, and they just left about 10, 15 minutes ago, if that.
So they came. You found them in the house?
I came out of the bathroom. And saw one of the bedroom doors was shut. I went and opened it, and they were standing right there in my house.
Are you injured? Do you need an ambulance? Do you want an ambulance to come and look at you?
I don't need an ambulance. But they do have my cell phone. I'm using a neighbor's phone right now. Thank you, sweetie.
What is your cell phone number?
My cell phone number is 904-982-7559.
All right, ma'am. So are you going to be waiting at 1033 Townsend?
Yes.
Okay. All right, well, we do have the call. We've sent it, and officers are going to be out there to you shortly, okay?
Okay, thank you.
You're welcome.
Ms. Buckley, when the police showed up, Did they also collect the clothing that you were wearing that day?
Yes, they did.
And did they also take a DNA swab from you?
Yes, they did.
And did you have any injuries as a result of being grabbed and kind of thrown down to the ground?
Other than a bruised shoulder.
Your Honor, may I approach for one moment?
I'm sorry?
May I approach the clerk for one moment?
Yes.
Ms. Buckley, I want to show you what's in evidence as State's Exhibit 135. Do you recognize that photograph, ma'am?
Yes.
All right, and is that you?
Yes.
And did you have a slight bruise or injury there to your neck?
I couldn't see it because it's, but they said, yeah, the police officer saw it.
And 137, what are we looking at there?
That would be a scratch mark from when they, I'm assuming when they tried to get me off the death grip.
Okay, you didn't have that before then?
No,
142,
that was where I scraped the sliding door being pulled back in.
and that was when both of them were pulling you in?
Hmm?
Is that when both individuals were pulling you in?
Yes.
143, is that just a close-up of that scrape?
Yep.
States 133, is that the clothing or the pants that you had on that morning?
It's the pants. The shirt matched, but they made me change.
And States 143, same pants? And they were collected?
Yes.
I don't have any further questions, Judge. Thank you.
All right, cross for Mr. Whitaker.
Good morning, Ms. Buckley. Ma'am, you mentioned that you ended up with a bruised shoulder.
Yes.
Do you think tattoo guy? Did you get some bruises on him?
Well, it's when we fell, because when they pulled me in, the two of them pulled me in, and I landed on my shoulder.
Okay. And then you were able to ultimately get tattoo guy off of you, correct?
Yes.
Okay. So these two people end up in your home, and they're in the original room that they're in. Was that close to your front door when you encountered them for the very first time?
It's the closest bedroom to the front door. Yes.
Okay. And so your obvious reaction is, get the F out of my house, and you go so far as to open the door, the front door.
Yep.
Correct. They unfortunately do not leave, correct?
Correct.
There then is some kind of physical altercation where, and I'm going to use your terms, tattoo guy ends up on top of you, correct? And it's at that point that you can't help but notice the very large tattoo on his arm, correct?
He had a tracksuit on, so the jacket, I did not see the tattoo in detail until late when he sat down on the couch after the kerfuffle at the front door, and we came in, that's when I saw him.
Okay. At that point, was he in a short sleeve shirt?
No, he had a jacket.
Taken off his clothes?
He hadn't taken the jacket off or anything.
At some point, did you get a good look at tattoo guy's tattoo?
Yes, I did.
And what was so distinctive about it?
It was the size of it, and also when I saw the year, the only thing I could think of is these guys are, just a couple years younger than my kids.
Do you remember that year right now?
Yes, ma'am.
Is it a number you'll probably never forget?
Pretty much.
1993, ma'am?
Yes, ma'am.
And obviously, that was something you were able to provide description right away,
Yes.
correct?
Yes. He had another tattoo on the other arm, but the way he was sitting, I couldn't read it.
Okay. Now, the other person that you've labeled Squirrely Dude, you didn't get a very good look at him.
No.
correct?
Mm-mm.
At one point, you did get to see his full right arm, though, correct? And got a good look at that?
When he went to change, he had the muscle shirt on. I was, like, from distance we are right now, I see beige and white. I see nothing else.
Sure, because you didn't have your glasses on. Fine. But you were able to see a good look at, and we're talking about Squirrely Guy now, Squirrely Guy's right arm, correct?
No.
Okay. Do you remember giving a deposition? And I realize it's been a number of years.
I do remember deposition, yes.
And that was much closer in time to when this all happened to you.
Mhm.
Counsel, I'm on page 21, starting line 25. Your answer was, and I got a good look of his right arm. I did not see any tattoos on his right arms. And he's got very, I call them chicken arms. You remember
Yeah.
responding to that?
Mm-hmm.
So the Squirrely Guy, you were able to see his right arm pretty closely when you were in very close proximity to him, and you didn't see any tattoos on his arm.
It wasn't close proximity again. It was the distance I am between you and me right now.
Okay.
Okay. And from what I could see, without my glass, I could not see any tattoos that were visible to me.
Okay. But back when you gave your deposition, you did indicate that you had gotten a good look at his arm.
You know, the only thing I could, get a good look of is, I see the shape, I see shapes, I see colors. It's the fact that he had really skinny arms.
Okay. Now, this person, Squirrely Dude, you described that the hoodie was not only on, but it was actually tied, correct?
Yeah, he pulled it, as soon as he saw me, he pulled the hoodie up and pulled it tight.
And Squirrely Dude, you didn't end up having much interaction with, correct?
Right.
Okay. It appeared that Tattoo Guy was kind of calling the shots, right?
I don't know.
Well, according to you, it was Tattoo Guy that kind of tells Squirrely Dude, hey, go change your clothes. Was that not your direct testimony? I'm sorry.
It was, it was Tattoo Dude's idea, yes, but as far as who was calling the shots, I can't make that call. I don't know.
Sure, okay. And you described that you end up in the living room and you are able to have a cigarette?
Yes.
And I guess Squirrely Dude at that point keeps trying to tell you, hey, I need help. Please look at my phone, right?
No, that was when we first landed in the hallway.
Okay, when you're trying to get them to
And
leave.
they tried they were like, lady, you don't understand. I said, I understand. You're in my house. You don't belong here. You need to leave. And they're like, we were ambushed, and Squirrely Dude, holds us down his phone for me to see. I said, he's like, we got it on phone. I said, I don't want to see that. I said, if that's true, you need to call JSO. I said, or leave my house one at a time, head down a couple blocks down to the expressway. But either way, you need to go.
Now, you were wearing your wedding rings when this occurred?
Yes.
Okay. And there were valuables in your home,
Yes.
correct? Fortunately, the intruders did not take those things.
Right.
And ultimately, Tattoo Guy takes your phone, ma'am?
Yes, ma'am.
There was a car at your home as well?
There was a what?
There was a car, your car, at your home?
Yes.
Okay. And they did not obviously steal that? Okay. I don't have anything further, ma'am. Thank you very much for your time.
All right, cross for Mr. Robinson.
Thank you, Your Honor.
Morning, Ms. Buckley.
Hey.
How are you doing?
I'm here.
You're here. Okay, so just a few questions. You're very certain, 100% certain, that there were only 2 people in your home?
Yes, ma'am.
You didn't see a third person?
Not inside my house, no, ma'am.
Okay, and the 2 people you saw, you didn't see anybody that was over 6 feet tall?
What?
You didn't see, the 2 people that were in your home, they weren't over 6 feet tall?
I still can't understand what you're saying.
Okay, I'm going to slow down because I speak with a little bit of an accent. So, the two people that you were in your home, you described one as being, well, you said you're 5'5", correct?
Mm-hmm.
And that they were about close in range to your height?
Yes.
Okay. No one, in your opinion, was over 6 feet tall?
No.
Okay. And you had mentioned that squirrely dude was, you saw him on his phone,
Yes.
and he was actively using his phone?
Yes.
Okay. Did you heard conversation, but you couldn't hear what he was saying?
Right.
Okay. Did you see him with more than one phone?
I just saw one phone, him on the phone, one phone.
Okay. And then neither of these individuals had gloves on?
No.
Okay. And tattoo guy, he basically held you down.
Yes.
He put his hands around your neck.
Yeah, he pretty much landed on me when we fell into the hallway
Okay. And he remained on top of you.
until I kneed him off.
Okay. But he, at some point, put his hands around your neck
Yes.
in an attempt
Yes.
to hold you down.
Yes.
So much so that he left a mark on your neck.
Yes.
He was violent with you.
They both were.
Okay. Now, as it relates to the police showing up to your house, when they get there, well, first we heard your 911 call, right?
Mm-hmm.
And even 911 asked you for a description, right?
Right.
Because it was important so they could identify who the person was, right?
Mm-hmm.
You were even able to give them a very detailed description of the clothes they were wearing when they were leaving. Yes?
Yes.
Okay. And that wasn't it. Police then came to your house, right?
Yes.
And they sat down with you and gave you an opportunity to explain and describe the individuals that were in your home.
Yes.
One of which had, as you stated, a very distinct tattoo on his arm that you remember as you sit here 5 years later.
Yes.
Now, I think you had said within the evening, that same day, so within 24 hours, they were able to come back to your home with a bunch of photographs, right?
Yes.
Now, when they were showing you these photographs, it's true that they give you some instructions before presenting you with the photographs, right?
Yes.
And they say things to you like, the person may or may not be in this set of photographs, right?
Yes.
And it's not just one photograph, it's multiple photographs.
Photographs, yes, ma'am.
Right. And it's not a photograph of a 1993 tattoo, right?
Right.
So, and they show you them individually, right?
Yes.
And this is to make sure that you're picking the right person.
Yes.
And you were able to ID, without a doubt, Tattoo Man.
Yes.
Did you come to learn that his name was Dominic Barner?
I don't know any of the names.
Okay, no problem. All right, thank you so much, ma'am. No further questions, Judge.
Thank you. Is there any redirect?
No, Judge.
May this witness be excused?
Yes.
All right, thank you. Ms. Buckley, you're excused and free to go, ma'am. All right, are you ready to call your next witness?
I'm gonna need to check to see if he's outside.
Okay, do we need a recess?
Judge, that might be best.
Okay.
Go over a few things.
All right, well, we have been going for an hour, so I'm going to give a recess to the jurors so that they may take a bio break. If you will leave your notepads behind on your seats and have a step into your respective jury rooms, we'll bring you out here just as soon as we can. Thank you, ladies and gentlemen.
See who's out there. See
Here.
Judge, it's evidence of the scene, obviously, and then his head, which has the largest injury, has been covered. I believe I have just one moment, Judge. It also depicts damage to the concrete beneath Mr. McCormick when he was rolled over, which is evidence of the bullet strike, which the evidence technician will also talk about. Yes, Judge, and it also goes to premeditation to show that he was shot while he was on the ground and defenseless.
All right. I have now had the opportunity not only to look at States 2A, but all the other photos in this binder. And in looking at these photos and making my analysis of whether this photo is overly prejudicial and outweighs any probative or substantive value, I'm going to overrule the objections. This is the only photo of its kind. There are some others that show close-ups, but this is the only one that shows, and not even the full body, I would say 3/4 of the body. And I don't find it to be overly prejudicial or extremely, gory, if you will. So I'm going to allow the state to use that item in evidence, assuming a predicate is laid.
Judge, I believe they were stipulated to all the other photographs, is that correct?
All of the photographs in 2?
Yes, sir.
Okay.
The issue is in regards to whether or not it fairly and accurately represents the prejudice.
Understood. All right, so to be clear, 2A through what number is being stipulated to?
Should be 1A through 3T.
All right, 1A through 3T on behalf of Mr. Whitaker, with the exception of this photograph that I've just ruled on, is being stipulated into evidence?
Yes, ma'am.
All right, and on behalf of Mr. Robinson?
That is correct.
Okay, then those will be appropriately marked into evidence
Judge,
with the numbered items as they are indicated on this exhibit sheet, which will be numbers 1 through 72. Is that correct?
yes, Judge.
Okay. Anything else we need to take up?
Judge, there were 4 more exhibits that I believe the defense is stipulating to, and that would be number 80 on the list. Is a photograph of the car after it crashed.
Yes, Your Honor.
All right, number 80 is being stipulated to by Defendant Whitaker and by Defendant Robinson.
Yes, Your Honor.
Okay, that will be marked into evidence.
Video 190.
All right, Defendant Whitaker,
No objection, Your Honor.
Defendant Robinson. Any objection to Exhibit 190?
No objection, Judge, on behalf of Providence.
All right, thank you. That'll be marked into evidence.
Lastly, Judge, 199 to 200.
All right, on behalf of Defendant Whitaker, 199 to 200.
No objection, Your Honor.
And on behalf of Mr. Robinson,
No objection, Judge.
all right, thank you. Anything else from the state?
No, Judge.
Anything from Defendant Whitaker?
Your Honor, I apologize that those were numbers 199
200.
to 200. And Your Honor, just for housekeeping's sake, the video or the photograph that we have objected to, formerly titled 2B, will now be introduced as States 28.
2B is 28.
That is correct.
Yes.
All right, before we bring the jury out, it has come to my attention from the bailiff for the jury for Mr. Robinson that juror number 6, having seen some of these photographs, recognizes the area in which the crime occurred. She advised that she worked in the area and that when the incident happened, there were some conversations she had with her coworkers about the incident. To what extent, I don't know. Whether she can set it aside, I don't know. But we can certainly bring her out now and allow the state and attorneys for Mr. Robinson to further inquire. I mean, I will inquire, of course, but if you want me to do that, I will. If you want to strike her and use an alternate, I will. I will defer to Defendant Robinson on this matter, and I will hear from the state on this matter.
Your Honor, question. So
Yes.
We don't know how they're renumbered. What was their number before being juror number 6?
81. This was juror 81 when we were selecting. But now juror number 6 on Mr. Robinson's panel.
How are they numbered in here?
It's the older one in this thing, next to the 2 gentlemen.
All right.
You want me to bring her out and inquire?
In an abundance of caution, yes, Your Honor.
All right, if we could please bring out juror number 6. Just right there.
No, I don't think that's him running.
You'll have a seat right there. Yes, sir, and please speak closely, clearly, and loudly into that microphone. All right, you may proceed.
Thank you. Would you please introduce yourself to the juries?
Officer J.L. Collins, Jr., ID 5686.
And you're currently with the Jacksonville Sheriff's Office?
I am.
How long have you worked for the Jacksonville Sheriff's Office?
A total of 24 years.
What's your current position today?
Training Academy, professional standards.
Okay. How long have you been there?
Almost 2 years.
Prior to this position, what was your position?
I was in Zone 1 on the bike unit, and prior to that, I was in Zone 1 in patrol.
Okay. What area of town was Zone 1?
Springfield, East Side, downtown core area.
Okay. Turning your attention back to January 15th of 2020, were you on duty?
No, sir.
Okay. What were you doing that morning?
I was working in a off-duty capacity at a charter school.
Okay. What school was that?
A Lone Star charter school.
And were you working as a school resource officer?
Yes, sir.
And because of that, were you also in your patrol vehicle?
I was.
Now, that morning on January 15, 2020, did you go up to the Merrill Road Shopping Plaza?
I did.
Okay. And that's in Duval County, Florida?
Yes, sir.
Right. And were you up there around 11 a.m.?
I was.
Okay. And what were you doing there?
Getting lunch.
Okay. Now, where did you go to get lunch?
Publix.
When you came out of Publix, did something happen that grabbed your attention?
Yes, sir.
And what was that?
I was walking to my vehicle, and I can remember hearing what sounded like a vehicle backfiring from a distance. And as I continued to walk to my vehicle, I've heard a series of rapid fire. Based upon my training and knowledge, this was a rifle because of the rapid fire of the weapon. And I'll never forget it. I said subconsciously, I know they are not doing this in the middle of the day. I turned and looked to my right, which was a great distance away, and I saw a subject running to a vehicle with a black and gray sweatshirt type hoodie on and a black Draco style pistol rifle in his hand, running to a vehicle.
Where was that vehicle parked?
I was parked, so if you don't know the parking lot, there's a Wells Fargo, there's a gas station, then there's a storefront area where there's a Dunkin' Donuts, as well as a staffing agency. And it was in that corner area where that Dunkin' Donuts and that staffing agency was.
Is that staffing agency, was it called Express Employment?
Yes, sir.
And what type of vehicle was it that you saw?
It was a Nissan.
Okay. Do you remember the color?
Silver.
Okay. What part of the vehicle did that person with the rifle get into?
Passenger side of the vehicle.
And at that point in time, did you know if anybody had actually been struck?
No, sir. I didn't see the crime, but I heard the rounds. I knew that something bad had happened. Either a building was shot into a vehicle or a person.
And what did you do?
Ran to my vehicle.
And did you go after the Nissan?
Absolutely.
All right. Where did you catch up to the Nissan at?
So when I got to my vehicle, that vehicle, as soon as the subject got into the passenger side, I can't even determine the speed it was going. It was racing through the parking lot violently. There was a red truck that I had to block or cut off to get behind the vehicle, and I picked the vehicle up on Merrill Road exiting the Publix parking lot.
Did you later learn the person in that truck had a dash cam?
I did.
And I want to show you a clip from that dash cam, which is in evidence of State's Exhibit 187.
That's the car right there, right there.
Was that the same Nissan that you saw the person with the rifle get into?
Absolutely.
Right. And the same car you were chasing down Merrill?
Absolutely.
When the car turned onto Merrill from the shopping plaza, where did it go?
Took a right onto Townsend.
And what kind of area is the Townsend?
It's a residential neighborhood. Have a high school in the area, several churches. Townsend is a main thoroughfare used to travel in that area.
Did you attempt to stop the vehicle using your lights and sirens?
Absolutely.
Did the vehicle stop?
No, sir, it accelerated.
How fast did that Nissan get up to?
I can remember one time looking at my dash, and that vehicle I was going almost 100 miles an hour.
Was the vehicle still pulling away from you?
Yes, sir, it was.
And was there other traffic on the road that morning?
It was 11 o'clock, per lunchtime. So it was a lot of people because there's a school there, there's residential area, like I said, there's businesses in that area. So it was very highly populated. That vehicle was going over 100 miles per hour in the wrong direction of travel.
Did you try to keep pace with the vehicle?
So per our policy, I can't go in that wrong direction of travel. My goal was to stay on the radio, give directions of travel, give conditions that whether or not I was safe, and I was also just trying to keep a visual on the vehicle as it continued to drive erratically away from me.
Were you able to maintain a visual of that vehicle for a while?
I was.
Did eventually you begin to lose sight of the vehicle?
So I got on the radio, obviously, to keep everyone abreast of the direction of travel as well as the conditions. While on the radio, there was another officer that was at Lone Star in Townsend, and he was able to pick up that vehicle at that point as they were pulling away from my sight.
All right, so another officer got behind the vehicle and radioed that to you.
Yes, sir.
Before you lost sight of it.
Yes, sir.
Where did you go when you got to the intersection of Townsend and Lone Star?
So I'm not super familiar with that neighborhood at that time. So I made a left onto Lone Star. So that vehicle turned into a neighborhood. And so my thought was, I'm gonna go to the back of that neighborhood, hoping that the vehicle pops out so that I can continue to pursue the vehicle if he pulls away from this officer like he did me. The officer got on the radio and he said they're turning around on me. So at some point in the neighborhood, the vehicle made a U-turn or either got to a dead end, I'm not sure. But I guess I was pretty much paralleling it. The vehicle turned around on him. I got my vehicle turned around, and I started going back toward Townsend on Lone Star. I was on Lone Star when I started going to the back of what I thought was the neighborhood that he might have came out on if there was an exit to the neighborhood.
So after you turned around and were going back down Lone Star, you were heading back towards Townsend.
Yes.
And when you got to that intersection of Lone Star and Townsend, what did you see?
So when I got back to Townsend, as I get ready to turn on Townsend, I see that vehicle just pop out and it's gunning it. I mean, they didn't stop. They didn't look at any of the traffic. They had no consideration for the neighborhood that they were in. None of that. They took off, and that vehicle just continued to accelerate.
Was that the same vehicle that you saw leave the shopping plaza on Merrill Road?
Absolutely.
Did you turn onto Townsend?
I did.
And as you were traveling down Townsend, did you see that Nissan do something?
Yes, sir, it crashed.
Okay. Approximately where did it crash?
I think it was the 1200 block of Townsend.
I'm going to show you what's in evidence as State's Exhibit 199. Do you recognize this map, sir?
Yes, sir.
All right. Does this map fairly and accurately depict the Townsend area, that residential neighborhood, and the streets, Townsend, Lone Star?
Yes, sir.
And I want to go to State's 200, which is a closer version of that map. Do you recognize that, sir?
Yes, sir.
Okay. And is the top road Lone Star, is that what you were turning off of onto Townsend?
I was.
Okay. And when you saw that Nissan crash in the 1200 block of Townsend, can you show on the map approximately where you were in your patrol vehicle?
So I had to be either in between.
If you touch the screen with your finger.
Okay, I can. Okay. So in between Alderman and Timber Lane, somewhere within here, they popped out of one of either Alderman or Timber Lane, and they, like I said, my consideration was, hey, what if somebody walks out of their neighborhood? What if a vehicle backs out of their driveway? That vehicle had no consideration of that. That vehicle had one thought in mind, not being apprehended. So within that area, I saw that vehicle pop back out on the Townsend Road. I had to be within that area of Alderman and Timber, somewhere in there.
Is that where you were when you saw it, or is that where you were when it crashed?
So I'm not familiar with the area, so I went back to ride the area on one occasion, and I believe I was within that area before you get to Timber, in between Alderman and Timber, probably somewhere around here, where I visually saw that vehicle crash.
And once the vehicle crashed, what happened?
I saw a male get out in all black of the driver's side of the vehicle. And I saw that same subject that had that black and gray hoodie on get out of the passenger side vehicle with that same Draco pistol-style rifle in his hand.
And what did that individual with the rifle in his hand do?
So I parked a great distance from the vehicle because that's what we're trained to do tactically. And I approached the gate not knowing if he was waiting to ambush me or whatever. When I got there, I saw that subject. He had jumped that fence, and when I got to the fence, he was jumping the fence in the rear of the residence.
Let me back up for a second. Where were you, about how far away were you when you saw that individual with the rifle getting out of that vehicle and fleeing?
It's hard to determine. I was still driving. I saw them exit that vehicle, and I had not even stopped my vehicle yet. That's how far they were ahead of me.
Okay. And how long of a look did you get of that individual as they fled?
So at no time was I ever close to the subject, and it was a short period of time. It was a glimpse of maybe a second or second and a half. It wasn't long at all.
And did you lose sight of that individual that had the rifle before you stopped your vehicle?
So yes, and that's when I guess he was climbing the fence. And I can remember some of the units came up on the radio asking if he still had the rifle because I told them that he had jumped the fence. And I remember him still having that rifle and when he jumped that fence.
When you finally stopped your car, got out, and approached that home, where exactly was the individual that had that rifle in his hand that you were?
He was jumping the rear fence.
How long of a look did you get at him at that moment?
Not long at all. I'd say a second, second and a half. He was in motion. At no time was this subject standing still or not in motion. He was in motion, actively resisting, just trying to get out of the area.
What direction of travel was he going?
So, Mirror Road. I believe more of a westerly direction.
Is the next street over Belmead?
It is.
Once you got to the house that he had cleared the back fence, what did you do?
The residents let me inside to go through their house. I jumped the fence, and I got to Belmead, and I had lost sight of him.
Did you ever see him again?
No, sir.
Did you radio his direction of travel to other officers?
Absolutely.
Okay. After coming out on Belmead, did you stay in that area or did you go somewhere else?
So, the vehicle crashed. I went back to the vehicle to stay there in case those suspects came back to the vehicle and tried to leave the area.
Did you provide a description of the person you saw run across the street with the rifle?
I did.
Okay. And at the time, do you recall what description you gave?
Basically, the most, I guess, identifiable things, what he was wearing, as well as the rifle, what color it was. And then I tried to give my best determination of height based upon me being nowhere near him at any time to be able to determine his exact height or weight.
Well, what was the height that you gave as a description?
I believe it was like 5'8" to 5'10", something like that. It was an estimation.
Does 5'5" to 5'8" sound?
Yes, yes.
Objection.
In the grounds?
Proper refreshing meeting.
Overruled.
Does 5'5" to 5'8" sound?
Yes, sir.
And was that the description you gave that day based on where you were when you saw this individual?
Yes, sir. At no time was I ever in close proximity of this subject. The first time I saw him in the parking lot when the initial shooting took place of the Publix shopping center. I mean, if you know that area, or if you don't, it's the Publix to where the Dunkin' is, that staffing agency, it's a long way. It's nowhere, it's not a short distance. So then when I was watching the subject get out the passenger side of the vehicle, I was still driving. And I was still a long way away based upon even where I showed on the map. There was never a time that I was right up there on that subject where I can give you a very clear and distinct. Everything I gave, aside from what I was able to visibly determine, which was the best characteristics, was what he was carrying in his hand and what he was wearing.
Let me Showing you what's in evidence, State's Exhibit 80. Do you recognize this, the vehicle in this photograph?
Yes, sir.
Is that the same vehicle that you chased or followed from the shopping plaza?
Yes, sir.
And is that the same vehicle that you saw the individual with the rifle flee out of?
Yes, sir.
And that was the same individual you saw get into that vehicle at the shopping plaza?
Yes, sir.
Now, while you were waiting by that vehicle, did someone approach you?
They did.
All right. And was that a civilian?
Yes, sir.
And do you recall, or did you find out what that person's name was?
Barbara Buckley.
And what was the purpose of her approaching you?
So there was another lady that I'm not sure who she was. She came up to me, and it was another officer. She came up to, we were there at the vehicle, and she said, "Hey, my neighbor, someone has been holding her hostage in her house for over an hour." She said 2 subjects had, and she said they changed clothes in her residence. And as she was telling us this, Barbara Buckley was running down the sidewalk in complete disarray and exhausted. She fell at our feet, just so overwhelmed. And she began to give me the account of the subjects holding her hostage in her residence and them changing clothes and them leaving the residence. And she said it was a orange colored vehicle, that orange or red, that came and picked them up. And she said it was either a Challenger or a Charger type vehicle, and that they got into that vehicle and left the residence.
Did you relay that information to other officers?
I put it out on the radio. Yes, sir.
And did detectives take over that investigation?
Yes, sir.
And did you help maintain a perimeter around that Nissan until other officers got there to take over?
I did.
Did you later learn that there was a house on Belmead that had a camera that recorded some things regarding this incident?
Yes, sir.
Okay. And have you had an opportunity now to actually view that video?
I have.
Show you what's in evidence in State's Exhibit 190. Did you see the individual at the top of the screen?
Yeah, like a less than, like a second and a half or less. I mean, blazing.
Do you recognize that individual?
Absolutely.
Right. Where do you recognize that individual from?
The same subject that fired those shots in that shopping plaza. Same subject that I saw exit the passenger side of that vehicle and head toward that fence. Same subject that I saw when I got to that fence that was jumping that rear fence toward Balmead.
Now, this is at 11:03:27. Did it take some time for you to actually come into view on this camera?
It did.
Go 11:05:55, still states 190. You recognize that individual?
Yes, sir, that's me.
How tall are you?
6'4".
This is still states 190. Do you recognize the individuals in this still shot from the video?
I do.
And who are they?
On the right is the subject with the black, and with correction, on the left is the subject with the black and gray hoodie. And on the right, that's me. And if you use that vehicle, I guess as a...
Well, looking at this video, let me ask you this. Looking at this video, having been at that area at that date and time, do you believe your description that you put out was correct?
Yes, sir. I was wrong.
Oh, just a minute, sir.
I was wrong.
Just a minute, sir. Thank you. What's the objection?
You can come sidebar.
All right, let me see court reporter and counsel at sidebar. All right, ready, Madam Court Reporter? Okay, you may proceed, counsel.
Thank you. Officer Collins, having now seen this video, you didn't see it before you gave that description of.
No, sir, I didn't.
All right, having now seen it, does that affect your opinion as to whether or not that description you provided was accurate?
There's no way it can't. I was wrong. I mean, at no point was I ever close enough to determine an exact height. It was a guess, something for me to give as an indicator to everybody that was coming to look out for. The most distinct thing that stood out was what the subject was wearing and what he had in his hand.
Okay.
But no, this better gives me a marker of, because if I'm 6'4" and I'm on the right, and these images are pretty much similar, very close in height, based upon that vehicle as a marker.
Okay, no further questions, Judge.
All right, cross for Mr. Whitaker.
Yes.
Sorry, Mr. Whitaker.
Good morning, Officer Collins. I could not help but notice, as you are about to take, I guess, a left on Townsend, the subject car, the gray or silver Nissan, is directly in front of you, correct? And we can replay it if you'd like.
Yeah, please.
Sure.
Thanks.
187?
I remember on Merrill being behind it initially, leaving the parking lot.
Just have to click it, start.
And I stopped it right there because that's your car, sir, correct?
Yes, ma'am.
Okay. And so you had described that there was a red truck that you kind of somewhat had to cut off to get behind the suspect vehicle, correct?
Yes, ma'am.
And I know we know now that that actually was Mr. Krueger's car who had the dash cam, correct?
I'm not sure his name, but yes, ma'am.
Okay.
It was the dash cam from the vehicle.
And you recognize your own car?
I do.
Okay. And, ooh, I'm sorry, I did it.
Yeah, I
Fast
can get out.
forward or no?
I can get out of it, and then you can play with how you want. Just click play and you click around. Click.
And right here, and for the record at 3864, we see your car behind the suspect car, correct?
Yes, ma'am.
Okay. You don't have your lights and siren activated.
Right. So
And here's the question in regards to that. So you're coming out of Publix, I'm going to assume, and I shouldn't, you probably got a sub or chicken at Publix for lunch?
a wrap.
Okay. And so you're coming out, you're in your normal patrol uniform because you were working off duty?
Yes, ma'am.
Okay. And you're going to your patrol car, correct, sir?
Yes, ma'am.
Okay. And the first thing you hear is, if I remember correctly, is it almost sounded like a car was backfiring, correct?
Distant. Yes, ma'am. I heard just what sounded like a vehicle backfiring in a very distant. Yes.
And then the next thing you notice is you're describing this person running in some kind of gray and black sweatsuit, but with a large gun, correct?
So I heard what sounded like a vehicle backfiring. Then I heard a series of rapid fire coming from what I know is a rifle.
Okay.
And then I see a subject with black and gray hoodie running toward a vehicle, getting in a silver Nissan on the passenger side.
Correct. And so at this point, when you jump in your car, several things have already happened, correct? You've heard shots, correct?
I'm listening. Yes, ma'am. That's one.
That happened,
That happened.
okay? You've heard not just one shot, but multiple shots, correct?
Right.
You, based on your extensive experience and training, you understand that to be from a high-powered rifle, correct?
Yes, ma'am.
Okay. And then you physically see what, even from that far distance, you believe is a Draco rifle, correct?
Yes, ma'am.
Okay. So at that point, you know there's been some type of shooting, correct?
Something bad's happened.
Okay. And then you're behind this car that you see him jump into,
Yes, ma'am.
this person with the large Draco,
Yes, ma'am.
and you're behind him, and they're actually stopped, correct?
They hesitated.
Okay.
They hadn't broken any traffic laws at that point.
But you just watched a gunman get in the car.
Right. I didn't watch the crime. I heard what was a rifle rapid fire.
Okay.
I absolutely didn't see the crime. But what I do know, like I said, something bad at 11 o'clock has happened without even knowing what it was that had happened.
Okay. And obviously you knew it wasn't a fellow officer, right?
No, it wasn't, no.
This wasn't an undercover car. You recognize this as a subject car.
Well, I knew that a crime occurred. I mean, yes, I knew a crime.
And you knew it was at felony level, correct?
It was I think I put out on the radio, it was a 3388, which is a person shooting, aggravated shooting, yes, with a weapon.
Okay. But as we've established from the video, when you're making that left-hand turn and going through the parking lot yourself, you don't have your lights and sirens.
So per our policy, we can pursue a vehicle without initiating our lights. I'm still trying to determine what I had. So when when they began to travel at a high rate of speed to get away from me, that began a pursuit. Okay. At that point, it was not a pursuit. I was following the vehicle.
And that's when you turned on your lights.
When I initiated the pursuit, I did.
Okay.
At that point, I was just following the vehicle, which per our policy, we're able to do that.
Okay. And so then you get into this residential area, and we've seen some videos of you after you've gotten out of your car, you're still looking for suspects, correct?
So,
Yes or no, sir? Were you looking for
I'm
suspects?
trying to make sure that I answer your question correctly.
Question's real simple.
Okay.
Were you looking for suspects?
Yes.
Okay. And then you ultimately, though, go back to your car on Townsend, right?
Go back to the vehicle where the subjects had exited, not my car.
Okay, so the Altima that actually crashed on Townsend Boulevard, correct?
Yes, ma'am.
Okay. And fairly close to the Buckley home, correct?
The house was a little, I don't know exactly how many houses it was. It wasn't the next house.
Sure, but within your eye distance.
It was a distance down the sidewalk. I don't have an exact address or numerical that I can give you or a accurate distance that it is. So
Fair enough.
I don't have that.
Okay, fair enough. But your role at that time is to start holding a perimeter, correct?
My role was to stay at that vehicle,
Okay.
and I think I mentioned it already, to make sure that the suspects didn't come back to that vehicle to possibly leave the area. I was on my radio getting units in place to do the perimeter of the area. That wasn't my role.
Okay. Ultimately, a perimeter is set up, correct, sir?
Yes, ma'am.
Okay. And a perimeter, for our jurors so they can understand, is when you know of a geographic area that you believe suspects may be in, You tried to actually put officers on the perimeter of that geographic area in hopes that you'll capture the suspects, right?
Yes, ma'am.
Okay, and that's what happened in this case, correct?
We set up a perimeter
Okay. And you personally stayed on Townsend, correct?
at the vehicle.
At that car, making sure that the suspects didn't try to come back to that car, right?
Yes, ma'am.
Okay. But you never saw an orange Dodge Challenger, did you?
I didn't see it.
Okay. And you think there were 2 people that exited out of that Altima?
Initially,
Okay.
that's what I saw. But I've seen video since that proves that there were 3 people in that vehicle.
I don't have any thing further. Thank you, sir.
All right, cross for Mr. Robinson.
Yes, Your Honor, thank you. Now, officer, let's explain the stage. Let's imagine this courtroom is a shopping plaza, okay? The Publix is up in the northeast corner, right?
So the Publix, if we're on Merrill Road, the Publix is here.
All right, so we'll say that the Publix is up there, right?
Right.
Now, your car is parked a little bit ways away. It's a little bit from the Publix, right?
It's in a parking spot in the parking lot.
But it's not right out in front.
No, it's not right in front of the store. I had to run to my vehicle.
All right. Now, you sprinted to your vehicle, right?
I ran to my vehicle.
Do you remember giving a deposition in this case?
Sir?
Do you remember giving a deposition in 2021?
I mean, running, sprinting, I mean,
Is it the same to you, running and sprinting?
yes, sir.
All right, now you ran track and field, right? Are you unsure if you ran track and field?
35 years ago.
But you ran track and field.
35 years ago.
All right. In this case happened 5 years ago, correct?
Sir? 5 years ago, yep. This case.
My question to you is, you ran track and field. And the answer is yes, right?
Yes, sir.
All right. So you ran, sprinted to your vehicle. And you did that because you heard those gunshots, right?
I did that because I'm a police officer and I have a duty to enforce the law.
And you have a lot of experience. You have almost a quarter of a century experience in law enforcement, correct?
Been with the agency for 24 years.
All right. And because of that, you have experience in these high-stress situations, right?
Everybody doesn't have a high-stress situation during their career.
But you have.
I have.
You've seen people be shot.
I don't know if I've ever seen anybody get shot.
Would it refresh your recollection to read your deposition from 2021? Would it help your memory? Officer?
I've been in scenes where people have been shot.
Have you seen people murdered before? Yes.
I've been in scenes where people have been murdered before.
All right. And you've been in active shooter type situations, right?
I have.
All right. That's different than the regular civilian. You're trained for these situations.
We go through active shooter training.
So not only do you have training through the department, but you also have training on the job in these situations, in high stress situations. Yes or no?
Are you asking me if I've ever been in one, or are you're saying training and then you're?
Let's break it up for you. Let's break it up.
Be specific if you don't mind, please.
When you were in the academy, you were trained how to be a police officer, correct?
Yes, sir.
All right. And in your decades on the force, you have experienced high stress situations like seeing somebody murdered.
I don't know if you can relate. I mean,
that's not my question. My question is,
have I ever seen anybody get murdered? The answer is no.
Your Honor, page 21, lines 11 through 19. Question, I think it's probably fair that your adrenaline was pumping. Answer, your answer. I mean, it's an experience that you can't explain.
I've seen people murdered before while working, and I've experienced auditory inclusion. I've been in that full mad shooting, active shooter type situation. It's something you can't explain to people where they will understand what happens with the body during that time, honestly. Okay. Those are your words, right?
Yes.
All right. So you have a different level of experience than the common person.
I think I've been in some situations where other people haven't that are in law enforcement. And the determination, I didn't see Charles McCormick get murdered, but I know something bad happened. I've been in situations where people were shot. I didn't see them get shot, but later I found out that they were murdered.
You said, I've seen people get murdered. That's what you said, right?
That's me basing it off of what happened when the person shot into a crowd. Me later finding out a lot of people that die, they don't die right away. Okay? Sometimes they die over time, they die at the hospital. I've seen people get shot, later determined that they were murdered.
What we're talking about here is your ability to react and focus in these situations. You're trained to handle these situations. That's why you ran, you sprinted to your car, you jumped in it, right?
I ran and sprinted in my vehicle
because of your
pursuit of vehicle that was leaving the parking lot of the public shopping plaza.
Because you're trained to react in those situations, right?
Yes.
And you were so quick that you were able to get up right behind the vehicle before it left the parking lot, right? We saw it in the video.
I was able to get behind the vehicle before it entered on the Merrill Road.
Now, you were in uniform that day, just like you are now, right?
Yes, sir.
You had your radio on you.
Yes, sir.
There was somebody, and now at this point, you know that it was a shooter. You just said that it was a horrible situation. This person is running with a Draco-style gun through neighborhoods, right?
Are you talking about the Merrill Road shopping plaza? Because you said neighborhoods. You said I'm behind the vehicle before exiting onto Merrill Road. Then you started talking about a neighborhood.
So let's break it down for you again. You follow the vehicle crashes, you talk to Mr. Cooper about it. One jumps out, runs west, one runs east, right?
Yes, sir.
You chase the one that goes west because you believe that that was the person that did the shooting, right?
That was the person that I saw with the rifle running, getting in the passenger side of the vehicle that had the same clothing description and the weapon was the same that I saw. Yes.
Officer, my only question is, that person jumps out and they run west, correct?
Yes.
And you chase him.
Yes.
Using your track and field legs, your long 6'4" legs, you chase after him.
35 years ago? Yes, sir.
Are you saying that you are now in poor health?
I didn't say that. I just said that I can't relate what happened 35 years ago to 5 years ago. Everything changes over time.
I'm not saying that you are a track and field star now like you were then. What I am saying is that you used to run track and field. Your answer is yes, right?
Yes, sir.
All right. You're in uniform. You have your radio. This person with a firearm is running through neighborhoods with family and children, right?
It's a residential area that I saw the subject running into, yes.
And because of your calls, this is a calls out over the radio to all of your colleagues. A perimeter is set up to catch this person, right?
At some point, yes, sir. Not initially.
There's multiple helicopters overhead.
I don't know about multiple, but we had the air unit come to the scene.
They had drones in the air trying to find the person.
I don't think we had drones at the time, but.
And you put out over the radio the description of the people that you saw.
I did.
Now, Mr. Cooper asked you for your answer as to the height of the shooter, and your original answer was 5'8" to 5'10". Do you remember what you said on that day in the heat of the moment over your radio?
I believe it was 5'8" to 5'10".
Would it refresh your recollection to take a look at the CAD notes?
that was a estimation
Officer,
of
that's
what I
not my-
saw. So there's no time that I was ever close to that subject. Everything that you see from a distance is not accurate when you're talking about height. There was no time that I wasn't a great distance away from the subject in the Publix Plaza, nor when they were exiting the vehicle. I was still driving and I was at a distance. I wasn't parked. I wasn't up on the vehicle. There was never a time that vehicle wasn't accelerating away from me.
Officer, I'm going to cut you.
So I never had an opportunity to look at that person like I'm looking at you or be this close at any time. So that was an estimate or a guess for me to put out some information, as well as with the clothing and the weapon, for pursuing officers that were setting up a perimeter or that was coming toward the scene.
Officer, I didn't ask you to explain the answer that you haven't given us to us yet. And that is what it is you put out over the radio that day. Do you remember?
I told you, I believe it was 5'8" to 5'10".
Would it refresh your recollection to take a look at the call action detail notes from that day? Would it help your memory if you looked at
I don't
them?
have a problem with that, but as
Your Honor, if I could approach?
Okay.
Just the 34354, page 4. It's the 53 page one. Already confirmed his badge number 5686. Your Honor, may I approach?
Yes.
Officer, do me a favor.
You can read that highlighted portion, and I'm going to ask you the question again.
5686.
No.
Sir?
Read it to himself. Thank
Oh,
you.
I'm sorry. Okay.
Officer, you put out over the radio that day that the person that you chased on foot was 5'5" to 5'9", correct?
Yes, sir.
That's what you said on that day.
I did.
All right. Now, you said a moment ago that you didn't have an opportunity to see the person. So let's break that down.
I didn't say I didn't have an opportunity to
I
see.
haven't asked you the question yet, sir. The person jumps out of the vehicle and they run west. You get out of your vehicle and you chase. You see that person clear a fence, right?
I saw him run toward the fence. I was in my vehicle still driving.
So your testimony
When I got to that fence, that subject was jumping a fence in the rear of the residence.
So your testimony is not that you jumped out of your vehicle, that you gave chase, that you actually cut through somebody's home and you chased him through one backyard.
I went through a residence to the backyard of that same residence that the subject jumped the fence, and I jumped the fence. The question in reference to what I put out on the radio, that video that had that marker of that vehicle, I was wrong in my height description. I was putting out just information for those that were coming. That was absolutely a mistake.
Officer, I'm not asking you to explain your testimony.
Well, you asked me about the height, so I was giving you.
I need you to focus on my question.
Okay.
Okay? And we're talking about now fences and you chasing him.
Okay.
You jumped out of your vehicle, you chased him through one backyard, correct?
Yes.
And you saw him jump a fence in that backyard.
Yes.
And then you went up to that fence yourself, right?
I went up to the first fence, and I jumped the rear fence.
All right. So you, as a trained officer, you see somebody jump a fence, sort of like this podium. I'm not saying it's the same height, but you go up to it. So you have a point of reference where you can say, I saw this guy, this shooter, next to this fence, and I walked up to it myself. The question hasn't been asked.
Okay.
You had a point of reference, correct? The fence.
No, I didn't have a point of reference.
You just said that you saw him jump over the fence. You just said...
Jumped the fence in the rear of the residence.
I understand that, but you saw, just like you can see me standing at this podium, you saw him next to that fence.
I didn't see him next to the fence. I saw him jumping the fence At no time was he not in motion that I ever saw him. Every time I saw him, he was accelerating away from me, either just trying to avoid apprehension.
All right. Now, getting back to the apprehension situation. So again, you have a shooter that's running around neighborhoods. JSO is trying to find this person, and you can give a description of what it is you remember best. In the description that you give, BM, that stands for blackmail, right?
Yes, sir.
Gray hoodie, black sleeve, black sweatpants, right?
If I remember the black sweatshirt with the gray in it, yes, sir, and the rifle, the black rifle.
Now, you read this. There's nothing in there about a Draco-style firearm, right?
I'm not sure. I mean, I just saw one highlighted line that you told me to focus on.
Do you want to read it again?
The whole thing. Is that the whole, is that everything? Because I remember putting out on the radio, I don't know if the, so that you're reading is someone's typing. That's not the call that I voiced out on the radio. That's just someone as possibly like a court reporter that's trying to capture everything that's being said. I don't know if they captured everything or not.
Officer,
I know what I saw though.
Officer, so when you call out over your radio, there's dispatch. All of this is recorded. And somebody that works for JSO takes down these notes. These notes are important, and they take those down, right? It's not a court reporter, it's somebody that works at your department, right?
That's human that can make mistakes, yes.
Are you saying that they made a mistake?
I don't know.
All right. So these are also, this is something that's done, it's kept in the regular course of business, right?
Was kept in the regular course of business.
So anytime you're talking over the radio, these CAD notes are produced. You know that in your 20 years of experience.
CAD notes, they document whatever the call taker received from the phone, from the caller.
Let's get back to the topic of the height. Nowhere in your call, whether it's the recorded call or the actual notes, do you say, could be 5'5" to 5'9", I'm not sure. You don't say you're not sure, right?
It's always a guess. I've never been trained in determining people's height. At no time was I close to this subject. Every time I've seen this subject, it was at a great distance. And I think it's fair to say that anytime you're looking at something from a distance, it's not going to be accurate.
Officer, you said a moment ago to this jury that what you're giving are the things that stand out to you most because you want to find this person. You didn't have to give a height at all. You could have said that there's a black male running through neighborhoods wearing this type sweatshirt. You could have left it at that, right?
Yes, sir.
But you confined it to a certain 4 inches. That's what you chose to do, right?
That was my estimation or guess.
All right. Now, very shortly thereafter, you had a conversation with Detective Gibson, right?
Yes, sir.
And you told Detective Gibson, quote,
Objection, Judge.
impeachment.
Okay. Overruled.
You told Detective Gibson, a homicide detective, quote unquote, 2 black males fled from the vehicle on foot in an eastern direction while the black male Officer Collins originally saw with a firearm fled westbound on foot, still in possession of a firearm. He described him as slender, 5'5" to 5'8" in height, wearing a black and gray hoodie and black sweatpants. He shrunk an inch.
I don't even remember what our conversation was. Did I write that?
Hear my question again, officer. Hear my question again. You had a conversation with a detective that was investigating this case, and you said that to him, yes or no?
I don't know.
Would it refresh your
I talked to a detective, I've talked to officers, I talked to several detectives that day. If I wrote it, then I said it. But if I didn't write it, I can't verify that, sir.
So are you saying, no, you didn't say it, yes, you didn't say it, or you're not sure?
I'm saying that if I didn't write it, I can't say that I said it or did it. If I wrote it, then I have no problem vouching for what I said. I talked to several detectives, and I talked to several officers that day.
Should we just talk to Detective Gibson?
If I wrote it, I can verify it.
So your answer is you have no memory if you said this or not to Detective Gibson?
It was 5 years ago.
I understand, but my question to you is the same. Do you have?
Not sure.
All right. So, today you were asked a question by Mr. Cooper as to the height, right? And originally you said the 5'8" to 5'10". He then came back and said, wasn't it actually 5'5" to, I think it was 5'5" to 5'9", so he corrected you. In February of 2021, when we took that deposition, and I asked you the question of the height of the person that you saw, you said you didn't know, right?
And it's the same thing I'm saying now. There's no time that I was close enough to determine an accurate height. At no point was I close. And I think it's fair to say that anything distant from us is very hard to capture as far as being accurate.
Officer, in 2021, February of 2021, basically a year after this happened, not 5 years like today, did I ask you, yes or no, the height of the person you chased? Did I ask you that question?
Yes.
Was your answer no?
Can I see it? You have it?
Would it refresh your recollection to take a look at your deposition?
Sure, thanks.
Your Honor, 1 second, get a page in line. Page 29, the whole middle of the page.
May I approach, Your Honor?
Yes?
All right, officer, do me a favor, take a look at you can read the whole page.
What do you need me to read?
To yourself.
Highlight it?
Yeah, read that to yourself here.
Thank you.
Yeah, read that to yourself.
Which part, the highlighted or?
The highlighted, but feel free to read the whole page if you want. Did that refresh your memory?
Okay.
State your exhibit 2, the one that you had at the end of the direct.
Officer, did I ask you the question 12 months after the shooting, can you make an estimate on the height of the person?
You asked me in reference to the Nissan vehicle, and I told you no. That's what that says, and that's what I said.
Yeah, thank you. Officer, the person that got into the Nissan Altima was the person that you saw do the shooting, right?
You asked me, that parking lot, if you know where the Dunkin' Donuts is and that staffing agency versus the entrance exit of that Publix, that distance is probably close to a football field in distance. It's a long way. I'm not able to give you an accurate height based upon that Nissan Altima like you're asking.
Officer, please hear my question. My question to you is in February of 2021, where you asked the question in deposition as to the height and the weight of the person that you chased that you believe was a shooter.
Is that what you just showed me?
I can show you the whole deposition.
No, I'm asking you because you.
I asked the questions here. It's not the other way around.
No, I'm trying to verify what you're asking me so I can accurately answer.
All right. The person that you saw get into the Altima, that was the person you believed to be the shooter, right?
Yes, sir.
And I asked you the height of that person, right?
Yes, sir.
And your answer was no, I can't give you that answer.
Yes, sir, what you just showed me.
Okay, same thing.
But you told me, you asked also, you're leaving out because you're not telling the whole.
Counsel, why don't you read the question as asked and the answers as given on lines 7 through 13, if that's what you're attempting to do.
So, Your Honor, the next reference and the better one that I can give is page 22, starting at line 6. Question, best Best description that you can provide. You've already given us the clothing in regards to two-tone, but anything else you can tell us about the suspect? Answer from you. The one with the rifle? Question, yes. Answer, I think you took red. I saw the black rifle, gray and black two-tone hoodie on, pretty much it. Question, okay, I didn't know if you had any kind of estimate on height, weight, race, anything like that. Answer, no, it was hard to determine. You said that, right?
Yes, if I were.
Right. So February of 2021, you were not able to give a height and weight estimate.
When I gave,
Yes or no?
when I gave it, I was. But it was based upon the distance that I had a glimpse, short, less than, probably a second and a half or less, of seeing this subject. From a distance, second and a half, maybe, at any given time.
Awesome.
But the video that's up now, where it references this vehicle near Belmead, I'm 6'4". This subject is closer to my height than I initially stated, sir.
Officer, and that's the point that we're getting at. In February of 2021, you were asked the question on height and weight. You had no information. Yes or no?
I did have information.
No. When you were asked in deposition, the question we just...
I said, no, I couldn't accurately give it to you.
4 years later, we're sitting in a courtroom and you're asked the question by the prosecutor, and your answer is, well, I can tell you. You didn't go back out to the scene, did you? You didn't go out there and measure anything.
I'm looking at the vehicle.
I understand.
And there's still photos. It's not moving.
Officer.
It's not moving.
You can't tell what type vehicle that is, can you? What type vehicle is it, make and model?
I don't think I need to determine what kind of vehicle it is. I think I need to be able to determine based upon my height and the height of the subject from the roof of that vehicle.
So you're making your estimate, that little tiny image that flies by that car, not knowing what type of car it is, but knowing how tall you are, not knowing if he's standing closer to the vehicle or not, to make that estimate.
I'm basing that off of the still image, sir.
All right. Now, no testimony in 2021, but today here, you're able to say, I was wrong about everything, and you want to know what? He was taller, right?
Looking at these pictures, yes, sir, he was absolutely closer to my height.
And the only thing that you've done in between the deposition in 2021 and the testimony here today changing it, you didn't go out there, you didn't measure anything, but you met with them, right? You met with them before you testified.
I think everybody does.
Yeah, and they corrected your testimony just like they did here today.
No, they showed me this video.
Okay, just a minute, sir. There's an objection.
That was not.
Sir, when there's an objection, you need to stop speaking. Thank you. State, what's your ground?
It's argumentative.
Okay, I'm going to sustain that objection. Let's just ask a question, answer the question, ask a question, answer the question. That's how a trial proceeds. So, counsel, you may proceed.
You sat down with them and talked about your testimony here today, specifically you saying that you were wrong about the height to make it fit my client.
They presented this photo to me, sir, as still image, and I was able to determine that I was wrong in my estimation of the height, that this height was closer to mine.
One brief moment, Your Honor.
Yes.
Briefly, Your Honor, then we'll be able to stop for lunch, if Your Honor wants to.
I'm sure the jury does.
Officer, you've taken plenty of depositions over the years, yes?
Yes, sir, I've had depositions over the years.
Yeah, and you know well that at the end of the depositions, the attorneys ask the questions. If anything changes, please inform us. You know that, right?
Yes, sir.
All right, you also have reports. If things change, you can file what's called a supplemental report, right?
Yes, sir.
You never filed a supplemental report in this case saying that you were wrong previously in your assessment. We're learning about it here in front of this jury, right?
I didn't realize it until I saw the still images.
And you just saw those this morning?
No, sir.
When'd you see them?
During my pretrial.
And when was that?
I've had maybe 3 or 4 pretrials. I'm not sure.
When was the last?
I believe it was a week ago.
All right, so you had a week to update people, but you didn't do that, right?
I did not write a supplement.
And it also took them 4 times to organize this testimony for today.
Oh, that's common.
With
Yeah,
John.
sustained. Thank you. Any redirect?
I don't think it's necessary, Judge.
Okay, may this witness be excused?
Yes, Judge.
All right, thank you. Officer Collins, you're excused and free to go, sir.
Your Honor,
Yes?
we still have this witness under subpoena.
Okay, so you're excused for now, but still under subpoena, sir. Thank you. All right, ladies and gentlemen, it is 12:07, so we're going to take our 1-hour lunch recess for the day. I'm going to ask that you leave your notepads behind. We're going to lock them, secure them, and return them to you when we reconvene. I'm also going to remind you, as I will at every long recess, that you're not to talk about this case among yourselves or with anyone else, or allow anyone to say anything to you or in your presence about the case. And of course, if anyone attempts to do so, immediately report the matter to one of my bailiffs, and they will, of course, notify me. Again, we are going to return your electronic devices. You may use them during the lunch recess, but at no point are you to use those devices to look up anything or any information about this case or the people and places involved in this case. And do be very, very careful that you don't inadvertently look at any articles or read any news stories that might appear on your cell phone. So with that, I'm going to give you till 1:10, and we will return here in courtroom 407 for the continuation of the state's case. So you are excused for lunch. Thank you very much.
All right, y'all. So we got about 30 minutes or so before this trial resumes. So we are going to actually go over to our, to the Ali trial, y'all. So I believe that the state has rested in this trial, and they were doing the charge conference, and closing arguments should be coming up pretty shortly. So going to go back over into that courtroom for the next 30 minutes or so, and we shall resume whenever this trial comes back. So see you guys then.
As to why, I didn't get a chance to cross him on why he wanted her to go home, because she wasn't supposed to be there, or just because the event was over and just go home. So I do think that instruction that he disagreed with.
And so I'm not making that argument. So insofar as that's helpful, I don't think that applies. That burglary plainly was committed prior to that statement being made. So I understand that concern. That's not an argument the state's making or would make, and I don't think that makes that instruction applicable. I guess my concern is that Mrs. Ali describes what she sees as it relates to what is happening to her husband. My concern is that whether the jury looks at that and says, well, then do we need to take what Mrs. Ali said she says and cut Mr. Ali out of those observations altogether, even though it doesn't address any behaviors done by Mr. Ali. In fact, it's completely silent as to behaviors by Mrs. Ali, or excuse me, Mr. Ali. So that's my concern, is that it is going to be confusing to the jury in terms of how they apply it to Mrs. Ali's statements about her husband.
What specific statements are you concerned about would be confusing to the jury if this instruction were given?
Yes, Your Honor. My concern is that the way it implies is Mrs. Ali very specifically says she rolled up. She doesn't say roll up, but she and Honey arrive on the scene, and that she is watching a student beat her husband, they're punching him over and over and over again. Those were the statements that she continues to make. My concern is that the jury, in reading this instruction based on essentially the nature of it, that somehow then they have to pretend she doesn't say Mr. Ali and it's just a person or someone else. That they shouldn't use it that way, but because of the way that it reads, my concern is that somehow they will neutralize and take Mr. Ali out of that statement by Mrs. Ali.
Well, luckily I don't have anything. So.
Any actions to Mr. Ali.
Oh.
There's no statements regarding a confession or conspiracy.
Oh, I was just gonna say I did check in, and everybody seems okay with the lumen drop. If that was the question you were getting ready to ask, so no issues as of yet. But we're fingers crossed that it's smooth sailing and everybody's happy.
The state said that they weren't going to argue, but that's not the only standard. You are telling the jury how they are to weigh the evidence and how they may use the evidence. And just because the state doesn't make an argument with respect to the burglary, it doesn't mean that the jury might not use Mr. Ali's statement.
All right. I am going to give instruction number 8. I think it is appropriate under the evidence that has been presented in this case as it relates to statements by the defendants. I do not believe that it's going to limit the state in how they can argue their case and the facts that have been presented in this matter as it relates to each of the defendants. Instruction number 9, the last clause of that instruction or of a third person was included in the instruction offered by the state and Mr. Kading. That clause was not in the instruction offered by Mr. Leary, and it appeared to me that it doesn't apply.
The state agrees with Mr. Leary's instruction, Your Honor.
All right, Mr. Kading?
I do too, Your Honor. I only included it because it wasn't bracketed, so I agree it's not relevant.
So what I have bolded in the draft instructions will be deleted. All right, Ms. Stone, any issues with 10 through 12?
Only on 10, Your Honor, I would indicate, I think we need a, he or she does any act that is a substantial step.
All right. If I add or she, any issue with that instruction, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right, and I didn't ask you, any issues with 11 or 12, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right. Any issue with number 13, Ms. Stone?
No, Your Honor.
Mr. Kading?
No.
Mr. Leary?
Yes.
All right.
So I guess at the outset, as evidenced by the pretrial brief and representations, the state had previously indicated, despite what was in the amended information, that they were not proceeding on an accomplice liability on the murder. I reached out to the state after I saw their draft instructions to say, had that position changed, or was this included in error? And they indicated that they did intend to offer this with respect to the attempted murder, and the specific explanation was based on Ms. Wagner's statement as to the actions of my client in terms of that she saw mom striking the man, and so her testimony was different from that, but regardless, I don't believe that there is, so I just want to be clear that the accomplice liability applies to the attempted murder, is that correct, from the state's
Yes.
perspective? And only the attempted murder, so operating from that. So
No, I mean, she's charged as a principal or accomplice several times. If we're talking about the attempted murder, which I understood the question was, then yes, it applies to the attempted murder, and she has been charged that way consistently. I think that there are two theories that the jury could apply it on, either as a principal or as an accomplice, but both of those are available to the state. And what we did discuss very much earlier on in the case, a different scenario that much later in the case, as we talked about it, Mrs. Wagner's information is different, and I think the testimony at trial is consistent with the charging, and the state intends to argue that as well. I think there's two theories that the jury could find that on, based on the testimony that has come out at trial.
I think we're on the same page.
Okay.
I wanted to be sure that I was only talking the accomplice theory, in addition to the intentional theory on the murder too, is the only, the count of attempted murder is the only account where the state is proffering an accomplice theory, not the assault two or the unlawful assistant. Is that correct, or am I incorrect?
I think counsel is incorrect. I think that both of those apply. I think the stronger argument, certainly for both of them, for the state is the principal, but I think the accomplice liability applies for both. The state would be arguing both of those as charged.
Okay, that's helpful. Thank you. So the question then becomes, in the instruction, is there sufficient evidence for the jury to consider my client as an accomplice? And I will start with the attempted murder too. If we look at the video, we know that in Exhibit 34, you can see at 213, you can see the Honda Element going the opposite direction on Mullen Road from the bus. And it then turns, the bus then parks, and then the Honda Element turns into the parking lot. The Element is already turning into the parking lot while the initial physical confrontation between Mr. Ali and Isaiah Williams, and can see the initial confrontation. So she then pulls into the parking, actually Haneen pulls into the parking lot, and on Exhibit 114, which is the Timberline High School video, we can then see her running across the parking lot, and there's been no testimony as to what is visible from there. We can surmise the distance. We know there are cars that she's running around, and that there are kids surrounding Mr. Ali, Fatima Ali on the ground. We then look at Exhibit 89, which was discussed yesterday, admitted earlier in trial, which shows the arrival of my client standing next to the truck with the large Douglas fir tree in the middle of that still shot exhibit. So we know there's been no discussion about a conversation between my client and her husband about solicitation, a direction, commanding, encouraging, or requesting Mrs. Ali to commit the crime of attempted murder. There's no testimony that she agreed to aid in the planning of the commission of the crime. So the sole question is whether or not she aided Mr. Ali in the allegation that he committed attempted murder. We know that mere presence and knowledge of criminal activity, so more than mere presence and knowledge of criminal activity must be shown to establish that a person who is present is an accomplice. That's in the instruction. So, and then there's case law that talks about it's not should have known, it's that they actually knew. Now, the state has made a large effort, or has addressed this topic repeatedly, that at no time did my client tell the police, talk about strangulation, or talk about or seen her husband strangle Fatima. She talks about the repeated punches to his head over and over and over again. Furthermore, the court is well aware of the positioning of everybody. So we have Mullen Road, we have Fatima on the ground, we then have her dad either on top or laying in between Mullen Road, so Fatima, Mr. Ali, and the school, the direction in which she's coming. There's been no testimony that, in terms of what was visible from the parking lot, there's no pictures or evidence that detectives went afterward to basically show what is visible from the parking lot. There's nobody says, it was very clear from where I was standing next to the truck or between Mr. Ali and the truck that it was very clear that what was happening. What she says is, I could see him being struck in the head by Isaiah. So the state has to prove that she has actual knowledge that he was attempting to kill her, and that she then, with that knowledge, agreed to assist in the commission of that crime. And there simply isn't sufficient evidence for the jury to be instructed on attempted murder 2 as to as to attempted murder. So then the next question is, as to assault 2, with respect to strangulation, same argument. You know, she comes up, and we know from Mr. Wagner's arrival, he comes from one side where he can actually see Fatima, intervenes, and his testimony is Dad immediately, he removed Dad's arm with some force, but there really wasn't much of a struggle, and he basically was able to immediately stop Mr. Ali and the actions of Mr. Ali. So then we go to the unlawful imprisonment. Now, the court noted yesterday in the halftime motion that strangulation isn't a part of reasonable parenting. But we have to look at it, again, from the eyes of my client. She sees, presumably, we don't actually even have testimony that she did see, or could see, or made eye contact, but there's an argument, circumstantially, that she was able to see her husband and able to see her daughter as they passed by the bus stop on Mullen Road. And in the video, 34, there is nothing that's happening at that point. There's been no physical struggle, there's no punches, there's no strangulation. So she pulls into the parking lot, she knows presumably where they are because that's where she ran. There's no testimony that anything that happened beyond those kids is visible. She then runs through cars, sees arms punching her husband's head, goes into the crowd, same time Wagner stops Mr. Ali. She then grabs her daughter. So in the split second that this all happens, mere presence and knowledge of criminal, more than mere presence and knowledge of criminal activity must be shown. If we're talking also about, self-defense, we talk about mistaken belief, right? Which is a somewhat analogous here. There's nothing to suggest that he says, I'm going to kill my daughter, and that was the purpose of going to the school. So there's nothing to suggest, again, that solicitation, command, encourage, request. The only issue is whether she aided him in attempting to kill her daughter in the fraction of a second where she arrived with Mr. Wagner and he diffused. There isn't a basis for accomplice liability. Now, the state is also arguing, and I'm not arguing for a halftime motion, as that the actions of my client as she's holding her daughter, the state is alleging assault 2 for that, and unlawful imprisonment. And I'm prepared to argue to the jury against that, but to say that she is an accomplice to what happened before she arrived, and in the fraction of a second that she's there, I think is an abuse of the accomplice liability statute and legal theory.
Just one moment. All right. Ms. Stone?
Thank you, Your Honor. Your Honor, counsel in his argument says that she sees her husband being punched repeatedly. We saw that from the arguments, or not, excuse me, the arguments, the body cam video of Mrs. Ali's statements that she sees her husband being punched repeatedly, over and over and over again. She in fact demonstrates that to Officer Chavez over and over and over again. Those punches can only be happening while her husband is strangling her daughter. Josh Wagner, who quite plainly gets there after Mrs. Ali, that is on video. That was also what Mr. Leary just indicated in his argument, because that's consistent with the video. Mrs. Ali arrives not long before Josh Wagner, but just before Josh Wagner. Josh Wagner, who knows none of these individuals from Adam, immediately says, as he's walking up, he can see that this man is strangling a young girl. Initially, as he is stopping his vehicle, he believes it is a car, or excuse me, a group of kids fighting another kid. He says as soon as he's out, he can see that it is a man strangling a child. Mrs. Ali arrives at that scene just prior to Josh Wagner, not long prior, but just prior, and instead, she, who knows both of the parties, she obviously knows where she's going to get to that bus stop in the first place, so she has communicated with her husband in some way. That is the state's argument, because otherwise she has no way to know to go to the bus stop from where she is sitting, even by Mr. Leary's own argument, out in the parking lot, if that communication has not happened. So of all the people there, even if she knew none of that, she knows who those individuals are. And so everybody there who doesn't know anyone else from Adam clearly sees and testifies immediately that they can see a grown man strangling a child. Mrs. Ali arrives on scene, and instead of assisting her child, immediately starts pulling and striking the children that are there to get them away from her husband. And all of her concern is about her husband. So she's already on the ground at the time that happens. She absolutely is an accomplice to that attempted murder. She is not helping her child. Counsel can make the argument that he doesn't believe the accomplice liability theory applies, or that the state has not met that burden. But all inferences should go in favor of the state, all of those reasonable inferences, and it should be provided to the jury to make that assessment themselves. Certainly she is more than simply on scene and present. That application actually in this case would apply, I would argue, to the kids who are videotaping, to the people who are watching and don't know what to do, not Mrs. Ali, who immediately jumps in, inserts herself, and is not there to assist her child. It does not appear based on the testimony that we have received. So the accomplice liability absolutely is appropriate for that, for the unlawful imprisonment as well, because then immediately upon being released, despite all the information to the contrary from the spectators, she immediately goes into choking her child as well as restraining her child while her child is trying to get away from her, in exactly what everybody else says they saw, and that she was there at the same time to see. Everybody identifies that after Josh Wagner does whatever Josh Wagner does to restrain Mr. Ali and have Fatima released from Mr. Ali, all of the striking stops. That is consistent with the video. So if Mrs. Ali is there to see repeated strikes over and over and over again, then she is also there when that strangling is happening of her child, and she knows those parties better than anyone else. So the accomplice liability absolutely should be given in that case.
Mr. Lurie, anything further?
I'll leave it up to the court, but I think I would encourage the court to go back and watch the short clip in 34, where you see the arrival of Mr. Wagner and you see the arrival of my client. If you have questions as to the representation of the parties, as to what my client did and what appeared to be visible to her.
All right. Certainly the court viewed that clip, which I believe was played multiple times during the course of the trial, and so I'm familiar with what I saw during the course of the many playing of that video, and I would posit that I saw more and more as I watched it time and again, based upon the questions that were being asked of any particular witness who was viewing that footage. Certainly as it relates the information, which is not ultimately controlling as it relates to the jury instructions. It's whether or not there has been evidence presented if with inferences, with reasonable inferences to the state, whether or not an instruction would be given, even regardless of how how the matter is charged within the information. I do find that there is sufficient evidence when I view the evidence with reasonable inferences to the state for their arguments of accomplice liability as it relates to Mrs. Ali. As has just been argued on the attempted murder charge, the assault in the second-degree charge, and then I don't know if you want any further argument as it relates to the unlawful imprisonment, but I also would, it's all of those things are linked together in the time frame, and so really I find that there's sufficient evidence with all reasonable inferences for the accomplice liability for all three, for the attempted murder, for the assault and for the unlawful imprisonment. And so I will be giving instruction number 13. On number 14, the Whitaker indicates that when there is an attempt, that there needs to be an elements instruction separately delineating the elements of the crime. The state proposed number 14. When I viewed that, it appeared to me that the last two paragraphs in the proposed instruction are not appropriate because only the elements, by my reading of WIPIC 100.02, should be included in that instruction. So, Ms. Stone?
No objection to that, Your Honor. State agrees with that deletion. I would also ask, essentially, anywhere it says FIA at this point, we just, based on the way the testimony came out, that we just change it to the name Fatima Ali, and date of birth obviously isn't even needed, excuse me. And
so
that will be throughout the instructions.
All right. Mr. Kading, as to instruction 14 with the suggestion that the last two paragraphs be deleted. Up in the first paragraph, it still says the elements would need to be proven beyond a reasonable doubt, so that is still part of the instruction.
Correct, and I agree with the court's analysis on that.
All right, Mr. Larry?
I agree with the deletion of the last two paragraphs. I have no objection to using Fatima Ali. I would object to the inclusion of her birthday because I think it's incumbent on the evidence to establish her age.
No, I said not to include it.
So if the court didn't go with your suggestion, I would note an objection. And then with respect to element 1 and 2, it says a defendant. I would ask that it say the defendant. My concern is that if they were to convict one defendant, it would necessarily result in the conviction of the other.
Ms. Stone?
I don't think I have an objection to that.
All right. And Mr. Kading, any objection to me using the name Fatima Ali and removing the date of birth?
No, Your Honor.
All right. Any objection as it relates to the defendant versus a defendant in elements 1 and 2 of instruction 14?
No.
Any exception on 15, Ms. Stone?
Yeah, I think it needs the principal or accomplice language in element 1, that the defendant, that on or about October 18th, 2024, the defendant, and then I think it should be inserted, comma, as a principal or as an accomplice comma, and then did an act that was a substantial step. So I think that language needs to be inserted in there.
All right, and this was your proposed instruction?
It was, yes, Your Honor, it just got left off.
All right, and so, just so that I have what your proposal is in full, after the word defendant, as a principal or as a accomplice?
Yes, Your Honor, both of those set within commas.
Okay. Mr. Kading?
Now I'm confused. So are they alleging that the defendant, Mr. Ali, was an accomplice to his wife's actions?
It's
Because
charged
this
with,
is
I
his
think,
instruction, right?
it is his instruction. I think that it is charged that way. I think that the state is alleging it at, not I think, the state is alleging it as a principal, but I also don't want the jury to get confused when they are listening to Mrs. Ali's, that somehow they have to decide that one person is something more than the other person. And I think that that language is appropriate in that, because it is irrelevant in terms of if they believe, if for some reason they believe that he is an accomplice over a principal based on the information, I don't want them to get tied up in that language. So that is an appropriate statement, and the state is arguing primarily that he is a principal, but that there is a concert of action between the two of them at the time these events are going on.
Mr. Kading?
And Your Honor, I don't know, based on what we've seen, how his actions, which were his own, he then is laid flat on the ground, not moving. If there's an allegation then that she did something, I don't know how he's an accomplice to what she's doing. Similar to what Mr. Leary was arguing, except my client being there and prostrate on the ground certainly has nothing to do with what's going on with Miss Ali behind him.
All right, anything further, Ms. Stone?
No, Your Honor.
All right, I am not going to, in Mr. Ali's instruction, include the language as a principal or as an accomplice, even giving all reasonable inferences to the state on the evidence that was presented during the course of the trial. I don't find that the evidence is that Mr. Ali, or it could be argued that he was an accomplice on the attempted murder to Mrs. Ali. And so I'm going to leave it as was set forth in instruction number 15. Mr. Leary, any exception on number 15? All right, then we are at number 16. Just a moment. Ms. Stone, on number 16.
Yes, Your Honor, element 1, same request of the state included the defendant, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step.
All right. Mr. Kading?
No objection to that.
Mr. Leary?
Based on the court's prior ruling, I think that assertion is appropriate.
With your standing objection?
Exactly.
Okay.
And then there is a typo, it should be element 3, not 4.
Thank you.
Your Honor, we ask the defense lawyers to approach the microphone, please.
Yes. Thank you.
Sorry, sir.
All right, number 17, any issue with that, Ms. Stone?
No, Your Honor, thank you.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Number 18 is the definition of assault. And the definition was different as was provided. It appears to me that at a minimum, the first paragraph in instruction number 18, which includes a sentence that is bolded, that paragraph would be included as the definition. I'm not addressing the next two paragraphs yet. So, Ms. Stone, your instruction did not have that second sentence in the first paragraph. Any objection to the second sentence?
No, Your Honor, it should have. Thank you.
All right. And so, just talking about the first paragraph, Mr. Kading, you proposed that language that the second sentence be included, and so you agree with that? First paragraph only, instruction 18.
I don't know that the second sentence, actually, I think it's bracketed, right? I don't know that that's something that's gonna be argued in this case. That it's an offensive touching. Usually we use that in a lot of other kinds of cases.
I'm talking about the language, a touching or striking is offensive if the touching or striking would offend an ordinary person. I'm pretty sure you proposed that language. If you're not proposing it.
Looking for my instruction package.
Oh, that's not true.
Okay.
You did not propose that language.
Okay.
You proposed just through the end of the first sentence and then nothing further. Apologize for that. That was language that was proposed by the state. They gave the entire 35.50 WIPIC instruction. And so you want just the first sentence?
Well,
Or that's what you believe is appropriate under the evidence, is what I mean.
I think that that's what we're talking about, is a harmful touching, not an offensive touching in paragraph 1. Their allegation is that there was actual bodily injury, so paragraph 2 talks, can I move on to paragraph 2? I'm sorry.
No, we're just talking about paragraph 1.
I don't think there was any offensive touching in this case.
Aren't you arguing that, or aren't you going to request that I give an instruction that this was discipline, or that could be a defense? And so isn't whether or not the touching is offensive associated with, it's not an argument related to your request that it was a
Yes.
defense?
Now that you mention that on the assault 4 would be a appropriate definition.
Well, all right. Mr. O'Leary, any objection to including the entirety of just paragraph 1, including the language that I have, that one sentence that's bolded for instruction 18, just paragraph 1?
Okay.
All right. So as to instruction number 18, the entire paragraph will be included, and of course it will be unbolded. Now, as to the second paragraph is to be given in cases involving an attempt to inflict bodily injury but not resulting in battery. That does not appear, from my perspective, to be what the evidence suggests, and that was, that language is not proposed by defense, it is proposed by the state. So Ms. Stone, I would like to know why you would want that included.
Yes, Your Honor. When we talk about the assault 4, I want to make sure, because we've spent so much time during the course of this case with Fatima, that all of these injuries have occurred. So when we're talking about the assault, those additional paragraph instructions make it very clear that when the jury then moves to look at the injuries to Isaiah, try and decide what level of injuries, if they're sufficient, if there's in fact injuries, those two follow-on instructions make it very clear that for the purpose of assault 4, no bodily injury is required. The state does not have to prove that bodily injury exists. And that helps clarify that for the jury, because like I said, we spent a ton of time talking about the nature of the injuries to Fatima. And there is obviously a significant distinction between those two. I would also indicate that Mr. Keating introduced photos that certainly look different, I think, from the states, or maybe arguably look different from the states. And I don't want the jury to get caught up in whether, well, we can't really see them here, or we don't see any, so it says that it's harmful, and we don't know that there's an injury, so therefore this assault 4 didn't occur. Those 2 additional paragraphs make it very clear that the state does not have to prove that, and that is not the definition of assault. If there is no injury that is required in that case, and so I am asking that those be provided. It helps the state more fully argue that, and I think it is helpful to the jury in making that decision.
Mr. Keating?
Well, again, I mean, we have video of a punch. It seems to me that that's covered by number 1, paragraph 1.
Mr. Larry?
I would object to the last 2 paragraphs. My concern is the confusion as to, the state wants this for purposes of the assault 4, which doesn't come up until instruction 39. And looking at the 2 convicted of 39 is they have to find that on or about October 18, 2024, the defendant assaulted Isaiah Williams. All they have to prove is an assault of Isaiah Williams in the paragraph defines assault as an intentional touching or striking of another person that is harmful or offensive. And so I think they certainly have the room to argue their theory as to why that has been committed. And my concern is that the inclusion of paragraph 2 and 3 will be detrimental and confusing to my client who is not charged with a misdemeanor assault 4.
Ms. Dunn?
I'm confused, I suppose, I'm confused as how that would be detrimental. Arguing the law as it applies to the facts in the case would be detrimental to a defendant. Paragraphs 2 and 3 are the law of the assault. It is a definition for assault. It is clarifying information for the jury, and so it is confusing to the state how providing a correct statement of the laws, especially as it relates to assisting them for Isaiah, somehow becomes detrimental to Mrs. Ali when there is a clear standard for Mrs. Ali as to the nature of the injuries that have to occur, or the intent for those types of injuries to occur, whereas assault 4 is relatively silent about that. So that argument doesn't make sense to the state in terms of how it becomes more detrimental at all, let alone be more helpful to the jury.
All right. As to the 3rd paragraph, I am not going to include the 3rd paragraph. That is the language, an assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. No inference from any of the evidence in this case relates to that portion of the definition of assault. And the WIPIC 35.50 indicates that the 3rd bracketed definition should be used if there is evidence that the actor's intent was not to inflict bodily injury, but only to create the apprehension or fear of bodily injury. And the evidence that has been presented in the light most favorable to the state is the 1st paragraph definition of assault, that it's an intentional touching or striking, and that is the evidence that has been presented, not that there was apprehension or fear with no actual physical contact. So I'm not including.
All right, y'all. So as y'all can see, we are back in the courtroom for the queso trial. We are just pretty much waiting for it to begin. Now, if you missed If you happen to miss what went on yesterday, child, it was a mess. But in the long scheme of things, they are accusing Queso, his cousin, and their friend of unaliving another Jacksonville rapper by the name of Lil Buck for actually dissing someone who may have already passed away. What's interesting about this trial is that that's kind of the culture down there in Jacksonville with the rappers. They all kind of beef and make songs about one another. So this trial has a lot of attention on it just because it also kind of relates to the Julio Fulio trial because these are essentially the same group of individuals or people or gangs, if you would, that are rivaling, right? We know that Young and Ace was also mentioned when we think about the Julio Fulio trial, and Queso is actually affiliated with Young and Ace. So, it's they say this is how it goes down in Jacksonville. There's 2 juries in this room because the cousin Scotty also has a burglary and a home invasion charge, and they don't want to inflame the jury as it relates to Queso. So kind of a little bit of a defense strategy or a tactic, if you will, to try and keep it fair and square. So one jury is just listening for Queso, and the other is listening for Scotty. Yes, D Wood. This is down in Duval County. This is down in Duval County in Jacksonville, Florida. If you are interested in the Julio Fulio trial, the young lady that was a part of that trial, her name is Alicia. Her trial is going to be starting on 8/18.
Are the jurors in their jury room? Prior to the lunch break, and I'll hear as succinctly as you can any additional argument that you may have been able to, now with a 1-hour lunch break, more thoughtfully thought through.
No, none more, Your Honor.
Okay.
Florida's a discovery state. Scipio stands for this exact situation. That I trust that Your Honor saw the case law. The
Yes.
situation was very similar. He was considered to be harmful. The situation here is different. Now, I objected and I went sidebar because I thought he was going to try to comment on the video based on the knowledge that came in the video. But that's not what this was. He sat down in their office and he did what they have Latham do. He did photogrammetry. He sat down and looked at one photo and another, not based on any personal knowledge from when he was there, and made an assessment on height. Now, there's a whole host of things that I would have done. The stuff that I said before, I would have done that. I'd also get an accurate reading on his height. I don't think he's 6'4", that's my lay opinion, but I'd want to know exactly what is his height. He's also giving an opinion based on a person that is running. We touched on this in the Dauber hearings that when a person runs, they draw. Interestingly, their expert Latham said he would never touch that video because it wasn't reliable for him to do an expert analysis.
Okay, but let's focus it. I care nothing about Mr. Latham and programmetry at this point. It's this witness and the discovery violation that you're alleging involving this witness's changed testimony? Okay.
So, Your Honor, I've brought out, yes, redacted testimony, or recanted. So I've laid out what the prejudice is to us. I mean, the fact that I'm having to do on the fly a cross-examination of a case that's 5 years old on something that I could prepare for, that I've been preparing for years. So there's that. That's the prejudice. Was it willful? Absolutely. They knew that this was coming in when they created that slide. Again, we don't have a problem with the slide. We have a problem with what came out of the officer's mouth. Based on Scipio, the second that they knew that he was going to say, I was wrong previously. They were under a duty to give it to us. Now, the reason why we stopped, and this wasn't asked about anymore in deposition, because in deposition he was asked a question, Your Honor has a full transcript. Do you know the height or weight of the shooter? And his answer was, I don't know, I don't know. The remedy that we are looking for is to strike that portion of his testimony with an instruction to the jury.
Which portion specifically?
When he said, based on my view of that exhibit, I was wrong in that and then gave his new opinion of the the person was around my height.
Okay, I'll hear from the state.
Judge, I would just say that I don't believe it's a material change in his testimony. He does not give a height. He was personally there that day, looked at the video. This is evidence that the defense has. His testimony today is, and as it has been when it was brought up by the defense, he gave estimates, he gave ranges. And today he just said, looking at that, knowing how tall I am, that's me in that video. I think I was wrong. I think he's a little closer to my height. He didn't say he's 6'3". He didn't say 6'4", 6'1", any of those things. He just said, I think he's closer to my height. I don't think it's a material change in his testimony.
Okay, thank you.
It's a change of nearly a foot from his previous testimony. It's a material change in his testimony. I understand and the important thing, Your Honor, this is our entire defense. We have been very clear what our defense is on this case, that it is all based on a misidentification. The height and the weight is the biggest thing. We're under an obligation to give that. They didn't. It's a violation.
Okay, thank you. I am guided, of course, by our rules of procedure that deal with discovery, Rule 3.220, B1B specifically, but also case law as expounded upon by our appellate courts that set a precedent. And the Florida Supreme Court has stated that unlike a failure to name a witness, changed testimony does not rise to the level of a discovery violation and will not support a motion for a Richardson hearing. And I'll cite to you the case of State versus Evans, 770 Southern 2nd, and that's at 1178. But if this were a Richardson violation, I would further make the finding that I don't find it to be willful, I don't find it to be substantial, and I don't find it to have a prejudicial effect on preparation. A witness who comes in to make a different statement than he or she has made previously is subject to impeachment, which you successfully did with the use of your deposition, as with any witness. But more critically, this isn't focusing on the substantive nature so much of the violation, but the procedural nature of the violation. This is a discovery procedural rule. And under our rules of procedure 3.220 B1B, the Florida Supreme Court has also advised, and the specific language in the rule does not require the disclosure of an oral statement when such a statement has not been reduced to writing or recorded in any manner prescribed by the rule. And this witness's oral statements to the state attorney in preparation for trial, as all witnesses meet with attorneys every time they prepare for trial, there is nothing at all improper about that. And in fact, I will be advising the jury that there's nothing improper about that, is not subject to disclosure since it was not recorded, as I understand, not recorded or transcribed in any way. Is that correct?
Yes, Judge.
Okay. It was a pretrial prep meeting a week ago where he looked at this exhibit and estimated, well, of course, he knows his own height and told us what his height was and gave his explanation or estimation as to height. So I'm not going to find a Richardson violation. I'm not going to strike the testimony. But I think the record is made on behalf of the defense, and that's my ruling. So other than that, are we ready to bring the jury in and move on?
One thing I wanted to bring to the court's attention, I've let one of the counsels know, I didn't let Ms. Schlach know, she wasn't in here. I guess, well, two things. One is, in the break, the state of Florida became aware of some of the jurors' faces on live stream.
The court has become aware of that as well. We have talked to the cameraman. He is aware that the jurors' faces shall not be filmed. The streaming, we do have a 2-minute delay, so we were able to take it down off YouTube, take it down off Law and Crime Network, take it down off other news video clips, but I want to once again reiterate that the jurors' faces should absolutely not be filmed. Okay? Let me get a thumbs up from the cameraman. Thank you so much.
I'm not sure which jurors it was.
It was these two right here. Yes.
Okay, I just want to make sure the court was aware. Another thing is I had a very incredibly brief interaction with the juror when I was walking into the courtroom. He wanted to know how to get into the courtroom. I told him I didn't know, I would check. And
How to get into this courtroom?
he was waiting in the hallway by himself, and so he didn't know how. So
Okay.
I just walked by, and now to answer him, I said, I don't know, I'll check. bailiffs without.
So he was trying to get into this door?
Trying to get to the juror, correct.
So this,
Or the exit.
okay, I see.
He was in the hallway out in front of the courtroom.
Understood.
Back into the jury.
Okay.
Honor, just a request moving forward. I don't know if it was part of your instruction. It may not have been, but I know I've had it routinely. That they tell the jurors that in the event that you see one of the attorneys and they, walk away from you and don't speak to you, know that it's because I've instructed them not to. And I think that that's what the state should have done. Just, any interaction, even with a smile, a facial gesture, isn't a proper communication with the juror. It should have been head down, walk away.
Okay, I have instructed them, and I will instruct them again, if that would.
I'm not saying the jury, I'm asking the other attorneys that in the event that any juror tries to speak to them, that they, as an officer of the court, walk away with it.
Okay, I will ask all attorneys to not speak to the jurors and to walk away from the jurors. I will advise them again that that's what y'all are going to do because you've been instructed to do so by the court. But I've also instructed them on multiple occasions that they're not to approach you. And, it's human nature. It's holding the door open for Ms. Schlacks. I think one of them did on Monday. But I will once again remind them so that we don't have any issues with juror contact going forward.
I don't want to make it seem like the state got in trouble for that interaction.
No, understood.
Yeah, the court has done it before, certainly.
I will remind them again along with my other reminders and admonitions, so it'll be part of my usual warnings to the jury.
Your Honor, final request is an or tennis motion to compel. Officer Collins has made his own type material in this case. But that's all based on his own assessment. I had my opinion when he walked by of height. I don't believe that it's 6'4". I have him under subpoena. This is not something that I've done before, but I do want to have an accurate measurement of his height if he's saying that the person that he chased was around his height.
Okay, is this something we have to deal with right now? He's not the next witness, right?
No, this is on Collins.
Okay.
Who already testified, just putting it, I want to make sure that it's contemporaneous with
Okay.
everything else with Collins.
And what is it you want me to compel? Why don't, since it's not an issue at the moment, you can put it in a pleading in writing. I'll have the state respond, and then whatever it is you're wanting me to compel, I will address that and think about it and rule on it. But if it's not for any witness today, then I would ask let's hold off on that until it becomes an issue. Okay. Are we ready to bring the jury out?
Yes, Your Honor. Oh, wait, I'm sorry. Mr. Atkinson gets to speak. Go ahead.
Just to expedite the next couple of witnesses, I've shown defense counsel a series of photographs that we intend on introducing. I was going to introduce them now.
And that they're being stipulated to? All right, let me also say this, because one thing that happened in the last time when you stipulated to the series of pictures is in that both of my clerks here have to label them and sticker them and do this and do that. And that is also, no offense to you ladies, a little distracting. So this is all something that should be done either before court, at the beginning of the day, or at the end of the day, or during lunch recess, although they need their lunch breaks too, not during the testimony. I'm trying to reduce, eliminate, minimize as much disruption during testimony as I can, from doors opening and closing, people's phones ringing, talking and whispering. We need to not have that done in the middle of testimony. Okay, but that said, if there are items to be stipulated into, then tell me now what those are, and then I'll inquire of the defense.
On the safety list, it goes through 5C, and it's 73 through 107. Series of photographs around the sun hall.
So 73 through 97 are being stipulated to?
73 through 107.
Through 107, okay. Is that with the approval of Defendant Whitaker?
Yes, Your Honor.
And, thank you, and Defendant Robinson? Photos number 73 through 107. Okay, those will be marked into evidence by stipulation.
The next set, Judge, is states 5D through 6Q, which would come in as 108 through 147. It's a series of photographs from the Fountain Boulevard address.
Okay, and some of those exhibits have already actually been moved into evidence.
Some were used for Ms. Buckley earlier, these are the remainder.
Okay, then the remainder between 108 and, what number did you say? 176? 147. 147. 108 to 147. Any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No objection.
Okay, and those will be marked into evidence by stipulation.
The next set is for 7U through 7Y, which will come in from 177 to 181. It's a series of photographs from 7201 Arlington Expressway.
All right, those are 5 photographs. Any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson? Okay, those will be marked into evidence by stipulation.
Finally, Judge, states 10 in, I believe is 248. There's a map from 7201 Arlington Expressway.
10N?
Yes, ma'am. I think it was written in after.
Oh, I don't have that one. Okay.
248.
Wait, what number? My exhibit only goes up, my exhibit list only goes to 226. Oh, all right, well, okay. I'll want an updated exhibit list if possible, but any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
And this is 244 to 247? No, what numbers are these?
Just number 247.
Oh, just number 247, the map? Okay, got it. 247 will be moved into evidence by stipulation.
On one of the lists, it was 248, on the other, it's 247. For the record, the only thing we're introducing now is the map, not the cat.
All right, anything else we need to take up before we bring the jury out?
No, ma'am, not from the state.
No, Your Honor.
All right, very good. Then let's bring them out, please.
Judge, for the 2 crime scene detectives, can I inquire from here, from the evidence cart?
Yes, as long as you speak loudly and clearly into the microphone.
Yes, ma'am.
All right, thank you, ladies and gentlemen. You may take your seats. Okay. Well, while we wait for Mr. Whitaker's jury to come, I do want to inquire if during this lunch recess, any of you heard, watched, or listened to any newspaper, television, or radio stories that may have been printed or aired about this case? No? Okay, I see no hands raised. And has anyone attempted to speak to you or approach you in any way to provide you any information or any reason about this case? And I see no hands raised. All right, let me also remind you, ladies and gentlemen, that during the course of this entire trial this week and next week, of course, you're not to talk among yourselves. You're also not to speak to any witnesses who might be waiting outside the courtroom. You're not to speak to the attorneys about any subject matter whatsoever until your deliberations are complete. In fact, I have told the attorneys that they are not to engage with you at all. And so if they see you coming, they are going to turn around and go in the opposite direction. They're not going to talk to you. And that might seem rude and disrespectful, but I assure you that they are not being so. They are following this court's orders and their rules of professional conduct to have no contact with you until your deliberations are complete. So please, again, do not engage them in any conversation whatsoever, even on a topic as mundane as the weather. All right? I thank you for that. We will await Mr. Whitaker's jury. Who was asking? Okay.
Jury 9 in the courtroom.
All right, thank you, ladies and gentlemen. You may take your seats. And before we begin, let me just inquire of you all if during this 1-hour lunch recess, any of you read, watched, saw, listened to any news stories about this case. If so, please raise your hand. Okay, I see no hands raised. And did anyone approach you to speak to you or have anything to do with anything having to do about this case? If so, please raise your hand. Okay, and I see no hands raised. Thank you. Lastly, I do just want to remind the jurors that as you come and go and during lunch recesses or end of the day recesses or any recesses where you exit the courtroom or the court jury room, you're not to speak to any witnesses who might be waiting outside the courtroom doors. You're not to speak or engage with the attorneys should you see them in the hallways and the elevators or in the lunch spots. They are not going to be able to speak to you about anything at all. In fact, if they see you coming, they're going to turn and go in the opposite direction, or if you get on an elevator that they're on, they're going to get off of it. And that might seem rude or disrespectful, but I assure you they are simply following this court's orders and their rules of professional conduct that they are to have no contact with you whatsoever until this case is completed. So please do not engage them in any conversation whatsoever. All right? So with that, I will call upon the state to call its next witness.
The state would call Detective Dunn.
Detective Dunn, please. And Mr. Atkinson, and for all the lawyers, a request has been made by the jurors for you all to speak closely, clearly, and loudly into the microphones. All right, Detective, if you'll come forward and be sworn. Yes, if you'll have a seat in that chair, please speak closely, clearly, and loudly into that microphone.
Good afternoon.
You may proceed.
Thank you, Judge. Good afternoon, ma'am. Will you please introduce yourself to the jury?
Yes, my name is Noelle Dunn, and I'm a retired crime scene detective with the Jacksonville Sheriff's Office.
Okay. How long were you a crime scene detective with the Jacksonville Sheriff's Office?
I was a crime scene detective for a little over 19 years, and I was with JSO for almost 26 years.
At the time that you retired and back in 2020, were you what is called major case certified?
Yes, I was.
Can you explain to the jury what that means?
Basically, it means that I've undergone additional training where I'm able to handle homicides and also other advanced types of crime scenes, such as officer-involved crime scenes, successfully. And it also means that I've gone through additional training. For example, I've had multiple classes in advanced crime scene investigation techniques, including a certificate of proficiency from the Institute of Police Technology and Management, which involved over 180 hours of crime scene processing techniques.
Ma'am, I want to draw your attention to January the 15th of 2020. On that day, were you dispatched to 7001 Merrill Road?
Yes, I was.
Is that in Duval County?
Yes, it is.
When you arrived on scene, your role in this case, you've said, is as a crime scene detective.
Yes, that's correct.
And when you arrived, was the scene secured?
Yes, it was.
Can you explain to the jury what that means and why that's important?
Basically, when they talk about scene security, it just basically means that the officers that responded initially have used crime scene tape to rope off the scene where people cannot just walk into your scene.
And can you explain to the jury what your role is as a crime scene detective when you arrive on a scene like this?
So basically, when I arrive on a scene, I meet with either the officers or the detectives if they're already there, and I get a synopsis of what's going on, and so I am able to better understand how to go ahead and proceed and start processing the crime scene.
What does it mean to process a crime scene? What are your responsibilities there?
So generally, it's any kind of documentation and evidence collection at the crime scene, and that can include photography, evidence collection, and any kind of measurements that are necessary.
When you are taking photographs of a scene, do you often take photographs to try to give perspective of where items are?
Yes, I do. I take overall photographs of the entire scene, and then I also take close-up photographs of the evidence.
And the jury's going to see in a little bit, but in some of the photographs, we can see what are called evidence placards, right?
Yes, that's correct.
Okay. Importantly, they're numbered. Are you giving any kind of order of sequence or chronological order to the evidence that you're finding, or is that the order that you found things as you're processing the scene?
So generally, the crime scene placards, even though they display a number, they don't refer to a chronological order, either the chronological order that it occurred during the crime. It actually refers to the order that I do see it when I come across it during my investigation.
Your Honor, permission to publish a series of photographs that have already been introduced into evidence.
Yes.
Ma'am, can you see on your screen where it says 7001 Merrill Road?
Yes, I do.
I'm showing you states 1. Can you explain to the jury what's going on in this photograph?
Yes, that's a view from Merrill Road looking north to the shopping center, and that's basically the entrance to the shopping center off of Merrill Road.
States 2.
So that's another view. That's inside the shopping center area in the parking lot, and that's a view of the businesses. That's looking at like the south wall of the businesses.
States 3.
That's a view of the Express Employment Professionals business. That's the east wall of the business, looking at it from the parking lot.
Okay. So just as a reference from states 2, you're kind of over here for stage 3. Is that fair?
Yes.
And then in stage 3, it's looking back towards where you were in stage 2.
Yes, that's correct.
States 4, just further down that wall.
Yes, it is.
And we can see the victim there on the ground.
Yes.
Going further down that same wall, states 5.
Yes, it is.
In stage 6.
That's another view of the shopping center going across.
State 7, what do we see here?
So that's a slightly closer view of the Express Employment Professionals business, and you can see the damage to the south glass window.
States 8.
That's also a closer view of the glass on the south wall.
States 9.
That's a view from the inside of the business looking back out. It's that same glass wall.
And states 10.
That's the east side of the window that's on the wall there in the same business, the Express Employment Professionals.
Okay. And you can see it in the photograph, but you can see that the blinds are down in some of these photographs, states 9. Did you have any difficulty seeing out the blinds?
No.
States 11.
That's a view of the east window, sort of looking back to the south window.
States 12.
That's a view out in the parking lot showing evidence number 9 and the victim's vehicle.
And when you take overall photographs, do you progressively take closer and closer photographs of the evidence out of placard?
Yes, I do.
So in states 13, we can see placard number 9?
Yes.
And what is that?
That was a casing that was recovered from the parking lot to the south of the victim's vehicle, and it was an unknown caliber casing.
States 14.
That's a close-up photograph of that same casing. It's showing the head stamp of the casing.
And that's here.
Yes.
States 15.
So that's an overview of the east side of the shopping plaza. It's showing some of the evidence placards that were labeling individual pieces of evidence, and also you can see the greater scene, including the victim.
States 16.
That's another view, the same view of the shopping center from a slightly different angle, again showing the evidence placards and also showing the victim and some of the other evidence.
States 17.
That's a view looking towards the south. It's the same general area showing the evidence placards and also the victim.
States 18.
That's a closer view, also looking to the south. It's showing the victim on the sidewalk in front of the shopping plaza and also the location of placarded items of evidence.
Okay. And in this photograph, we can see, I'm circling it, but for the record, it's kind of a white box with orange on it and then some other material here. Can you explain to the jury what that is?
Yes, there was a medical business that was close by, the Baptist Health. And when this incident happened, the people used their medical supplies to attempt to treat the victim for his injuries. And they left those behind.
States 19.
That's evidence placard number 1 showing casing.
States 20.
That's a close-up of the same casing, and it's showing the head stamp of the casing.
States 21.
That's evidence number 2 with another casing.
States 22.
That's evidence number 3 with another casing.
States 23.
That's evidence 4 with another casing.
States 24.
That's evidence 5 with another casing.
States 25.
That's evidence 6 with another casing.
States 26.
That's evidence 7 with another casing.
And I know that in this series of photographs, we're not seeing the head stamps with the firing pin impression, but these are all fired rounds.
That is correct.
States 27.
That's evidence number 8 with another unknown caliber casing.
States 28. What do we see here?
That's an overview of the victim, basically showing the immediate area and the medical supplies and the condition of the victim when we found him during our investigation.
Okay, and coming down kind of slightly from the victim's waist, this item on the ground, did you ultimately find bullet strikes into the concrete?
Yes, we did.
States 29.
That's a close-up photo of the victim. It's showing the belt at his waist, and it's showing that the belt was severed.
States 30.
That's the victim's cell phone that was in his pocket. It's showing that it was shattered.
States 31.
That's the front of the cell phone when we removed it from his pocket.
States 32.
This is an overview of the lower part of the victim's body. It's also showing some of the condition of the victim's body when we found it during our investigation.
States 33.
That's a close-up of the victim's right leg. It's showing the damage that we observed during our investigation.
States 34.
Those are items that were recovered from the victim's pocket during our investigation.
States 35.
That's showing the victim's identification that was located in his wallet at the time of our investigation.
States 36.
That's the contents of the victim's wallet when we were doing our investigation.
States 37.
That was when I laid out the money, indicating how much money we recovered from the victim's wallet during our investigation.
States 38.
That's another view of the sidewalk and the evidence looking towards the north.
States 39.
That's an example of some of the paperwork that we recovered around the victim at the time of our investigation.
States 40.
That's another example of paperwork that we located around the victim.
States 41.
That is also additional paperwork that we located around the victim.
States 42.
That is another paper that we located by the victim.
States 43.
Those are also papers that we located on the ground by the victim.
States 44.
Those are additional papers that we located on the ground by the victim.
States 45.
That's another view looking towards the north. It's showing the evidence that has the placard labels on them and also the condition of the victim's body.
And States 46.
That's evidence 10. It was an unknown fragment that we recovered.
States 47.
So that's showing the east wall of the Baptist Health Building, and it's showing where we labeled some bullet defects to the metal molding and also to the glass that we located, and it was to the north of where we observed the victim.
Okay. And I'm circling kind of right in the middle of the picture below the tape. Is that what you're referencing?
Yes.
And you said that anytime that you find suspected bullet strikes to buildings, you will label those.
Yes, that's correct.
Same kind of question as the placards. Are you giving an order of sequencing or just the order that you found them in?
No, we're not sequencing it. We're just basically documenting it in the order that we actually do find it.
States 48.
That's a closer view. It's showing that metal molding, and it's showing some of the labels that we put on it, showing the bullet defect to the actual metal molding and then also to the glass nearby.
States 49.
That's a close-up of the bullet defect to the metal molding that we labeled as B1.
States 42, or sorry, states 50.
That's the other corresponding side of the metal molding, and that we labeled as B2.
States 51.
And then that's the final area where it shows a bullet defect to the glass that we labeled as B3.
States 52.
That's an overview of the east wall of that shopping plaza, and it's showing the evidence placards, and it's showing the location of the victim's body in perspective with the Baptist primary care area.
States 53.
So that's showing, if you look at the planner on the right-hand side, at the base of the planner, we located another bullet defect, and that's also labeled there.
Okay. Is that what I've circled on the screen there?
Yes.
For the record, it's at the base of the concrete planter. States 54.
So you can see the planter in the left-hand side of the photo, and then also that's showing basically the south wall of the rest of the plaza as an overview.
States 55.
That's a close-up of the bullet defect that we labeled at the base of the planter.
States 56.
That's evidence 11, which was an unknown fragment that we located at the scene.
States 57.
So that's an overview of the east wall of the shopping plaza. Again, it's just showing the evidence placards, and it's showing the perspective and how they're related to each other.
And states 58.
That's an unknown casing, and it was evidence number 12.
States 59.
So that's a view of the shopping center looking towards the north, and it's also showing the relationship of the different items of evidence to each other at the scene.
States 60.
That's evidence number 14, and it's an unknown caliber casing.
States 61. What is the focus of this photograph?
So that's another close-up of the right side of the victim's body, and you can see the fact that the belt was severed, illustrated in that photo.
Okay. And I'm circling a couple of items on the screen. Can you tell the jury what those items are? Just for the record, they're like a cone-shaped item. Below is underwear and a couple of other metal pieces.
Yes. So we located several fragments by and under the victim's body, and the specific cone-shaped fragment appeared to be consistent with the tip from a rifle round.
States 62.
That's a closer-up photo of the object that we were just describing, the unknown fragment that appeared to be consistent with the tip of a rifle round.
States 63.
That's documenting the right hip of the victim, showing a wound that we observed at the time of our investigation.
States 64.
That's a bullet defect into the concrete by the victim.
States 65.
That's showing the victim's body was moved after the medical examiner got there and started their investigation. It's showing fragments that were located under the victim.
States 66.
That's another unknown fragment that was located in the area.
And 67.
That is also illustrating some more unknown fragments that were located in that area.
States 68. Can you explain what the yellow items that you place on the ground are that I've circled?
Yes, so after the victim's body was removed, there were bullet defects into the concrete, and the yellow markers are labeling the bullet defects in the concrete.
69.
So that's basically Evans Placard A, and it's illustrating one of the defects that we located.
70.
That's Evans Placard B, and it's illustrating another defect that we located.
71.
That's another overview of that same area where the victim's body was, and it's showing a third Evans Placard C.
And 72.
That's a close-up of Evans Placard C, which was a bullet defect into the concrete.
And the physical evidence that you collect as you are processing the scene, do you collect those items and place them into the property room?
Yes, I do.
Do you yourself do any forensic testing on those items?
No, I do not.
Your Honor, permission to approach the witness?
Yes.
Ma'am, I'm showing you what's been introduced, or what's been identifying the state's 8T for identification purposes. Do you recognize this item?
Yes, I do.
Can you explain to the jury what this item is?
So the part on the left are 10 unknown caliber casings, which are the evidence items that I placed in the property room. And then the one on the right is another unknown caliber casing.
Your Honor, this time the state will move into evidence which mark the state's 8T as state's 202.
Okay, any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, then 8T will be marked into evidence as State's Exhibit 202.
And I'm next showing you what's been marked as state's 8U for identification purposes. I'll ask you to look at that item. Can you tell the jury what that item is?
These are both unknown fragments. One was evidence number 10, and one was evidence number 11 that I collected at the scene.
Your Honor, this time the state will move what's been marked as state's 8U and state's 203 into evidence.
All right, any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, 8U shall be moved into evidence as State's Exhibit 203.
Finally, ma'am, I'm showing you what's been marked as 8V as in Victor. Take a look at that item.
I recognize this item.
What is that item?
They are two unknown fragments that were located on the ground under the victim.
All right, at this time, the state will move 8V as in Victor into evidence as state's 204.
Any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, then State's Exhibit 8V shall be moved into evidence as State's Exhibit number 204.
One moment, Your Honor.
Yes.
Thank you. I have no further questions.
Okay, any cross from Defendant Whitaker?
No, Your Honor. Thank you.
Any cross from Defendant Robinson?
No, Your Honor.
All right, may this witness be excused?
Yes, ma'am.
Okay. Thank you, Detective. You're excused and free to go.
Thank you, Your Honor.
All right, State, you may call your next witness.
State would call Detective Grant.
Grant?
Yes, ma'am.
All right, Detective Grant, please. Oh, okay. I was looking for her on the list. All right, Detective, if you'll come forward and be sworn. Yes. You'll have a seat right there. Be sure to speak closely and loudly into that microphone.
Good afternoon, ma'am. Can you please introduce yourself to the jury?
Yes, my name is Rebecca Grant, previously Rebecca Crosby.
Okay, and where are you currently employed?
I'm currently retired.
Retired from the Jacksonville Sheriff's Office?
Yes, I am.
When you retired, what was your assignment at the Jacksonville Sheriff's Office?
The crime scene unit,
How long were you with the crime scene unit?
8.5 years.
And were you also what is called major case certified?
Yes, I was.
I want to draw your attention to January the 15th of 2020. On that day, were you dispatched to 1033 Townsend Boulevard?
I was.
And while there, did you learn that you were asked to process both a vehicle that was nearby as well as a home located at that address?
Yes,
Were you working with another detective on that day?
I was. I was working with Detective James.
Your Honor, this time the state would would ask to publish what's been already admitted into evidence, a series of photographs.
All right, you may go ahead.
Ma'am, the jury's already heard kind of from Detective Dunn about what your procedure is when you arrive on scene, but is it any different when you're processing a scene that is outside versus a scene like a home?
No, when we get to the scene, we always speak with the detective on scene.
Get an understanding of what happened?
Yes,
And then take overall photographs as well as photographs of particular items.
correct.
So we'll start with the home. I'm showing you State's Exhibit 108. Can you explain to the jury what's in this photograph?
So this is overall photograph of the exterior of the house and also to show the house number.
State's 109.
A continued overall photograph of the house.
State's 110.
This is just an overall photograph of the front door.
State's 111.
And this would be an overall photograph of the right side of the residence.
State's 112.
Again, another angle of the residence.
113.
And this is the overall photograph of the left side of the residence.
114.
Photograph of the back porch.
115.
This is the sliding glass door.
State's 116.
This is the room that, when you enter the sliding glass door, that you come into.
State's 117.
Once you enter the sliding glass door, this is where we're showing that you continue to walk through the house.
118.
An overall photograph of another room in the house, the dining room area,
119.
of the kitchen.
120.
And this would be a photograph of the front door.
121.
Again, a picture of the front door.
122.
This is an overall photograph of a picture just showing the hallway.
123.
This would be the living room area before you enter into the hallway.
And if you're standing at 123 and you look out these windows, where does that lead you to?
That should be the front yard.
124.
This is the hallway.
125.
This would be a picture of the spare bedroom that's on to the right of the hallway.
126.
That would be the spare, inside the spare bedroom.
127.
Again, a picture of the hallway,
128.
showing me walking down the hallway.
129.
The closet in one of the bedrooms.
130.
This is the hallway picture showing should be a bathroom door to the left and another spare bedroom.
131.
And this was the bathroom in the hallway.
132.
Spare bedroom in the hallway.
In addition to photographing the house, were you also asked to take photographs of the resident of the house, Miss Barbara Buckley,
Yes.
showing you dates 133? Who is this?
This would be our victim, the homeowner.
Dates 134. What do we see here?
I was advised by detectives on scene that she had injuries, so this is photographing an injury to her neck.
135.
This is just a closer photograph of her injury with a scale, just kind of give it perspective.
136.
An injury to her wrist, her left wrist.
And 137.
Again, the same thing, just a scale just to give it perspective, the size of the injury.
Ultimately, are you going to take a swab of her neck and her wrist?
Yes.
States 138.
This is a photograph of her hands.
States 139.
This is showing that she has possible blood on her hand, her thumb.
And 140, is that what we're talking about?
Yes,
141, her hands again.
again.
142,
Just another injury to her right arm.
143,
Again, just with scale to show the perspective of the injury.
143, it should be 144.
This is an overall photograph of her pants, the back side of it.
It's what should be 145.
That's to show that there's possibly what we think is blood on her pants.
Okay. And when you suspect that there's possibly blood on an item like pants, is there something that you can do to test for that?
Yeah, so we take a sterile swab, we hydrate it with distilled water, and we swab the area in question, and then we conduct a hemodynamic test that once you stick it in that test kit, it will turn blue if it's a positive reaction.
It should be 146
Again, just showing the area that we're focused on.
and 147. Is that the hemodynamic test?
Yeah, so that would be the reaction that we got.
Ultimately, we talked about the fact that you did a swab of her neck and her wrist. I can have it on the time. I'm showing you this marked as State's Exhibit 9L for identification purposes. Can you tell me if you recognize that item?
Yes.
What is that item?
This would be the touch DNA swab that we took of her neck and her left wrist.
Your Honor, this time the state would move into evidence which is marked as 9L as 220.
Any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, 9L shall be marked into evidence as State's Exhibit 220.
Showing you it's been marked as 9K for identification purposes. Recognize that item?
Yes. These are two buccal swabs that we collected from Mrs. Buckley.
Can you explain to the jury what a buccal swab is and how you take it?
So a buccal swab is basically we take sterile swabs and we swipe the inside of the mouth, and it's basically a comparison swab of the DNA that we collect.
All right, this time the state will move into evidence which is marked as 9K as states 219.
Okay, any objection from Defendant Whitaker? Any objection from Defendant Robinson? All right, 9K will be moved into evidence as State's Exhibit 219.
Detective, ultimately, did you collect the shirt and pants from Ms. Buckley?
I did.
I can show you first what has been marked as Exhibit 10K. Recognize this item?
Yes.
And what is this item?
This was the shirt that was given to me on scene by Detective Richardson.
The shirt received the photograph?
Yes.
And state move this into evidence as states 244.
Okay, and any objection from Mr. Whitaker? Any objection from Mr. Robinson? All right. State's Exhibit, what exhibit is this?
244 now. It was identified as 10K.
10K, okay. 10K shall be moved into evidence as State's Exhibit 244.
States 10L.
Yes, those were the pants she was wearing.
Your Honor, the state will move into evidence which is marked as states 10L as states 245.
Okay, any objection from Mr. Whitaker? Any objection from Mr. Robinson? All right, 10L shall be moved into evidence as State's Exhibit 245.
In addition to processing the home of Ms. Buckley, Detective, you were asked to process the crashed vehicle that was somewhat nearby.
Yes, I was.
I can have a moment. showing you State's Exhibit 73. What is State's Exhibit 73? Can you see that on your screen?
Yes.
What do we see in this photograph?
So this is the numeric of the residence the vehicle was located.
State 74,
Just an overall photograph of the area where the vehicle is located.
State 75,
Again, an overall photograph.
State 76,
This would be an overall photograph of the vehicle as we found it.
State 77,
Overall photograph of the vehicle and the damage.
State 78,
Overall photograph of the vehicle and the license plate.
State 79,
Another overall photograph of the vehicle.
State's 80,
And an overall photograph of the vehicle and the damage.
State's 81. What do we see in this photograph?
This is a picture showing that the gear shift is still in drive.
When you arrived on scene, was the vehicle still turned on?
Yes,
Who turned the vehicle off?
I did.
State's 82. What do we see here?
So this is a photograph of the exterior looking inside the vehicle of what's in the driver's seat.
You said that at this point you're taking photographs from the exterior of the vehicle?
Correct.
You're still on scene at this point.
Yes.
Ultimately, are you going to have the vehicle towed to the JSO warehouse?
Yes, we are.
And what's the point of doing that?
To have a more secure location and then also to get the search warrant.
When you move a vehicle from one scene to the warehouse, is there something you do to secure the vehicle to make sure that it's not tampered with?
Yes, so we seal the vehicle, all points of entry, with evidence tape with our names, the date, and the report number.
All right, so State's 83,
So this is also an exterior picture looking in showing a rifle in the back seat.
and State's 84. We've now moved to the warehouse.
Yes, so this is our warehouse, just showing an overall picture, trying to document that the seals are still placed.
Okay, and I'm circling kind of in the middle of the screen, a blue sticker on the hood of the car. Is that what you're referencing?
Yes.
Were any of the seals tampered with?
No.
State's 85,
Again, to show the seals were still in place.
State's 86,
This would be an overall photograph of us, of the interior of the vehicle.
State's 87,
Overall photograph of what we found in the driver's seat.
State's 88. What is that?
It was a white T-shirt,
State's 89.
and this is to show the make and size of the T-shirt.
This is the one that's in the front seat.
I'm not sure which one this is.
State's 90,
This would just to show overall photograph of the glove box area in the center console.
and ultimately you're taking your photographs in series.
Yes.
State's 91,
This is an overall photograph of the left rear passenger area.
State's
Or,
92. I'm sorry.
Sorry, right rear.
State's 92,
Again, overall photograph.
State's 93,
Overall photograph of the area.
State's 94,
And this would be the overall photograph of the other T-shirt.
State's 95,
An overall photograph of then the left side of the vehicle.
State's 96,
This is the overall photograph of the trunk of the vehicle.
State's 97,
This is an overall photograph of the Glock that we collected in the driver's seat.
State's 98,
This is to document the identification of the gun that we located.
State's 99,
This is to show that there was an actual live round that was in the chamber of the gun.
State's 100,
This is the live round next to the magazine of the gun,
State's 101,
and that would be the live rounds located in the magazine of the gun.
State's 102,
Overall photograph of the rifle that we found.
State's 103,
This is to document that the rifle was actually in fire mode and not safe.
State's 104,
This would be the live round that was located in the chamber of the rifle.
State's 105,
This is to show the stamp head of the live round.
State's 106,
Again, this is identifying the type of rifle it is.
and State's 107.
And these are the live rounds that were located in the magazine of the rifle.
In addition to photographing and collecting evidence from inside the vehicle, do you also take swabs of the compartments of the vehicle?
Correct.
Can you explain how that's done?
So it's the same process. We take a sterile swab and we hydrate it with distilled water, and we break down the vehicle in 4 compartments. And those 4 compartments would be the driver's side, the left rear side, the front passenger side, and the right rear passenger side.
And how do you divide up the passenger side from the driver's side?
So we tend to swab, for example, the driver's side, we swab areas that are common for a driver to touch, such as steering wheel, gear shift, door handle, those type of areas.
That also include the center console of the vehicle.
Yeah, so we would split those in half and do one side here and then one side on the other side.
Understood. If I can have a moment. Showing you what's been marked as states 9M for identification purposes. Can you take a look at that?
Yes,
What is that item?
it would be a touch DNA swab of the driver's compartment.
This is the one that you performed and just explained?
Yes.
At this time, the state will move into evidence we mark as states 9M as states 221.
Any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, the 9M shall be moved into evidence as State's Exhibit 221.
Next, showing you what's been marked as states exhibit 9B. Take a look at that item. First, the brown bag that I've just kind of pulled out of the side. Could you explain what the brown bag is?
It's basically a way to, the item, to collect the item without contaminating the item.
And this is what goes into the property room?
Yes.
And on the brown bag, do you write what is inside of the bag?
Yes, we do.
First, can you take a look at this item on the bag?
Yes.
Can you recognize this item?
Yes, it's the white T-shirt collected from the driver seat.
Your Honor, this time the state will move into evidence which is marked as states 9B as states 210.
All right, any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No, Your Honor.
All right, 9B shall be moved into evidence as States 210.
Next, showing you what's been marked as states 9C, as well as the bag. Tell the jury you recognize this item.
Yes, so this is the white T-shirt that was in the rear back seat in the middle.
Your Honor, this time the state will move into evidence which is marked as states 9C and states 211.
All right, any objection from Mr. Whitaker? Any objection from Mr. Robinson?
No, Your Honor.
All right, 9C shall be marked into evidence as States 211.
Your Honor, the next exhibit states 8Z, which is a rifle. I believe it's been cleared by the bailiffs.
Okay.
And we're showing you what's been marked as states exhibit 8Z. You recognize this item.
Yes.
What is this item?
That would be the rifle located in the back seat.
Your Honor, at this time the state will move into evidence which is marked as states 8Z as states 280.
Okay, any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No, Your Honor.
All right, States 8Z shall be marked into evidence as number 208.
Just quick permission to publish, Your Honor.
Okay.
those are the live rounds located in the rifle.
The rifle that we just saw?
Yes.
Evidence what's been marked as 9A, it states 209.
Any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, then Exhibit 9A shall be marked into evidence as 209.
When you collect an item like a rifle, you process it or you swab it for potential DNA.
Yes, we do.
Can you explain how that's done?
So again, the same process, take a sterile swab, hydrate it with distilled water, and then we swab the areas rough, like with a rough exterior. Usually it could be the magazine, the slide, I mean, it's according to what type of gun it is.
Something like a smooth surface, like the slide of a handgun, can you swab that item and leave that for potential fingerprint examination?
So no, we wouldn't swab that. That would be for possible latent prints.
Showing you what's been marked as State's Exhibit 8W.
That would be the Glock that was located in the driver's seat.
Your Honor, the State will move into evidence what's been marked as State's Exhibit 8W as State's Exhibit 205.
Okay, any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No, Your Honor.
Okay, without objection, State's 8W will be marked into evidence as 205.
And the same thing with this, it's the rifle. You can swab with the same procedure.
Correct.
Smooth items available for examination.
Right.
Showing you what's been marked as State's 8Y and 8Z, sorry, 8X and 8Y. You look at these two items.
Yes.
What are these two items?
These would be the .40 caliber live rounds that were located in the handgun.
Your Honor, the State will move into evidence which will mark as 8X as State's 206 and State's 8Y as 207.
Okay, any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
Okay, so State's Exhibit 8X shall be marked into evidence as number 206, and State's Evidence XY shall be marked into evidence as State's 207.
Thank you, ma'am. I have no further questions.
All right, is there any cross from Defendant Whitaker?
A.
Ms. Sachs, do you need the photographs?
Yes, I need,
96, from the vehicle or the home?
yes, 96.
96.
Detective, just a few very brief questions. Did you make any effort in regards to this Altima? It would turn over, like when you got it to the police impound yard, were you able to crank up the engine again?
We don't crank it up again.
I've seen in past cases, was there any effort made to determine if anyone had ever connected a cell phone to the car? You know, with Apple Play, CarPlay, anything like that?
Not to my knowledge.
Then in regards to what's now been stipulated as State's 96, did you do any kind of fingerprint analysis on this item?
I did not.
Once you take all of your photographs, those are automatically forwarded to the lead detective in the case, correct?
Well, it's sent off to our print lab, who then, he has to get a copy through them.
Okay, because obviously that's something the lead detective is going to do. That's why you make every effort to meet with either the lead or one of the detectives so that you can kind of determine where should I be focusing on, correct? And you make sure that your reports and really the Jacksonville Sheriff's Office does it, correct? They make sure that all of your reports and all of your photos are readily accessible to those detectives because they kind of have the bigger picture, right?
Correct, they have access to those, yes.
And of course, that was done in this case.
Yes.
I don't have anything further, Your Honor. Thanks.
All right, any cross for Mr. Robinson?
Briefly, Your Honor, yes. Good afternoon, how are you?
Okay, good.
So, question with respect to the swabbing of the interior of the vehicle, okay? You were saying that you use one swab per compartment?
Yes,
All right, so for instance, if you're in the driver's seat, you're going to use one swab for the steering wheel, the seat belt buckle, the center console. Is that the way that it's done?
correct.
All right. Does that lead to the potential of combining DNA? If you have two contributors, one on the steering wheel, one on the seat belt, would that create a mixture?
Possibly, but it's a better proponent to collect more DNA with one swab.
I'm sorry?
It's a better to be able to collect more DNA with one swab in one compartment area, yes.
One moment, Your Honor.
Okay.
Nothing further. Thank you, ma'am.
All right, is there any redirect?
No, ma'am.
May this witness be excused?
Yes, ma'am.
All right, thank you, Detective. You're excused and free to go.
Thank you.
Your Honor, can we take a short recess to confer with which witnesses we have available for the rest of the afternoon? Oh, okay.
Ready? All right, call your next witness.
Emily, Anna here.
I'm sorry, who?
Emily, Anna here from Florida Department of Law Enforcement.
Okay, thank you. All right, ma'am, if you'll come forward and be sworn. All right, if you'll be certain to speak closely and loudly into that microphone, thank you.
May it please the court.
Yes.
Good afternoon. Please introduce yourself to these two juries.
Yes, my name is Emily Amhere. The first name is spelled E-M-I-L-E-E, and the last name A-M-I-H-E-R-E.
And ma'am, I'm going to ask you to just pull that microphone a little bit closer to you to make sure everyone hears you. You got to project with two juries here. Thank you. What do you do for a living, ma'am?
I'm currently employed at the Florida Department of Law Enforcement in the Jacksonville Regional Operations Center as a crime laboratory analyst in the firearms section.
How long have you been so employed?
I've been with the department in total a little over 12 years now.
And how long have you been in the firearms unit?
I've been in firearms for approximately 10 years or so, in the last 8.5 or so as a qualified analyst.
So give the juries an idea of how you came to get this job, your training and experience, and then what you do at the Florida Department of Law Enforcement.
So I have a bachelor's degree from the University of Florida, as well as a master's degree in crime scene investigation forensic science from the George Washington University as my educational background. And then at the Florida Department of Law Enforcement, I completed their in-house training program, which is approximately 16 to 17 months for crime laboratory analysts in the firearms section.
Do you receive training once you're hired by the Florida Department of Law Enforcement that helps you perform the duties that you're here to testify about?
Yes.
And describe that a little bit for the jury.
So the training program for crime laboratory analysts in the firearms section, again, is approximately for me was about 16 to 17 months, which includes 2 phases. And those are going to include academic study and experimental and comparative study of all the subject matter that a crime laboratory analyst will encounter in independent casework. So these would be things like history of firearms and ammunition, working mechanisms of firearms, how to disassemble and compare fired components, usually bullets and cartridge cases, but also including shot shell components that an analyst will encounter in casework. So again, the training occurs in 2 phases, and each phase will culminate in what's called an oral board examination, which is approximately 2 to 3 hours with the trainees training committee, which consists of all qualified analysts in the firearms section, and those have to be passed before you can move on to the next phase. The second phase is much like the first, but also includes a period of supervised casework, which is approximately 800 hours, which usually works out to about 5 to 6 months, where an analyst trainee will work cases under the supervision of a qualified analyst in the section. Once all of that is passed, and trainee will be given their mock case to work independently and testify to their findings in a moot court setting. And again, once all of that is passed, they'll be able to be signed off and authorized for independent casework in the firearms section.
So we've mentioned firearms. What are the types of things that you would testify to in a court using your training, education, and experience?
Primarily, the duty of a firearms examiner is to examine, microscopically compare fire components, usually bullets and cartridge cases, to each other if no gun is submitted in a case, or to a specific firearm if a particular gun is submitted in a case, to see if they were fired from the same source.
In addition to that comparison, when you're looking at fired components, are you also generally an expert in firearms generally?
Yes, I've been qualified as an expert, yes.
And approximately how many times have you come into courts like this and provided your opinion with regards to what you've just testified to?
Approximately over 50 times at trial, and then other depositions and hearings as well.
I would this time tender the witness is able to give her opinion in the field of firearms and the ballistic testing that she does.
Okay, is there any additional voir dire either defendant Whitaker or defendant Robinson wishes to conduct?
Can't argue that experience, Your Honor.
Okay, thank you. Go ahead, Mr. Mizrahi.
So let's explain a little bit. We mentioned FDLE. The jury hasn't met anyone from FDLE yet. What is the Florida Department of Law Enforcement, and how does it interact with the Jacksonville Sheriff's Office, the State Attorney's Office, things like that?
Very simply, the Florida Department of Law Enforcement encompasses a state law enforcement agency that has both the forensics and investigative side to aid local, county, and city law enforcement, in my particular case, in forensic services.
So you're in the firearms unit. Does the Florida Department of Law Enforcement also have a DNA unit?
Yes, they do.
And are those separate?
Yes, they are.
Okay, so you're not going to come and testify about DNA, and they're not going to come testify about firearms?
Yes, I have no training in DNA at all. All I do is firearms.
And I would now turn your attention. Do you have your case file with you?
Yes, sir.
And have you prepared for this testimony and reviewed it?
Yes.
If you ever need to refer to it, please feel free to do so. That's fine, okay?
Okay.
And that's going to be in your FDLE number 2020-04626?
Yes, sir.
And did you receive a series of items purported to be either things that came out of a firearm and then 2 firearms?
Yes, there were components as well as 2 firearms submitted in this case.
So I want to first talk about things that just ended up being inconclusive because we don't need to spend a lot of time on it. Did you receive a number of fragments of what was purported to be fired bullets?
Yes, there were numerous projectile evidence items in this case, including some fire bullets.
And were those of any value for you to compare to any firearms?
Specifically, several items were no value. I can name those if you'd like.
I don't think we need to. I think let's go to this. Is it common that when you have a projectile crash into concrete and walls that it gets so deformed that it's of no use for comparison?
Yes, that does happen.
Did you also receive a series of shell casings?
Yes, there were also cartridge cases submitted.
Explain to the jury the difference between these fragments / bullets and what a cartridge case is.
So very simply, a cartridge case is just the metal receptacle that holds all the components of unfired ammunition, otherwise known as cartridges. So those components are going to be the bullet, the cartridge case itself, the primer, and the gunpowder. So once a round is discharged in a firearm, those first components, the primer and the gunpowder, will be consumed by the detonation, and the bullet will use those products of that detonation from the primer and the gunpowder to be propelled down the barrel of a firearm. So that will leave the barrel of a firearm toward whatever the target was in the shot, and the cartridge case itself will be ejected from the firearm, usually in a semi-automatic fashion.
And so like in a revolver, those cartridge cases would remain in the firearm until they're somehow manually expelled.
Yes.
But in a semi-automatic or an automatic, they would automatically be expelled from the firearm.
Yes, sir.
In your training and experience, is it common to be able to match one shell casing to another shell casing to determine whether or not those two shell casings or cartridge casings were fired from the same firearm?
Yes, the comparison of cartridge cases to each other is an examination that I will perform quite often.
Are you able to link cartridge cases to bullets that go down the barrel?
So cartridge cases and bullets that are expelled down the barrel of a firearm will be two separate components. So comparing the cartridge case to the bullet that has been fired is not an examination that we can practically do, because the marks from the inside of the cartridge case will be obliterated, that will be on the bullet would be obliterated by its travel down the barrel. So the only thing that we can do is compare cartridge cases to cartridge cases and bullets to bullets.
Are you also able to do bullets and cartridge cases to firearms that you have?
Yes.
Okay, and you did that in this case?
Yes, that was the request.
Are you also able to test the functionality of any firearms that you received?
Yes.
All right, so let's quickly go through the various items that you did, and we're going to begin with the cartridge cases. May I approach the witness, Your Honor?
Yes.
And these have already been introduced into evidence. Showing you what's been here into evidence, it states there 202. Do you see that?
Yes, sir.
And how do you recognize it?
If I may. By the unique FDLE case number, the item number on the packaging, as well as on the cartridge cases.
Is it the yellow sticker?
Yes, the yellow label on each of these packages is from FDLE, and those items will be affixed with those labels as soon as they are submitted to the laboratory.
Okay, so we see a series of, I guess, 10 cartridge casings in one, and then one cartridge casing in another, and they have separate numbers. One is number 24, and then one is number 1. Can you see that on there?
Yes.
Why are they separate?
Because those were two separate numbered items that were submitted.
Were you able to do a comparison of all these shell casings to each other?
Yes.
And what were your findings?
I came to the opinion in the comparison of these two cartridge case items, the total of 11, that they were identified as having been fired in the same firearm.
During the course of your examination, were there any cartridge casings that did not match these 11 cartridge cases?
No, again, the item identification opinion was for those cartridge cases to each other.
I'm showing you what's been entered into evidence. It states 205. Let's see if we find your sticker. Do you see that?
Yes, sir.
And did you examine this rifle?
Yes.
Are the cartridge cases that we just talked about, could they possibly have been fired from this rifle?
Since the rifle and the cartridge cases that were submitted in items 1 and 24 were of the same caliber, they could have been fired in that firearm, which is why I had to compare tests from that rifle to the cartridge cases that were submitted.
For example, if the only firearm that you received was the .40 caliber, you wouldn't even have done the comparison because there's no way those cartridge casings could have been fired from a .40 caliber handgun.
Yes, that's true. That's what we would call an elimination on class characteristics, the class characteristic being the caliber.
So when you did the comparison, were the cartridge cases fired from the rifle?
I came to the opinion that they were not. So that was an elimination opinion of the item 1 and 24 cartridge cases as with respect to that rifle.
Was the rifle operational?
Yes, it was functional at the time of my examination.
And you actually did a test fire?
Yes, I did.
Likewise, did you have any cartridge casings to examine and compare to State's Exhibit 205, the .40 caliber? I guess you need to look at that as well. May I just approach freely?
Yes.
Yes, I examined that firearm, and there were no .40 S&W caliber cartridge cases submitted to me with these items.
Was that firearm, the .40 caliber, functional?
Yes, it was.
Did the laser sight on the gun work?
At the time of my examination, I found it to be non-functional.
I also want to show what's been pre-marked as State's Exhibit 9D. Did you examine one bullet that was potentially able to be made a comparison to the
Yes, I examined this bullet.
And why did you begin the examination? Was it because there was characteristics on it that you could potentially match?
Yes, the first part of any examination is judging the suitability of the item, whether there are any marks that could be compared to anything at all. And I found this item to be somewhat suitable for comparison, which is why I ended up comparing it in this case.
And did you note that that had come from the medical examiner's office?
The envelope and the packaging that was submitted to me did state that.
And what did you notice about this fired bullet?
As far as the conclusion?
Well, yeah, what were the characteristics of it? What was the conclusion?
So the characteristics as far as the caliber class, I found from the measurement and size of the bullets that I took that the bullet was 22/5 millimeter caliber class.
And were you able to link that bullet to any of the firearms that you examined?
No, my opinion was inconclusive based upon the examination of the bullet to the rifle in this case.
And you already previously testified how you don't compare bullets to cartridge casings, but is it consistent with the cartridge casings, this bullet?
So the caliber class of the bullet, 22/5 millimeter caliber class, would be consistent with the caliber of the cartridge cases, which was 223 Remington /5.56 millimeter NATO caliber cartridge cases.
There may be later evidence in this case about an XTAR EXP 556 MK1. Were you asked to do some research on that type of firearm?
Yes.
And that type of firearm, can you describe it for the jury?
So it's an AR style pistol, just the general description of the type of firearm made by a company that is now discontinued called XTAR, and that is a same caliber 223 Remington /556 NATO caliber that is similar to the rifle here in this case as far as the caliber.
Okay, so you're not, obviously you didn't get one of those guns to compare,
No, I did not.
and you can't make any comparison about whether the cartridge casings and or the fire projectile came from that type of gun. Is that fair?
No, I couldn't. I would need to see the item.
But is it possible that they did?
Just based on the class characteristics, that being the caliber, that they are similar, that would be a comparison I would have to do if the item were ever submitted.
But unlike the .40, which you can immediately rule out, that type of firearm could fire what we have in this case.
Yes, the XTAR 556 could fire a 223 Remington 556 caliber round.
Thank you. That's all. Well, let me move into evidence if there's no objection from counsel's 9D into evidence as 212.
All right, is there any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, we'll move States 9D into evidence as States 212. Okay, any cross from Defendant Whitaker?
Briefly, Your Honor. May I approach the witness?
Yes.
I'm doing well.
I'm going to ask you to take a look at 208. And you examined this?
Yes, again, my tag here with the FDLE case number, item number, and my initials, as well as on the firearm is there.
And when you receive a firearm like this, you may assume it's fireable, but you actually tested yourself to figure out if it's operational or not, correct?
Yes, all guns would need to be function tested and test fired to see if they're operational.
And this particular gun was in fact operational.
It was.
Now I'm going to show you the 205. Would you do the same with this firearm?
Yes, the examination for any firearm would generally be the same to test for functionality at the bench and then also attempt to test fire.
So if someone wanted to intend to shoot either one of these firearms, they absolutely could.
Yes, I found them to be functional at the time of my examination.
Okay, thank you. Cross for Defendant Robinson.
Please, Your Honor. Good afternoon. How are you?
Good afternoon.
It's good seeing you. You work with the Florida Department of Law Enforcement, correct?
Yes,
And that's referred to as FDLE.
yes,
You're a gun expert within FDLE,
yes, I work in the firearm section.
and you've testified as an expert on firearms dozens of times before, correct?
Yes, I've been qualified to do so.
Now, I'm not going to get into specifics here, so feel me on this question first. You make a salary through FDLE, right?
Yes, my salary is paid by the state.
Whether you're in here testifying on this case or you're back at FDLE testing items on another case, your pay is the same, right?
Yes, it is.
Meaning that you're different than a private contractor expert that's hired and paid specifically for their time and testimony on a case, right?
Yes,
Right. Now, you were asked a question about the X-Tar. What's the name of that gun?
I believe it's the EXP 556.
Now, you said that was a company that recently ceased to exist, right?
As I've researched it, it's been discontinued.
All right, so in 2020, that company was in existence, correct?
As far as I've researched.
And it was sometime in between then and now that they stopped producing the firearms, specifically the one that you just mentioned, right?
As I research, yes.
All right. If a company were to go bankrupt, cease to operate, and stop manufacturing the guns, would that then make the gun rare?
I don't know exactly how many they sold or how rare the firearm might be.
All right. Now, you as the firearm expert working for law enforcement, did the government ever come to you and show you a photograph of a third firearm and ask you as the firearm expert to identify that gun?
Identify the gun from the photograph.
Correct.
I was showed a photograph during a pretrial as far as a model that they wanted me to look at, and that was it.
And they never, the pretrial was before charges were filed back in 2020?
It was just recently this year before testimony in this case.
One moment, Your Honor.
Okay.
Nothing further, Your Honor. Thank you, ma'am.
All right, is there any redirect?
No, Your Honor.
May this witness be excused? All right, thank you, ma'am. You may step down and you are excused and free to go.
Thank you.
We have another shorter witness.
We have a civilian, and we have the FDLE people are still here, but we're going to take a civilian real quick.
Okay, and it's a short witness? Okay, it's just for the jury, so we'll do this one witness and then we'll take an afternoon recess. Just wanted to get the timing of it all. So state you call your next witness.
This David call Miss Renada Boston.
All right, Ms. Boston, please. right, ma'am, if you'll come forward and be sworn. No, all the way up here. Thank you. All right, and be sure to sit up close to that microphone and speak loudly and clearly into it. Thank you. You may proceed.
Thank you, Your Honor. Ma'am, will you please introduce yourself to the jury?
My name is Renada Boston.
All right, can you sit up a little closer to the microphone? Thank you. Or you can pull the microphone closer to you.
Ms. Boston, do you live in Jacksonville?
Yes,
How long have you lived in Jacksonville?
my whole life.
I want to draw your attention to January of 2020. Back in 2020, where were you living?
In Lake Chateau.
Okay, and that's an apartment complex?
Yes,
And is that at 7201 Arlington Road?
yes,
Do you remember a day back in 2020 in January where there was heavy police involvement, contact out in the area?
yes,
And you were getting notification alerts on your phone?
yes,
I'm showing you what's been marked as states 248. Do you see that on your screen?
yes.
And ma'am, can you, by touching the screen, show the jury where you were on that day, approximately?
Here.
Okay. And for the record, you've kind of drawn it in between where it says 7201 and another building, 7201, and there's kind of a white truck and a gray car there?
Yes,
And at some point during the day, were you outside talking with your neighbors on what you call the wall?
yes.
Can you explain to the jury what the wall is?
When I come out my apartment, it's a set of stairs, and on the stairs, it's connected to a wall, and you can sit there.
Okay, you can kind of see it on the map there.
Yes,
And I'm showing you States Exhibit 180. Sorry, is that a fair representation of the wall?
yes,
Okay, and you said you have to come up a set of stairs to get out from the apartments?
yes.
Do you remember what time of day it was that all of this was going on?
It was like, late in the morning, early afternoon.
Okay. Now, where the wall sits, is it, when it butts up to grass, is it just where the sidewalk ends and the grass starts, or is there an elevation difference?
It's elevation difference.
Okay, so it's not sitting straight up, but there's some difference. And what is higher, the grass or the wall?
The wall is higher,
Okay. How much is the wall higher than the grass?
a few inches.
A few inches?
Like a few feet.
A few feet. Okay, so if I start with my hands where they're equal, I'm going to kind of demonstrate, and you tell me when to stop, approximately when you think that it is, okay?
Like that's,
About there?
yes,
Okay, and how much would you estimate that is, just kind of looking at it?
probably like a feet or two.
A foot or two? At some point while you're standing there, do you hear something from behind you in the woods?
Yes,
And going back to the map, you said that you're about here. Is this the woods here where I'm drawing on the map?
yes.
And what is it that you hear?
We were talking and I heard like scrubbling, like a sound, like a trash bag kind of rattling sound, like leaves.
Okay, like a rustling of leaves?
Yes,
All right. At some time around the time that you hear that noise, do you see something else that draws your attention?
yes.
And what is that?
A car
Okay.
approaching us, like coming the way we were sitting.
And what was significant about the car?
It was a lady driving, holding a cell phone. She looked lost, like she was looking for something.
Okay. Do you remember what she looked like?
Yes,
Remember what race she was?
yes.
What was she?
She was white.
Okay. Had you ever seen her before in that complex?
No,
And at that point, back in 2020, had you lived there for some time?
yes,
Kind of knew most of the people in the area?
yes,
You had never seen her before.
no.
Do you remember what kind of car she was driving?
Like a silver four-door sedan.
At some point after seeing the sedan, do you see somebody come out of the woods from behind you where I've drawn on the screen?
Like moments after the car had passed. I did.
And can you describe that person to the jury the best that you remember?
Just the build of the person.
Okay. About how tall did he appear to you?
Maybe like he was 5'8", 5'9".
Okay. What about his build?
He was slim.
You remember about how much you guessed that he weighed?
Maybe like 160, 170.
Did you get a view of his skin complexion?
Yes.
And how would you describe that?
But pecan brown.
Could you see his hair at all?
Yes.
What did that look like?
He had dreads.
And how long were his dreads?
It was to his chin.
Do you remember what he was wearing?
I remember the top.
Okay, what did that look like?
A gray hoodie.
How long do you think that you saw this person for?
Seconds.
And what did you do when you saw that person come from the woods?
I ran.
Okay. Did you ever see them again?
No.
Did you ever see what happened with the white woman in the silver sedan?
No.
Eventually, the police came out to the complex?
Yes.
And they spoke with you?
Yes.
Thank you, ma'am. I have no further questions.
All right, cross from Mr. Whitaker. All right, any cross from Mr. Robinson?
Squats, do you need these photographs at all?
Good afternoon, Ms. Boston.
Afternoon.
Okay, so this happened all the way back January 15th of 2020, right?
Correct.
You were living in that apartment complex at the time?
Yes.
And that apartment complex has cameras, right?
No.
It does not?
No.
You were sitting on that wall. You weren't sitting by yourself, were you?
No.
You were sitting with two other individuals, right?
3.
3 others. Okay, Claudia was one, right?
Yes.
Marva was one.
Yes.
And you're right, and Larry was the other one.
Correct.
Okay. They were all sitting on the wall where you were sitting.
Yes.
Were they all sitting there when the person came out of the woods?
Yes.
Okay, they saw him too?
No.
They didn't.
No.
How do you know?
Because we were all talking and I stood up. Like I had heard the sound 3 times and like my 3rd time hearing it, I stood up and turned around and the view was in the opening where I was sitting. They were sitting more so behind this building where they couldn't see what I saw.
Okay. But what you just stated was you were sitting on this wall, right?
Yes.
Okay. And I know that Mr. Atkinson got up here and talked to you about the fact that there's some elevation on the wall, right?
Yes.
And you can see that the State's Attorney's Office has pictures of the apartment complex, right?
Yes.
They could have easily taken a picture of the elevation that you described, right?
Right.
But you haven't seen one of those, have you?
Not.
Okay.
In this.
You do not know, you haven't yourself gone out and measured the height of that wall, have you?
No.
You didn't measure the level of that elevation, have you?
No.
Okay. And so you did mention, though, that you were first sitting down, and then after you heard that sound, you stood up, right?
Correct.
So you made that observation from a standing position, correct?
Correct.
Okay. And just to reiterate, the individual that you saw, male or female?
It was a male.
Okay. 5'8" to 5'9"?
Yes.
And you used the word slim, right?
Yes.
Okay. And the weight range you gave was 160 to 170 pounds.
Correct.
Okay, and I hate to do this, I don't normally ask people this, but for example, how much do you weigh now?
I weigh at like 180.
Okay. The description you gave as a skin color was butter pecan brown.
Correct.
Okay, and that's lighter than your complexion, correct?
Correct.
And now also you were able to take note of the fact that this individual was wearing a gray hoodie,
Yes.
but the hoodie was down.
Yes.
Okay. The individual's hair was down, correct?
It was just loose.
Loose, okay. But in dreadlocks is how you described it.
Yes.
Okay? And you said the length of the dreadlocks of that individual went down to their chin.
Yes.
Okay. The hood was not covering this individual's face, was it?
No.
Okay. The bottom of this individual's face wasn't covered, was it?
No.
And then you immediately said, now you see this person coming out. Did they have a firearm in their hands?
No.
Okay. And the reason that you took off running was what?
Before that, we had got an alert to the phone stating that a murder had happened and what the individual was wearing. So I was asking the police, like, if it happened down there, why would they be down here? Like, why y'all got us?
Like almost like it was so far.
Yeah.
Okay. The information you got, in your opinion, seemed far from where you were.
Yeah.
Okay. And then so because of that, that's what kind of made you take notice of this individual. Okay. And because you received information that it was possibly related to a murder, you just took off running.
Exactly.
Okay. Now, now on that day though, you spoke to law enforcement, right?
Yes.
And you were able to tell them exactly what you saw?
Yes.
And I'm sure they asked you a description of the individual, right?
Yes.
Now, you also then remember about 2 years later, receiving a subpoena to come in for a deposition, right?
Yes.
And it was over Zoom?
Yes.
Okay, and all the attorneys were there, right? You remember that?
Yes.
Prior to that, had you met at all with the state attorney's office?
I don't remember.
Okay. And then the next time that you've spoken to anyone about this is today in court, right?
Correct.
Okay. Did you meet with the prosecutors within the past few weeks before you testified today?
Yes.
Okay. And what, you went to their office, they asked you to come in so you could sit down and go over evidence?
Yes.
Did they show you your deposition transcripts?
Yes.
So you could remember what you told us back then, right?
Correct.
Okay. And nothing's changed. Everything that you said back then is the same as you've said today, right?
Yes, ma'am.
Okay. And then the other thing that they brought out was that something caught your attention about a car that came into the complex, right?
Ma'am.
You noticed what you described as maybe did you say a silver sedan?
Yes, ma'am.
Was it 4 doors?
Yes, ma'am.
Okay. And you noticed that there was a woman inside?
Yes, ma'am.
And you described her as a white lady?
Yes, ma'am.
Dirty blonde hair?
Yes.
Okay. And you said this was someone you had never seen before?
No, ma'am.
Now, you gave the opinion as the person looked like they were lost.
Yes.
What made you think that?
Just the way she was looking. She looked lost.
She looked like she was looking
Looking
around?
around, yeah.
Now, you had
She had a
mentioned she
phone
had
up.
I'm sorry.
She had a phone up in her hand, and she was just like looking from side to side.
Okay, so let me ask you this. When she said she had a phone in her hand, right? Could you physically see the phone in her hand?
Yes.
Did she have it to her ear, or she
No.
was looking at it?
She just had it up, and she was driving.
Okay, so did it look as if she was trying to pay attention to the phone and what she was doing?
I'm not sure. I just seen the phone in her hand.
Okay. Did it look as if she was talking?
No, she was looking.
Okay. And did you see where that car ultimately came to a stop?
Yes.
Okay. Did it park?
Yes.
And did you see that suspect or individual jump into that vehicle?
I did not.
And that's just because you turned around and took off running?
Exactly.
Okay. Now, after that, because you had initially told the police that you had seen the shooter, right?
I said
Or
I
the
seen
suspect,
someone come.
I apologize. You saw the suspect coming out of the woods?
Yes.
Okay. Did they ever come back to you and try to show you any photographs?
No.
Thank you, Ms. Boston. No further questions. Thank you, Your Honor.
All right, thank you. Any redirect?
Just briefly,
Ms. Boston, you said that you saw the individual that came out of the woods for a brief second or two.
Yes.
Do you think that you would have been able to identify anybody in photographs?
No.
No further questions. Thank you.
May this witness be excused?
Yes, ma'am.
All right, thank you, Ms. Boston. You're excused and free to go, ma'am. All right, ladies and gentlemen, then at this time, it's just 3:01. I'm going to ask you to leave your notepads on your seats. Again, we will secure them, return them to you when we reconvene after our afternoon recess. If we can take approximately 15 or so minutes to give you a bio break, then we'll return back out here to continue with the state's case in chief. Remember, you are not to talk about this case among yourselves. Thank you, ladies and gentlemen.
Against Mr. Ali, or do we need to, since there's two count fours?
Yeah, this is, yeah. It's the same one.
Do you believe that it needs to say as charged in count 4 as to Mr. Ali?
I don't think it hurts, Your Honor. I think it's
Okay.
clarifying.
I will add that the only count 4 of assault in 4-3 is to Mr. Ali, but I do want the instructions to be as clear as possible. With that addition, the state's already indicated no issue, and Mr. Kading, no issue. Anything from you, Mr. Larry, on that one? All right.
I do think the state is going to be requesting, though, if the court gives 36, the state is requesting that 1604 first aggressor be provided instruction as well.
Do you have that instruction?
We do have it, Your Honor. We'll print it. We can come back to that then.
All right.
Through the others.
Also, just for the parties' information, as it relates to these instructions that we're looking at right now, I have number 37 as the instruction related to no duty to retreat, and then I have the necessary instruction in 38. I actually would give the necessary instruction. It will be moved up. It'll be before the whether or not there's a duty to retreat if I give both of those instructions. Certainly I'll give the necessary instruction, and that was just my error in not having that be first. Any issue with number 38? Ms. Stone?
No objection to 37 or 38, Your Honor.
Thank you. And those were your instructions, Mr. Kading, no issue. Mr. Larry?
No issue.
All right. On number 39, Ms. Stone, are you requesting that I continue to use initials?
I am not, Your Honor. I'm asking that you use Mr. Williams' name in that.
Yep, yes. Any objection, Mr. Kading, just to changing that instruction only as to listing the name of the alleged victim instead of initials? And removing. Ms. Stone, any issue with 40, 41, 42, 43?
No, Your Honor, none.
Mr. Kading?
No, Your Honor.
Mr. Larry?
Take issue with 41, with 6503. I don't think it actually applies to the facts in this case. I think that pertains to the note on use says do not use this instruction in the usual case. I think it's if there's a partial, like someone breaks a window and sticks a hand in, does that constitute enter or burglary? Here we're talking about her presence on the entire Timberland High School property.
Ms. Stone?
I don't think it hurts to have it. I would agree that following or the insertion of any part of a person's body, we could end it there with a period, and the remaining clause would not need to be, or clauses would not need to be included.
All right, I did not look at that, I didn't print that particular instruction as it relates to the WIPIC. And so I want to look at that. So I'm going to have to come back to that one.
So no objections to 42. And then the court also asked me about 43.
That's correct.
Okay, I do have an objection to that. So that is WIPIC 60.05, the inference instruction. Particularly the facts in this case. I think inference, note on use, the WIPIC committee says use caution in giving this instruction, see comment below. They talk about the concern about inference instructions generally. I think there's a particular concern by the defense for Mrs. Ali about the court telling the jury that they can infer that she acted with the intent to commit the crime against the person or property therein, particularly when there's a mixed motive here. The state's allegation is that the burglary charge gives rise from her unlawful entry or remaining at the school with the intent to violate the protection order. There's also an equally alternative explanation, which is why she was there, was to see her daughter, recover her daughter, and protect her daughter. And so obviously the state can argue to the contrary. I can argue my position, but I think particularly in this case, the inference instruction is improper.
Ms. Dunn?
I disagree, Your Honor. I note that counsel makes that argument after modifying the to convict instruction under 46 to try and say that the state essentially must prove and add an additional element of proof to the state, which is not required by law or by statute. The state need not elect any. I think there's a number of arguments as to what crime she could be doing. First of all, she's violating the no contact order. She knows exactly where Isaiah has run. Assaulting Isaiah. She's already described an interaction with Isaiah, re-assaulting her daughter,
Also, I printed out and read many of the WIPICs involved in the different charges that are before the court, anticipating different arguments that I thought I would hear. I did not anticipate this argument. I have not read this WIPIC. I also optimistically thought we would conclude instructions before our noon break, and we are not going to, so that'll give me time to look at the WIPIC on both instruction 41 and 43 before I rule on those issues. Number 44.
state agrees we don't need it.
All right, so that instruction is withdrawn. Any issue with 45, Ms. Stone?
No, Your Honor.
Mr. Kading?
Nope.
Mr. Leary? All right. 46 is the elements instruction regarding the burglary in the second degree. The difference, I believe, between the two offered instructions, one from the state, one from Mrs. Ali, was that you have included the specific crime of violation of a court order. Mr. Leary, I'm going to go ahead and let you argue on that.
So I do believe I put in my trial memo that I had a question as to what was the specific underlying crime that my client was alleged to intending to commit. I did have a conversation with Ms. Stone. She indicated to me that it was violation of the protection order. If there are other crimes, then I would make a motion for a bill of particulars as to what crime And then the question is gonna be is whether or not the current jury instructions adequately inform the jury as to what crimes there are. And so, I want it to be really, I wanna know so that I can articulate and describe why my client, there's two parts. Enter or remain unlawfully with the intent to commit a crime. And I think I'm entitled to notice as to what crime the state is alleging my client intended to commit as a part of the burglary. If it's beyond the protection order, I think I want to know what it is, and I want to make sure that the jury is properly instructed as to all of the crimes that the state is going to use to argue that my client committed burglary.
Ms. Stone?
Your Honor, when we had that conversation, Mr. Leary offered me a number of options. I said, yes, no contact order, a reassault of Isaiah. With all due respect to Mr. Leary, I would characterize his response to that as poo-pooing some of those options as he disbelieves them, but the state clearly articulated that. We are at the end of trial. I just gave a number of indications of crimes that could be provided. The case law is very clear that that is not an element for the state to prove at trial in a burglary. I have provided now multiple times an indication of arguments the state will make as to what those crimes are. I understand that Mr. Leary disagrees with those on behalf of his client, but those, plainly you cannot add elements for the state to prove that are not required by either statute or case law. That is what counsel is intending to do here. It is not appropriate to put that in the to convict instruction because it is not in fact an element. And when we go to argue that to the jury should expressly know that that is not an element. And Mr. Leary cannot argue that the state has to prove that. The jury does not have to elect which of those it is. The jury has to believe, and that is why the inference language in the prior WIPIC exists in the first place. So it is improper to add that as an element. There is not a bill of particulars at this stage of the case to provide to counsel that I have not already provided in the argument as we have sat here.
So I would just, I'm sure as the court reviews, the court will see note on use. It may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests. That's in the WIPIC 46004. So that's the basis for the request.
I'm sorry, which WIPIC are you looking at?
So I'm looking at the to convict WIPIC for burglary in the second
Yeah,
degree.
60.04?
Yes, 60.04, which is instruction 46.
Yes. What did you say the language says here?
So note on use?
Yes.
It says, under some circumstances, it may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests.
And then it says burglary in the first degree elements.
It says, see comment WIPIC 6002, burglary in the first degree elements.
And then when you go down further to comments, under crime against a person or property, ordinarily, the jury instructions need not specify the crime that the defendant intended to commit inside the burglarized premises. As an exception, that crime must be specified if it is material to the defendant's theory of case. Applying Bergeron, the Court of Appeals has held the jury instruction in a burglary case should not include the elements, even if the defendant has asserted a good faith claim. And then it goes on to say there is no statutory definition of what constitutes that crime. The Washington courts have construed the requirement with a, quote, common sense, end quote, view of the underlying purpose of the statutes to prohibit and punish conduct creating a risk of or actual harm to persons or property within a building. I have now provided that to defense counsel, again, multiple times. It is not required within the statute. It is not an additional element the state has to prove at trial that the underlying crime has either in fact been committed or for the jury to elect which of those possibilities that they believe could have happened or she was intending to go in, does not have to elect between those possibilities of behavior. So I do not think it is appropriate.
All right, and I also do have that instruction in front of me, and I thought I heard you say something different, Ms. earlier, which is why I had you repeat what you said. I'm going to use the instruction as proposed by the state. The WIPIC does not require, nor do these circumstances require that the court specifically indicate the language that was proposed by Mrs. Ali, that entering or remaining was with intent to commit the crime of violation of a court order, and I will not include that language. The instruction as was proposed by the state is a correct statement of the elements that need to be proven for the, that's the burden on the state. Number 47, any issue with 47, Ms. Stone?
It should have I think we have restraint provisions language should be coming after provision of the order. Gunnar, can we come back to 47 and 48? We modified the language on that and we're going to resubmit that. So we'll provide those to the court.
Okay. All right. Actually, we're gonna start, it's noon, or it's a minute to noon. So we will come back and address the additional instructions. Mr. Kading, since you are now offering an assault in the 4th degree as a lesser charge, I need you to provide over the lunch hour the elements as to that lesser charge. I already have the definition because the definition's already been previously provided, as well as a proposed verdict form, since you are proposing those instructions, and I don't have those.
And I do think Ms. So provided the initial request for those lesser included. That may be in the packet that she handed up to the court just a few minutes ago. So, and I think it went to both Mr. Leary and Mr. Kading as well. It's just the hard copy that Ms. Leary just provided.
I see.
The verdict form would not have been in there though.
All right.
We need a verdict form for the lesser included assault 4. Right?
That's what you're offering, right?
Yes.
Okay.
I'm just trying to make sure that I got it.
I don't want to create instructions. I want to use the instructions that the parties have submitted. They may be changed, but the court does not want to create the instructions.
And then we're not talking about 151, but the only question I had at the outset, and I think we'll just need to flesh that out, is whether we had enough letters for lesser included based on the number of lesser included that we're going to be given.
Right, that's going to have to be modified based upon, I created the concluding instruction with one lesser included, because at the time I created that addition within that instruction, the only lesser crime was the assault in the 2nd degree.
And I do think you had indicated, Your Honor, to delete the special verdict form, but I do think we need the special verdict form.
I added that language later on, which is, so look at the entire instruction. That's why I thought it should be deleted there, because it's included further down in the instruction.
Thank you, Your Honor.
All right, so We will be in recess until 1:30, and then we will take this back up. Mr. Larry?
I think there's one instruction left, but I don't think it's gonna be in disagreement, so I don't know if we wanna hammer it out now, or
The two things that we were watching, they I mean everything is on break right now, but queso, the 15-minute break is over, so I'm expecting it to come back on.
And I've been conducted independent DNA testing since January of 2010.
And during that period of time, have you undergone training through the Florida Department of Law Enforcement that allows you to come and give your opinion in courts?
Yes.
And approximately how many times have you testified?
I lost count, but I think it's about 87 times.
And what fields are you testifying in?
I testify in the fields of forensic serology, forensic DNA analysis with expertise on population statistics.
And what is serology?
Serology is the identification of body fluids like blood, semen, and saliva.
And what is DNA testing? Explain that, how it's forensically used.
So DNA is stands for deoxyribonucleic acid.
It is the genetic material that is passed on from parents to offspring. Half of the DNA comes from the father and half of the DNA comes from the mother. No two individuals would have the same DNA with the exception of identical twins. It is useful in forensic DNA analysis because DNA profiles can be developed from question samples, and these DNA profiles can then be compared to DNA profiles from known individuals.
Is this type of DNA testing well accepted in the scientific community?
Yes, it is.
And have you ever not been allowed to give your opinion on your DNA testing in courts like this?
Never.
Your Honor, I would tender the witness as an expert in DNA testing and its statistical population components.
Any additional voir dire from attorney for Mr. Whitaker? And for Mr. Robinson?
No, Your Honor.
Okay, you may proceed, Mr. Mizrahi.
Thank you, Your Honor. So the jury heard about DNA. We think of DNA as something that like defines our biological traits like height, weight, hair color, skin color, eye color. Are those the types of areas of the DNA that you're looking at?
No, the DNA areas that I'm looking at doesn't code for any trait that are visible.
And I think sometimes it's commonly referred to as junk parts of the DNA.
Yes.
Is that because we don't really know exactly what it does?
It doesn't code for anything, so they're, yes, called junk DNA.
But the science is not junk.
It's not.
And it's in the course of your training experience, other than identical twins, do any two people have the same DNA profile?
No.
And the areas of the DNA molecule that we're looking at, are they different among different people?
Yes. So most of our DNA are the same because it codes for like our two eyes, nose, ears, and all the other bodily functions. But the areas that I am looking at, they are different among individuals. And that's why we are looking at the small segment of the DNA that are different among individuals.
And during the course of your training experience, do you continue with education that allows you to continue to be up to date on the latest expertise?
Yes, we routinely conduct journal clubs at work, and I also attend DNA conferences once a year.
And does the lab go through the FDLE lab that you work at? Does it go through proficiency and testing to make sure it's accredited, things like that?
Yes.
So, during the course of your testimony today, did you ensure that all the safety protocols of your lab were followed and adhered to?
Yes, I did.
So have you had the opportunity to review your 2020 530 file?
Yes.
And if you ever need to refer to it, just let us know. That's perfectly okay, all right? Did you receive a lot of information and evidence related to a Barbara and David Buckley?
I did.
Now, obviously, you're not at the scene collecting all this evidence, so you're relying upon law enforcement to provide you the information on the packages.
Correct.
And then you put in your report what the law enforcement officers have done.
Yes.
You can't testify as to how they did it or anything like that.
Correct.
How are you able to testify to this jury that once FDLE gets the item, that item is forensically secure? In other words, you put it into a vault to make sure the seals are done and all that. Explain that to the jury.
So FDLE has an evidence intake section where the items of evidence that are submitted by contributors, the police departments and sheriff's offices are submitted to FDLE. So every case gets assigned a unique FDLE case number, and every item associated with that case gets a unique FDLE item number. Once these pieces of evidence are entered into the system, they are placed in a secure vault that only few members of FDLE personnel are allowed to have access to. And until I request the transfer of custody of those items to myself from the crime laboratory technicians, they remain secure in the vault.
And the jury's kind of, I think, from a distance, seeing things like evidence tape and signatures and things like that. Why is that important?
It is important so that I would be able to know if my seal has been broken into or tampered with after I'm done with my analysis.
Was there any indication in any of your work that the items had been tampered with?
Not with the previous cases that I've testified to where evidence were shown to me.
So I want to go and explain a little bit about what you did there. Lucky for us, the two main items I want you to look at are sitting right to your left. Do you see both a pajama bottom and a pajama shirt?
I see a pajama bottom and, yes, a pajama shirt.
The pajama shirt is 244 and the bottoms are 245. So we're just going to refer to them as bottoms and tops.
Okay.
And you previously looked at those items and identified them as the items that you worked in this case.
Yes.
And I think you could probably see we might as well do it. You can see the bags that are in here that have your identifiable information.
Yes.
So when you're examining items like this, explain to the jury how you go about examining the pajama bottoms and tops to see if there's any DNA that you can test.
So for these particular pieces of evidence, they were described to me as pieces of evidence suspected to contain possible blood stain. So I look for stains that are consistent with originating from possible blood stains, which may present themselves as red-brown staining, brown staining, black staining, green staining, or yellow staining.
And why do you specifically look for blood stains or any kind of stains for doing your DNA testing?
So for this particular case, it was...
Let me ask it like this. Would blood contain DNA?
Yes,
Okay.
it will.
So as opposed to going over the whole shirt or the whole bottom searching for potential touch DNA, you go directly to the blood. That's going to give you the best chance.
Yes, and also it was on the case tracking form that possible blood was located on the victim's clothing.
And did you do a test to see if there was any presumptive blood on those items?
I did.
And what was the results of that? If you need to refer to your, go ahead. I'm sorry.
The pajama top and pajama bottoms both gave chemical indications for the presence of blood.
So when that happens, does that target where you're going to do your DNA testing?
Yes, so the same area that gave chemical indications for the presence of blood would be the same areas I will take samples to proceed to DNA testing.
And did you do that?
I did.
Now, before we get into the results of those, it's important the jury understands the concept of an intimate sample and what does that mean for your testing? How do you take that into account?
So the items of evidence such as clothing are actually referred to as indigenous samples.
Indigenous, that's better, okay.
And which means that the person wearing the items of evidence, we can expect their DNA to be present and would not be unusual. And I can use that person's DNA sample present on the item to back out their DNA to be able to determine if there's any DNA foreign to that person or any DNA not belonging to that person wearing the pajama top or pajama bottoms.
Did you actually receive a known buckle? I say buckle. Is it buccal or buckle?
I say buccal, but I think most people nowadays say buckle.
Oh, okay. I'm not going to say that. So that's going to be State's Exhibit 219, which is going to be your number 2. Is that going to be Ms. Buckley's known buckle?
Yes.
Did you use that to parse out her indigenous DNA from her pajamas?
I did.
So in parsing out Ms. Buckley's, did you also have her husband, or purported to be her husband, David Buckley's buckle swab?
Yes.
And was he excluded as a possible contributor?
He was.
Did you find DNA that was male that was foreign to Ms. Buckley?
I did.
And did you find it on both items?
I did.
So was it a mixture of Ms. Buckley and then this unknown person?
Correct.
Just the two of them?
Yes.
Did you also receive Mr. Barner's buckle swab as well as Mr. Whitaker's buckle swab?
I did.
I'll just show you those for the record. the state's exhibit 222 is going to be Mr. Barner's swab, Dominic Barner, and then state's 224 is going to be Mr. Whitaker's.
Yes.
So you're getting these known profiles from Mr. Barner and Mr. Whitaker. Did you develop a full DNA profile for them?
I did.
Did you compare the full DNA profiles from Mr. Barner and Mr. Whitaker to the unknown male DNA you took from the blood stains on the shirts and the bottoms?
I did.
And let the jury know what the results of that was.
So for the DNA profile from Dominic Barner, his DNA profile was compared to the shirt from Barbara Buckley, and Dominic Barner is included as a possible contributor to the mixed DNA profile obtained from the shirt from Barbara Buckley.
And the shirt would have been number 244 for the record. So included as a possible contributor, what does that mean? Does that mean it could be him, may not? Explain to the jury how statistically significant that is.
Yes, so because I wasn't there and I didn't create the mixture, I can't say it's definitively these people who are in the mixture. So I say possible, but the DNA types are consistent with what I observed between the DNA type from Dominic Barner and the DNA types on the pajama from the top from Barbara Buckley. And then I calculated a likelihood ratio. So the observed mixed DNA profile from the top, from the pajama top, is greater than 700 billion times more likely to occur if the sample originates from Barbara Buckley and Dominic Barner than if it originates from Barbara Buckley and an unrelated individual.
Okay, so 700 billion is a huge number.
It is.
Is that a conservative estimate?
Yes. The actual number is actually so much greater than that, but we cap our reporting segment at 700 billion because it's something that we are more familiar with. It's a number we're more familiar with.
And even that number is more than any human beings have ever lived on planet Earth.
That I'm not sure, but it's definitely more than the people on the planet now.
Yeah, well, that's fair enough. And the people on the planet now, are we up to 9 billion yet? 10 billion? Are we that high?
I think we just exceeded 8 billion or approaching 8.5 billion.
So this is 700 billion times.
Yes, it's greater than 700 billion.
Greater than 700 billion. So that was with Mr. Barner on the shirt.
Yes, and Dominic Barner is excluded as a contributor to the mixed DNA profile from the bottoms.
Okay, and then likewise, Mr. Whitaker is excluded from the top.
Yes, he is. He is excluded from the top.
So we have Barner on the top, and then we have Whitaker on the bottom, which I guess you haven't gotten to yet. Explain to the jury what the results of the bottoms were.
So a complete DNA profile was obtained from Leroy Whitaker Jr., and that DNA profile was compared to the mixed DNA profiles from the top and bottom. So Leroy Whitaker is excluded as a contributor to the mixed DNA profile from the pajama top. Leroy Whitaker Jr. is included as a possible contributor to the mixed DNA profile obtained from the pajama bottoms. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originates from Barbara Buckley and Leroy Whitaker Jr. than if it originated from Barbara Buckley and an unrelated individual.
And I want to just briefly explain to the jury how you just practically are taking Barbara Buckley out, and then what's the DNA profile left behind? How do you do that?
So, as I mentioned earlier, half of the DNA comes from the father and half of the DNA comes from the mother. And so we have the DNA profile is actually just a pair of numbers at the 21 areas of the DNA that I'm looking at. So individuals will have different DNA types. Only identical twins would have the same DNA. So anything that does not belong to Barbara Buckley is said to be foreign to her.
And in your analysis, were you confident that there was only one other source of DNA, meaning only 2 total contributors?
Yes.
And we should probably show the jury where we're talking about. Did you make marks on the bottoms to indicate where you got the sample from?
Okay, so on my notes, I said area A is red-brown staining on the back.
Did you do a parentheses and put the letter A there?
Yes.
There's another on the side that's facing me where it says neg.
That is short for negative.
So if the jury, if they need to see it, it's the little parentheses that says
A.
A. It looks like there's a little hole there.
Yes, that's where I collected the sample from for DNA testing.
I also want to show you one other item that you looked at, which is State's Exhibit 220220. Do you recognize that?
I do.
What's that?
The neck and left wrist swab of Barbara Buckley.
Again, you expect to find Barbara Buckley on the swab taken from her neck.
And wrist, yes.
And what were the results of that once you accounted for Ms. Buckley's DNA being present?
So the neck and left wrist swab also gave chemical indications for the presence of blood. And the DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And Barbara Buckley is expected to be a donor to this item, and she is observed in the mixture. David Buckley is excluded as a contributor to the mixed DNA profile.
And was Mr. Barner found to be the other contributor?
Dominic Warner is included as a possible contributor to the swab from the neck and left wrist of Barbara Buckley.
And was the statistic the same?
Yes, observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Barbara Buckley and Dominic Barner than if it originated from Barbara Buckley and an unrelated individual.
Other than Leroy Whitaker and Dominic Barner, and obviously Mrs. Buckley, Barbara Buckley, did you reveal any other DNA profiles?
I did not obtain any other standards, so I didn't make any other comparisons.
I guess that was not a great question. Was there anything in those samples where you matched it to Whitaker and Barner, like a third person, I guess is the better question.
No.
Is it common in the Florida Department of Law Enforcement for you to develop a full profile of Leroy Whitaker and then, or any defendant or suspect, and then have another analyst use that full profile for comparison purposes on additional testing?
Yes.
And you're aware that that happened in this case?
I'm aware that this is cross-referenced to a different case, to another case, but I don't know if this DNA profile was used for that case.
And you see Ms. Heisler outside?
Yes.
She doesn't live here anymore?
She doesn't.
Was it nice to see her?
Yes.
Okay. And she'll testify about that. But is that common in FDLE for
Yes.
one analyst to do the standard and then another analyst to use that standard?
Yes, I have done that in many other cases.
And the standard that you did for Leroy Whitaker, that's just part of your case file and it gets documented?
Yes.
So someone else can come back and use it?
Yes.
That's all the questions I have.
All right, thank you. Cross for Mr. Whitaker.
Good afternoon.
Good afternoon.
How are you doing?
Good, thank you. How are you?
Good. In your 21 years at FDLE, those have all been in serology and DNA?
Yes.
Is it fair to say, over the 21 years, that there have been a lot of changes in the technology?
Yes.
Okay. And obviously changes in your protocols as well?
Yes.
Correct?
Correct.
I mean, 20 years ago, did you have the level of safety protocols that are now in place?
I think so. Nothing much has changed with our standard operating procedures, with the exception of the platforms and the amplification kits. The technology is pretty much the same.
Okay. And you mentioned as part of your training, obviously you have your education before you even began at the FDLE, but part of your training at FDLE is to actually learn how to testify effectively.
Correct.
Correct?
Yes.
Like you literally have mock moot courts.
Yes.
Okay. All right. Now, you had mentioned something that, to your knowledge, no two people have the same DNA, correct? Besides
Yes.
identical twins.
Correct.
Okay. And that's based on what we know right now, correct?
Yes.
And another way to say that is, and we'll get there, and I apologize for somewhat jumping around, but when we start talking about the statistical significance of a certain result, that's based on a specific database, correct?
Correct.
Okay, and in that database is sample DNA profiles of then where you're able to statistically determine what level of the population might have that particular loci.
This is a likelihood ratio, so I think that's different from random match probability.
I should let you explain it because I guarantee you'll do a better job than me trying to ask the question.
Okay.
What is the database? How was the database created?
So the database is created by collecting samples from blood banks, from, I think for this particular database, it was from Memphis, Tennessee,
Okay.
and Fort Lauderdale. And then there were buccal swabs from Paternity Lab in Ohio. And so these samples were then extracted and DNA profiles were developed and tabulated. And then the number of times a particular DNA type is observed in the population, they are tabulated. And we are using this database, which is used nationwide and used by the FBI as well. And this is published in a peer-reviewed journal, Forensic Science International Genetics, and it can be refuted by other people, other scientists out there, but this has been validated to be valid for our purposes.
For the statistical analysis.
For this statistical analysis, yes.
And so, if I understood you correctly, number one, how many people are in the database?
I believe it's about 1,097 individuals in the database, including Asian individuals, which, you know, we're not calculating the likelihood ratio of.
Okay. And a real-world application, is it somewhat the concept? Is it somewhat similar to like when we hear about polling results? And then people are trying to say, because we had a poll result, we can then assume we took a small database, we can now then expand upon what we think will happen for a larger population.
Yes.
Okay, so very similar to like when we'll read in the paper before some type of an election, the polling numbers are suggesting, correct?
Yes, but I think it's different in the fact that Caucasian population, the genetic differences between individuals are greater than between populations.
Sure, okay. And so your calculations are, and they're scientific, they've been scientifically validated.
Yes.
But just for kind of the education of our jurors, we're creating these numbers, or we're finding these numbers based on the, I guess, known profiles of, was it 1,197 people?
1,097.
1,097. Okay. Okay. And I think it goes without saying, but I'll go ahead and say it, that obviously those 1,097 samples that make up this database, we know for sure that there were not two DNA profiles that exactly matched, correct?
Correct.
And through all of your 21 years, you have not come across a situation where two different people that were not identical twins had the same DNA profile, correct?
Correct.
All right. So you had mentioned in regards to kind of the different protocols that are in effect at FDLE that you all actually have your own vault, correct?
We have a central vault in the evidence intake section, and we have our own lockers in the biology DNA section.
You obviously do not know where a particular piece of evidence or standard was prior to getting to the Florida Department of Law Enforcement.
Correct.
There is a difference between what we call touch DNA, and then I'm going to use the word intimate sample. Would that be correct?
No, not for.
Correct me. Correct
Yes.
me.
So
Tune me up.
intimate samples are samples that were collected from an individual's body, like orifices and, skin swab. And indigenous samples are samples like bedding or clothing or purses or cell phones. But both intimate and indigenous samples, we expect that individual's DNA to be present there. Or we don't necessarily expect, but if we see them there, it's not unusual because they have contact with those pieces of evidence.
And forgive me because the distinction I'm actually trying to make by a very poorly worded question is the difference between touch DNA, where you might ultimately be seeking epithelial, versus blood. Okay? And is there a difference?
Yes.
Okay.
Blood is a much richer source of DNA.
Okay. In regards to touch DNA, give us some examples of what touch DNA would be.
So touch DNA would be, if say for example, my hands are sweaty and then I touch this surface, there is a possibility that I can leave my DNA behind or my skin cells behind on this surface, and then if it's swabbed at a later time, then my DNA can be picked up from those skin cells, but it's not a guarantee. There's a lot of factors that come into play with touch DNA, getting left behind on an item or not.
And sometimes you will know that you have DNA, but you don't have any identifiable DNA or interpretable DNA, correct?
Can you repeat the question?
Sure. And let me actually go to the example in this particular case. Just for an example of sometimes you know there's DNA there, but it's just not interpretable. In this particular case, you attempted to get DNA from Ms. Buckley's fingernail swabs.
Correct.
Okay. And your ultimate result in regards to that was due to the limited nature of these results, the data is not interpretable.
Correct.
Okay. You did find, though, that there was DNA foreign to Ms. Buckley, correct? Just,
it was too little to be compared to anyone's standard.
and you also have that with the instrumentation, that there are times you're ultimately, to get these numbers, you're looking at graphs.
Yes.
You're looking at peaks.
Correct.
And if a peak isn't, there's sometimes what you call, you can't call a certain peak, correct?
Yes.
Help us understand what that phrase means.
So we have a threshold. So a peak has to reach a certain height in order for me to be able to say that that is a DNA peak attributable to a person.
And so there are times that we have what's called a mixture, correct?
Yes.
Okay. And what I've heard you explain is that, or actually let me start with the results in regards to the pajama bottoms.
Yes.
Would you call that a mixture?
It was a mixture.
Okay. And is it fair to say you call it a mixture because you found at least two different persons' DNA?
Correct.
Okay. Mr. Mizrahi had asked you a question, were you confident, and we're specifically talking about the pajama bottoms, that it was only the two that it was only 2 people?
With the results that I interpreted and I have observed, I am confident it is only 2 and 2 individuals only.
But again, we unfortunately have in DNA technology situations where you may have peaks that don't meet your threshold, correct?
Yes, but I don't interpret those peaks because they're not interpretable.
Sure. And so they're not interpretable in terms of identifying them to anything, correct?
If they're not even called, I can't interpret them.
Okay, you can't even call it a specific DNA marker.
Correct.
Okay, fair enough. There are a number of steps in regards to the DNA process, are there not?
Yes, there are.
You actually do not complete all of those steps yourself, do you?
I don't.
And in this particular case, there was an Aliyah Field, correct? Am I pronouncing her name correctly?
Aliyah Fields.
Aliyah, is it Fields?
Fields,
Okay.
yes.
She's no longer with the Florida Department of Law Enforcement?
She's not.
Okay, but she performed some of the manual steps in this process, correct?
Robotic steps.
Okay. She also helped perform the quantitation setup?
Yes.
Okay. And then there was another worker, Roe McKenzie?
Rowena McKenzie, yes.
Okay. And she also operated the robot for amplification?
Yes.
Okay. And you're a supervisor at the Florida Department of Law Enforcement, correct?
I am.
Within your
I am not.
You are not?
I am not.
But you were supervising these people, correct?
I'm not.
Okay. But they do important steps to the DNA
Yes.
process, correct?
They have undergone training and they have completed their training successfully. They do proficiency testing and competency testing before they are able to operate these instruments with casework samples.
In your time at the Florida Department of Law Enforcement, you have experienced instances of what's called sample carryover contamination, correct?
Yes.
Okay. If you could, explain what that is to the jurors.
So sample carryover contamination could occur if there is a sample that has a large amount of DNA that could then bleed over to other samples that are adjacent to it on a plate.
And you personally, ma'am, are not sure of how many times in your career at FDLE you've had instances of contamination?
I don't remember, but it is recorded.
There is documentation as is required for
Yes.
your accreditation. Can I just have one moment, Your Honor?
Yes.
When you were asked, ma'am, in regards to whether or not other analysts, and I think you mentioned that you were aware in this case that there might have been 2 separate analysts working on different aspects or different parts of the case. What would that analyst use in terms of what you produced for the known profile of Mr. Whitaker?
The DNA profile that was generated in the course of the analysis.
Meaning the double numbers
Yes,
or the actual item?
just the double numbers.
And can I touch the numbers, ma'am?
Yes.
Show you the JAMA files, which reads 10L for identification, but I think it's been introduced in a minute. I just want to make sure that I understand. Where this is marked A, this is where you took the actual cutting,
Correct. That whole.
that hole. What is the significance of what's on the back?
That is actually the front.
Oh, I'm sorry, the front.
So there is a stain there that I think could be a possible blood stain, and I tested it presumptively for blood, and it was negative. So I marked it.
And that's why you stopped any further analysis?
Correct.
Okay, how about this
I only assign a alphabetical identifier on areas that gave chemical indications for the presence of blood. I must not have labeled that negative.
Can you look through your bench notes? Because obviously you take very detailed
Right.
notes over exactly what you do.
So I said with red-brown staining on the front pant leg and back pant leg, and positive area A, right, red-brown staining on the back, and negative red-brown staining on the front. And a sample was collected from area A for DNA analysis.
All right, thank you very much, ma'am. I don't have anything further.
All right, thank you. Cross for Mr. Robinson.
Good afternoon.
Good afternoon.
I didn't have anything for you, but then you were talking about population, so it caused me to put together a few questions. So you were asked about 700 billion times more likely, right?
It's actually greater than 700 billion times.
That's a lot of billions.
Yes.
And we all agree, and I think that it was Mr. Mizrahi that said that that's more people than have ever been on the planet.
Which I'm not sure of.
Okay. But it's more than are on here right now. I'll agree with that.
Yes.
Now, if instead I were to change it, and this doesn't have to do with your analysis, but your expertise, if I were to change that to 4.4 million times more likely, that's a lot less, right?
Yes.
Is that equivalent to the population of Florida?
See, the likelihood ratio statistic that I calculate doesn't have anything to do with the Earth's population. It is independent of it. But the fact of the matter that we are capping the reporting at 700 billion is because it's something that most people can relate to.
Okay, but we're talking about 4.4 million.
I don't know the...
Let me finish
Okay.
the question. If it's 4.4 million, and I understand that you're going, you're not saying that it's against the population, but the terminology that's used by FDLE, that's used by all analysts across all reports, ties to the population, correct?
It doesn't.
So then what's the relevance of the number? To just give a big number?
No, the likelihood ratio is what the number that is the statistics that is calculated when comparisons are made.
Okay. So you can have, and we can end with this. You can have comparisons when it's in the hundreds of billions, right?
Yes.
If it's on the low end of the millions, that's lower, much lower on the spectrum, right?
Yes.
Nothing further, Your Honor. Thank you.
Okay, is there any redirect?
So Ms. Schlacks briefly brought up the concept of not having DNA and the fragility of DNA. Could you explain to the jury, in your training experience, if I touch something, does that mean I'm going to automatically leave behind DNA that we're going to find?
No.
Explain that to the jury.
So, as I've mentioned earlier, there's a lot of factors that come into play as to when touch DNA can be left behind. It depends on the length of time between the contact of the skin surface and the item of evidence. It depends on if there was enough friction to slough off skin cells from the skin surface to the item. It also depends if the person recently washed hands, or if the item was clean prior to it being swabbed or being sampled after it was touched.
What about environmental factors? Heat,
So-
water, stuff like that.
DNA is a very stable molecule. However, it can be degraded by extreme heat. It can be degraded by cleaning products. It can be degraded by water because it can promote microbial growth. And it's also sensitive to pH changes.
It can also be like wiped away.
Yes.
I just want to make sure it's not necessarily cleaning products, but just wiping something away.
Yes. Somebody could have touched it, and that person just like picked up the DNA with his skin surface or her skin surface, and DNA was not there anymore.
Ms. Schlax asked you about the why about there being only two contributors to the DNA? Why are you so confident that it's only two?
Because so like I mentioned earlier, half the DNA comes from the father and half the DNA comes from the mother. It can be the same DNA type at one area of the DNA, or it could be two. The maximum number of DNA types that I expect at one area of the DNA for one person is two. So anytime I see 3 or 4, then it tells me that there's more than one individual there. And the DNA that I observed on the shirt, or the bottom and the top, I am very confident that there are just two people because I've seen a maximum of 4 DNA peaks.
Never saw a fifth, which would indicate a third contributor.
Correct.
And the DNA profile that wasn't Barbara Buckley matched the DNA profile of either Barner or Whitaker.
They align with their DNA profile. They're consistent.
And we're looking at 21 different locations?
Correct.
Explain to the jury, because we excluded Mr. Buckley. If there's any location where that DNA does not match either Mr. Barner or Mr. Whitaker, are you able to definitively exclude them as being a contributor?
Exclusion is absolute. If there's any discrepancy whatsoever in just one area of the DNA, that is on exclusion.
And we were talking about the population of the Earth, but this statistical probability is to show how rare the likelihood of someone, an unknown individual, contributing that DNA versus either Mr. Barner or Mr. Whitaker. Is that a better way to say it?
It sounds correct, but I don't know if it is correct.
Oh, well, it's not. You're not saying that there's a 700 billion people in the Earth, and you might find one person that has that.
No. What I'm saying that DNA profile is 700 billion times more likely to occur if it originates from Barbara Buckley and Dominic Barner on the pajama top than if it originated from Barbara Buckley and an unrelated individual who is not Dominic Barner. So the likelihood ratio is a statistical calculation that compares two opposing explanations to the same event. So the event being a mixed DNA profile of two individuals was observed on the pajama top. The first explanation is that DNA profile originated from Barbara Buckley and Dominic Barner. And the second explanation is that DNA profile originated from Barbara Buckley and an unknown individual. The first explanation is greater than 700 billion times more likely than the other explanation. That is what likelihood ratio is about.
And I assume you're not an expert in political polling or anything like that. Is that true?
I'm not.
But in your lay mind, have you ever heard of someone being 700 billion times more likely to win than somebody else? Have you ever heard that kind of polling reported?
No.
That's all the questions I have now.
All right, thank you. May this witness be excused? All right, thank you, ma'am. You're excused and free to go.
Thank you.
All right, state, you may call your next witness.
Laurel High School. We didn't get them. Oh, go ahead, yeah.
Yes. All right, ma'am, if you'll come forward and be sworn. If you can have a seat right there in the center. And be sure to hold that microphone or have it close to your mouth. Speak loudly and clearly. Thank you, ma'am.
Hey, police the court.
Yes.
Please introduce yourself to both juries.
Hello. Hello. My name's Coral Heisler. It's Heisler.
What do you currently do for a living?
I work at the Charleston Police Department, and I just opened up a new forensic DNA laboratory.
Is that working at the Charleston Police Department you opened up?
Yes.
So you, that's kind of cool. How long have you been there?
About a year.
And so you moved from Jacksonville, Florida?
Yes.
And were you previously employed with the Florida Department of Law Enforcement?
Yes, I was.
For how long were you employed with Florida Department of Law Enforcement?
For about 14 years.
And the jury's already heard about who FDLE is, and were you a DNA analyst?
Yes, I was.
You currently still are in Charleston.
Yes.
So explain for the jury a little bit, we've already heard some of it about your educational background, training experience that allows you to come into courts and testify.
I have a bachelor's from Penn State in forensic science with the option in biology. I was trained at FDLE through a two-phase training program. The first phase is mainly academic. There are readings, textbooks, exams, lab practicals. And the second phase is supervised casework, where I'll work actual cases under the supervision of a qualified analyst. There's a series of 3 oral boards or oral examinations in front of my training committee and a mock trial.
And over the years, have you undergone proficiency testing to make sure that you're qualified to testify in DNA?
Yes, I have.
And is the lab accredited?
Yes.
And the jury's heard a little bit about this. When you're doing specific testing, do you make sure that the samples that you're testing both are not tampered with, and that you're doing your testing without tampering with it externally from like you or other analysts?
Yes, I make sure the package is sealed, and I wear protective equipment, PPE, like a mask, gloves, hairnet when I work the items.
When you actually work the items, do you use blanks to make sure that there is no contamination?
Yes, I do.
So have you, and how many times have you testified as an expert?
About 70 times.
You ever not been qualified and expert in forensic DNA technology and the statistical components?
No.
At this time, I would tender the witness.
Any voir dire from Defendant Whitaker? And from Defendant Robinson? All right, you may proceed.
So the jury has already heard of deoxyribonucleic acid and how it's worked forensically, so we don't need to go all through that. Have you had the opportunity to review your case file with regard to 2020-626?
Yes.
It's pretty lengthy.
Yes.
Thick. Okay.
It is.
You did a lot of testing in this case?
I did.
And we heard from analyst Adana, who indicated that she did the sample from Leroy Whitaker. Did you eventually use her produced sample in some of your comparisons?
Yes, I did.
Is that commonly done at the Florida Department of Law Enforcement?
Yes.
And throughout DNA technology, because you're in Charleston now?
Yes.
So I want to turn to your testing, and we'll kind of go through with it. The items taken from reported to be a Nissan sedan. Did you do DNA testing on 2 white shirts from the Nissan sedan?
I did. May I refer to my notes?
If that helps refresh your memory, you may.
Thank you for asking. I should have said that. I said it to the other one.
Yes, I did.
Did you also do swabs from the rifle and the Glock?
Yes, I did.
Did you also swab live rounds and bullet fragments?
Yes.
So we'll go through some of the easy things first. The bullet fragment, did that end up matching Charles McCormick? The victim in this case.
Yes.
Okay, so the swab from the live round, that did not demonstrate anything that could be extracted and quantified?
The steps, I do extract the DNA, and when I moved to the quantification step, there was insufficient DNA to continue the DNA process.
And so those were the swabs from the live rounds and the rifle. Also, were there swabs from the rifle and the Glock? Did those indicate a mixture that could not be interpreted?
That's correct.
So that was the easy stuff. Let's go, and it's actually right to your left. I know you previously looked at them in your pre-trials. I usually show this beginning first with State's Exhibit 210, which corresponds to exhibit number 9 for you. Right?
Yes.
And then State's 211, which reports with exhibit number 10.
Yes.
And where was 9 located according to the law enforcement, and where was 10 located according to law enforcement?
Nine was the driver's seat, and 10 was the rear seat middle.
Okay, so I'm going to refer to 9 as the driver's seat, which 9 is going to be 210, and then 211 will be 10, the rear seat. Okay?
Okay.
So we'll just do front seat, back, driver's seat, back seat. In the analysis of the white T-shirt, were you able to locate a hair that could be tested for DNA?
Yes.
Objection, Your Honor, just clarification, which white T-shirt is this to?
Yeah.
From the driver's seat.
Yes.
Explain for the jury how you determine that a hair is suitable for DNA testing.
I take the hair, I put it under the microscope, and if I see possible debris or epithelial cells or look at the root and determine it's suitable for DNA testing, I proceed. I take a cutting of the end of the hair and put it in a tube.
And did you determine that that DNA was from a single source?
Yes.
And did that DNA end up not matching some of the people we're going to talk about that we've already heard, Leroy, Whitaker, Hakeem Robinson? It did not match any of those people.
That's correct. They were excluded.
All excluded.
Yes.
Okay. But did you also perform a test on the shirt itself?
Yes, I did.
How did you go about doing that?
I swabbed specific areas of the shirt to look for wearer DNA, and I swabbed the collar area and the armpits, and I believe the shoulders. 1 second.
You can check to see. And you're using one swab for all of those areas?
Yes, to concentrate the DNA on one swab. I swabbed the inside of the shirt, collar, armpits, and shoulder.
And in doing that test, did you determine that there was a mixture of DNA that could be compared to other people?
Yes.
And that mixture was consistent with how many individuals?
3 donors.
Were you able to exclude in your first round Charles McCormick, Krista Odom, Cora McKnight, and Miss Barton? I don't want to say her name wrong. Eva Barton were all excluded as possible contributors?
Sorry, I have them listed as numbers. I just have to verify.
Okay. Yeah, take your time.
Yes, they were excluded.
Were you later provided the known DNA samples from a Leroy Whitaker and Hakeem Robinson?
Yes.
And did you compare those known DNA samples to the mixtures in the driver's seat T-shirt as well as the rear seat T-shirt?
Yes, I did.
And what results did you have beginning first with the driver's seat T-shirt?
For the driver's seat, Leroy Whitaker is included as a possible contributor to the mixed DNA profile obtained from the item. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Leroy Whitaker and 2 unrelated individuals than from 3 unrelated individuals.
And the jury has already been explaining that billion-time likelihood, but I guess let's just get a different perspective. What does that mean?
It's likelihood ratio is a weight of the evidence in a form of a number. I can tell you, yeah, it's 7 billion times more likely or 700 billion times more likely, but that doesn't really mean much. Like if I can say he's included, but that doesn't mean much without giving you a weight to the number. And that 700 billion is the weight.
And to confirm the Hakeem Robinson, did you actually perform the DNA analysis on his known buccal swab?
Yes.
And that's going to be states 223?
Yes. Buckle.
So 700 billion times Hakeem Robinson on the driver's seat, but there's a mixture of multiple people.
It was a mixture of three.
Turning to the rear seat, did you perform the similar DNA analysis?
Yes, I did.
And what were the results of that?
That also demonstrated a mixture consistent with 3 donors.
And did it match any known profiles that the Florida Department of Law Enforcement had developed?
Since it's not a single source, I don't say match, I say included. And Leroy Whitaker is included as a possible contributor to the mixed DNA profile obtained from this item. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Leroy Whitaker and 2 unrelated individuals than from 3 unrelated individuals.
And so same testimony that you gave with Mr. Robinson in terms of what that means, 700 billion, what it means.
Yes. I stated the inclusion for Leroy Whitaker for item 9 and 10. We didn't go over Mr. Robinson for item 9.
Who did you say for item 9? I'm sorry. I missed that.
I just stated the inclusion for Leroy Whitaker for item 9 and 10, not the other individual yet.
Correct. I'm sorry. Let's go back to 9 so I make it clear. Who's on 9? Or who's included on 9? 9 being the driver's seat.
I did state Leroy Whitaker was included as a possible contributor, and that's the likelihood ratio of 700 billion that I gave. And when I compare Hakeem Robinson, I do also include him as a possible contributor to the mixed DNA profile, and it is the same likelihood ratio. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Hakeem Robinson and 2 unrelated individuals than from 3 unrelated individuals.
Sorry, I wasn't listening carefully. So both Hakeem and Leroy Whitaker are included on the driver's.
They are.
Well, let's have the witness clarify. T-shirt on the driver's seat. Tell me, repeat again, if you will, please, who is included in that T-shirt?
I independently looked at the reference samples from both Leroy Whitaker and Hakeem Robinson. In my first statement, I compare Mr. Whitaker, and I'm including him into the mixed DNA profile that originated from item 9, or the driver's seat white T-shirt. And then I look at Hakeem Robinson, and I also included him as a possible contributor to the mixed DNA profile. And then I reported the likelihood ratios independently for each of them.
So we heard from Analyst Adana that she's confident in one of her other, and it has nothing to do with what you did, that she knows it's only 2 people because there's no more than 4 loci in any particular location on the DNA, no more than 4 alleles in any particular loci. So here, are you confident that there's at least 3 people involved?
Yes.
How can 2 people both
Okay, y'all, this isn't me. This is the feed. So we're just waiting for the feed to come back up. Hopefully, okay, y'all. Hopefully, it comes back up. I'm gonna speak. Oh, there you go.
Case Exhibit 226 and Case Exhibit 225, which are samples that you developed with Abdul Robinson Jr. and Abdul Robinson Sr.
Yes.
And were you able to exclude Abdul Robinson Jr.?
Yes.
And with Abdul Robinson Sr., were you able to exclude him in some areas, but then it was undetermined in others?
From the driver's side?
I'm sorry, for the shirt, he was excluded. Go ahead.
Driver,
Just explain the results. Let me stop.
for item 9, the t-shirt from the driver's seat?
Yes.
They were both excluded.
I was talking about the driver's compartment where
Okay.
I'm jumping ahead. It's my fault. And they were excluded from the rear middle seat as well.
The t-shirt on the rear middle seat, they were also excluded from.
Okay, and I don't think we've given the results for the rear yet. What were the results on the rear?
You have not.
Let's do it.
Okay. So what results are you looking at now?
DNA mixed, 3-person mixed DNA profile from the T-shirt from the rear of the vehicle, the rear seat. Number 10, I believe.
They are also excluded from that.
But were you able to include, and also Hakeem Robinson was also excluded from that?
Hakeem Robinson is excluded as a contributor to the mixed DNA profile obtained from the white t-shirt from the rear middle seat.
You were able to include Leroy Whitaker to that shirt?
Yes, he is included as a possible contributor to the mixed DNA profile obtained from this item. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Leroy Whitaker and 2 unrelated individuals than from 3 unrelated individuals.
Okay, so despite my jumping around too much, Hakeem Robinson and Leroy Whitaker are included on the front seat and only Leroy Whitaker on the back seat.
Objection, mischaracterization of the testimony. Front seat versus T-shirt on front seat.
Okay, if you'll just clarify your question.
T-shirt that we've talked about that's sitting right to your left side.
Yes.
That mixed DNA profile included both Hakeem Robinson and Leroy Whitaker.
Yes.
And the rear seat T-shirt sitting right to your left, it was just Leroy Whitaker.
Correct.
So did you also get some touch DNA swabs that were taken from the reported 4 compartments of the Nissan car, sedan?
Yes.
And 3 of them, were you able to report any identifiable DNA?
No, it was a mixture that was not suitable for comparison on 3 of the items.
Were you able to report some information with regard to the driver's seat compartment swab taken from the Nissan sedan?
Yes, it was a mixture consistent with 4 donors.
That's 4, so that's the most we've seen. Is that in Stacey's Exhibit 221?
Yes.
So Stacey's Exhibit 221 had a mixture of 4 potential donors.
That's correct.
And what did you report in terms of Hakeem Robinson being a contributor to one of those profiles?
He is included as a possible contributor to the mixed DNA profile, and the observed mixed DNA profile is approximately 4.4 million times more likely to occur if the sample originated from Hakeem Robinson and 3 unrelated individuals than from 4 unrelated individuals.
So explain to the jury why we see a number like 4.4 million as opposed to 700 billion.
I'm looking at the frequency of the DNA types and the overall profile and making that comparison. So it's not quite as big as 700 billion, but it is an inclusion that's greater than 1 or whatever number you would say. I'm just giving a weight to the inclusion.
And is the number potentially explanation for it because there's so many contributors of DNA because there's 4 potential people? Or is it because you just didn't have as much DNA to analyze?
It's just looking at the overall profile and how I can include him at certain locations and the frequency of the alleles at those locations.
Were you able to exclude people from that driver's side swab?
Yes.
Who were you able to exclude?
Leroy Whitaker is excluded as a contributor to the mixed DNA profile obtained from that item.
And how about Abdul Robinson, Sr. and Jr.?
They're Junior is excluded, and 34, or I'm sorry, senior is inconclusive. I couldn't make a determination to include or exclude.
The junior was excluded.
Yes.
All right. May I have a moment to check with counsel?
Yes.
Thank you, Your Honor. That's all the questions I have.
All right, cross for Mr. Whitaker.
Good afternoon.
Good afternoon.
How are you doing?
I'm good. How are you?
Good, thanks. It's somewhat obvious, but just to get it out there, you can't see DNA, can you?
I mean, I can see red-brown staining if there's blood, but I can't see the DNA profile, no.
Sure. And like when you look at any item, and what I'm trying to have you explain for the jurors is just how tiny DNA is.
Yes, it's very small.
I've heard it referred to that you can't even, you can fit, correct me if I'm wrong, like a million DNA on the top of a pen head.
I haven't tested that.
But it's fair to say it's extremely small, correct?
Yes.
Okay. And you never know, with the exception of if you see some red-brown staining, you can anticipate you may very well have a DNA result if it is in fact blood, correct?
Blood is a rich source of DNA.
Sure. But sometimes a stain can be some other substance that's not blood, correct?
Correct.
And so there's no way you, as the analyst, when you look at any of these items, have any idea what DNA results, if any, you might get, correct?
When I look at items, I'm trained in identifying stains, so I do look for specific stains that would have characteristics of blood, if that's what you're referring to. But I don't know if it's going to be a mixture when I'm swabbing something for wear or single source, or maybe no results even.
And so let's go specifically to, I guess we have some T-shirts that you ended up analyzing, correct?
Yes.
And my understanding, and please correct me if I'm wrong, is that you did not take cuttings. You literally made your own swab. Is that correct?
Yes, I swabbed the shirts in those areas.
And it sounds like one of the reasons you would have swabbed the particular areas that you did is that you're trying to capture maybe known areas where people naturally sweat. Would that be fair?
Not necessarily sweat, just I know that has the most contact with their body, so it would have skin cells on it to identify who was wearing the shirts.
And so you look for those particular areas because you're trying to capture whatever DNA might be there, correct?
Yes.
And when we're talking about trying to get DNA from an item such as the 2 shirts that are next to you, DNA technology can tell us a lot, but it can't tell us when that DNA got on that shirt, correct?
That's correct.
And can't tell us how it got there, correct?
That's correct.
Because there is this concept of transfer of DNA, correct?
Yes, there's transfer DNA.
And I'm sure as part of your very extensive training, you've become aware of studies that they have done, scientific studies where if I grab this pen and then hand it to Mr. DeCoste, and then you test the DNA from Mr. DeCoste's possession, my DNA may very well be on that pen, correct?
Yes, it's possible. That's more so like touch DNA versus wear DNA.
Sure. But the concept exists, correct?
Yes.
And that's something you just always have to be aware of when you're doing your analysis and trying to explain the results, correct?
It doesn't really affect my analysis on the DNA because I'm still just testing what DNA is on the shirt. I don't know how it got there.
Nor do you know when, correct? Because DNA can be degraded over time, but I think we're all aware of situations where DNA has been recovered 10, 20, 30 years down the road.
Yes, that's why we do cold cases.
And so that technology exists as well.
Yes, it's the same DNA technology that I'm using.
In this particular case, you were never given a standard of Dominique Barner?
That's correct.
So you did not include or exclude him from any analysis you completed?
I made no comparisons of that person.
How about anyone named Chris Brown?
No,
Okay. How about anyone named Torrigan Williams?
no.
Did you do any testing on any hairs found?
Yes.
Okay. And what kind of testing on hair does FDLE do?
It's the same DNA testing.
There's also something called mitochondrial DNA testing, correct?
Yes, there is.
Okay. Florida Department of Law Enforcement does not do that testing,
But
correct?
they do not.
And so that was not completed in this case?
No.
Okay. And mitochondrial DNA testing is for the Y chromosome? Is that correct?
That's for Y DNA testing.
Okay.
For mitochondrial DNA, it's looking at the whole hair shaft, and I only look at the root end of the hair when I do perform DNA analysis. I do STR, which stands for short tandem repeat DNA testing.
And in this particular case, I guess there were about 70 hairs?
On what item?
I'm sorry?
On which item?
I guess total on all the different items that you were looking at?
I'm notated on item 9, which is the shirt from the driver's seat, that I collected approximately 70 apparent hairs, and that there was a clump of apparent hairs and some also remained on the shirt. And on the other white t-shirt from the rear, that had about 65 hairs, and some also remained on the shirt.
And then you ended up picking 2 out of those hairs for DNA testing?
I determined 2 to be suitable to continue DNA testing with.
Okay. I don't have anything further. Thank you very much, ma'am.
All right, cross from Mr. Robinson.
I could have one moment?
Okay.
Great. No, not yet. I'm going to come over with him. All right, thank you. Good evening. Hi.
Yes.
How are you?
I'm well. How are you?
Doing well. Your Honor, I'm going to approach. I want to retrieve Exhibit 210.
Okay.
Mr. Robinson's DNA, not involved in that one. Do you understand this to be your item 9, Exhibit 210?
Yes.
Put it over here. In front of the juror. Safe to say, when you get that, it was a dirty article of clothing?
I actually notated it was not very dirty.
Look, I have a dog, I have hairs all over my clothes, but there was a lot of human hair on that t-shirt, right?
I can't testify if it's human hair. I noted there were hairs.
There was also multiple types of DNA, right?
When you say types, do you mean like blood, semen, saliva, or different people? I don't know what you mean.
Let's leave it at this. It was not a freshly laundered shirt.
I don't know when it was laundered.
Freshly laundered meaning that it's clean, it's folded, like the shirt that I put on today before coming here. Do you have any indication that that was a clean, freshly laundered shirt?
I don't.
Okay. So you get the shirt, what I will term is the dirty shirt, and you tested it. You pulled off a bunch of hairs and you found how many were suitable?
2.
So that would have left 68 hairs that were on that shirt, give or take.
Those are the ones I collected. There were possibly more, yes.
Now, with respect to private lab testing, mitochondrial DNA testing, the remaining 68 on that could have been tested, right?
I should clarify, I wrote they're apparent hairs. I'm not saying they are definitely hairs. So I don't know if they could have been tested.
Fair enough.
If they're fibers, that wouldn't have DNA necessarily.
Fair enough. But there were, the hairs that you determine are suitable for testing, they have the root. And that's what you can test, right?
Yes, I look at the root.
All right. So however many other hairs there were, if it were 2 or if it were 68, those could have been tested because these private labs can test the actual hair, right?
Again, I'm not saying necessarily that they're hairs or human hairs or fibers. I'm just looking at items that were not suitable for DNA.
You testified a moment ago that there was a clump of hairs.
I did say a clump, and I should have said apparent hairs. I didn't pull them all apart.
But if we don't look, and we don't know, right?
I wasn't able to pull them all apart, and I'm not able to say if they are fibers or hairs. I'm sorry, I'm not trying to be confusing, but it was a clump that was all intertwined. There could have been fibers involved in them. I'm not specifying the difference between if that went to a trace DNA or a trace section instead of DNA.
You found 2 hairs that were suitable, but you would agree that there was other hairs recovered from the shirt. Understanding that some of them may have been fibers, there was other hairs that were recovered.
Yes.
That could have been tested.
Yes.
If the state chose to send them for mitochondrial testing, right?
I'd imagine. I'm not sure how that works.
Okay. Now, you got another name from the hairs, right? Tied back to a gentleman, Mr. Hogan.
Objection, Your Honor. Hearsay.
All right, sustained.
Without saying the name, you tied one of the hairs back to somebody whose name has not been said in this courtroom, right?
I'm not sure how to answer that.
We need to reject, we might need a reproach.
Okay, let me see court reporter and counsel at sidebar.
Tally says, my question would be, is she independent? We doing this, or is she told to do? So I'm assuming that Tally's questioning the examiner. Like, did someone tell her what to test and what not to test? It sounds like she made the determination on her own and that she only tests a certain kind of sample. But if they wanted to, they could have gone to another testing site that they could have sent the samples off for additional testing to pull back any additional DNA profiles if they existed. So I hope that answers, Tally. Nikki's got a question out here as well. She asks, is the honor trial on jury watch? They were doing jury charge instructions. I can go back over and check and see if they actually read the instructions, but I'm assuming that we still have to do closing arguments and they're doing that tomorrow. So I will double back and check, but I'm pretty confident they're doing closing tomorrow. Shay says, dang, who is Hogan and Chris Brown? Well, I think you know that they said Hulk Hogan, rest his soul, they said he passed away. We lost this week. We lost Malcolm J. Warner, Ozzy Osbourne, and Hulk Hogan today was announced. Now Chris Brown. Now you know who Chris Brown is. I hope you know who Chris Brown is. There will be no Chris slander in this chat room. Kim says the Hulk don't like us. I wouldn't be surprised. It ain't too many that do. Oh no, Taylor, they were mentioned in the trial. Yeah, I'm gonna pull the so after the later on this evening, I'm gonna take this video and I'm gonna put it in this place that I found. I'm gonna pull the transcript because there were so many pieces that I felt like I didn't understand, especially when it just came to her DNA analysis of who was included and who was excluded. Like I need to go back through that a second time before I feel confident. So I do know that there was a fourth person. Oh, shout out to Keisha. Keisha says that they will be doing closing arguments on Monday for the honor trial, and there's no court tomorrow. I do know that there was a third person. There was the fourth person. So is that Tor again though? See that's why I'm confused. See, it almost sounds like there's 5 people whose DNA may have had a hit. I'm gonna pull the transcript and look at it because I don't know. Nikki says that so far it seems to be a lot of reasonable doubt. Absolutely. We've got 3 instances of where the investigation was botched. We got the police. We had Mr. Collins on the stand lying about if he saw the person, how tall they were. Oh, here we go.
Yes.
But not necessarily. He could have wiped his brow with it, right?
Yes, I don't know how the DNA got on the shirt.
Nor do you know when it got onto the shirt.
That's correct.
All right. If it's 700 billion and it degrades down, you can't put sort of a time on it, like the rings on a tree, right?
So that's not really how it works. It doesn't degrade from 700 billion. That's the likelihood ratio I'm associating with comparing the two. Degraded DNA would be, let's say, a good DNA profile with information at all locations that then was subjected to, let's say, extreme heat, and it degraded and gave a different type of effect to the DNA that made it less likely for have a DNA at every location tested.
So we agree. You can't say when the DNA got onto the shirt.
That's correct.
And the fact that his DNA is on the shirt that's in the car, that doesn't mean he was ever inside of the car, right?
No, I'm just testifying to the DNA. I don't know how it got there or when the shirt got there or who was in the car.
Now let's talk about the driver compartment, okay?
Okay.
Now, you never go out to the car. You get the swab from the different compartments, right?
Yes.
I'm showing you it's been entered in as States 88. Always takes a minute. All right, does that look, I don't know if that's upside down or not. Can you see the steering wheel off to the left and then the rear, the different gears, the gear shifter?
Yes.
Okay. You agree that looks like a T-shirt from the front seat?
Yes.
Now let's talk about an example. Ms. Schlack used me for one a moment ago. All right? I'm wearing this jacket, a little bit chilly in here. Got a little bit heated this morning. But I want to be a gentleman to Ms. Schlack, so I give her my jacket. I never sit in her seat. I never sit at her desk, right? But I give her my jacket. She puts it on, she wears it, leaves for the day, I get it back, right? If a tech were to come in here and swab that seat, that desk, my DNA could be on that seat, right?
I have no idea I'm not making the connection from you wearing.
This jacket that I'm wearing right now, right? This morning, it got a little tough. Maybe a little bit of sweat in here. My DNA is in this jacket, right?
She sits it on the desk.
Just stay with me step by step. My DNA is on the jacket, right?
I don't know. I haven't tested the jacket.
It could be.
Yes.
Like that T-shirt on it, right?
Yes.
Now, I want to be a gentleman, and I give my jacket to Ms. Schlacks. I don't sit in the chair. I don't go near their table. I got my own. But I give her my jacket, right? She puts it on. It's on the chair. My DNA, we agree, is already on it. My DNA is going to end up, it's going to transfer over to that chair. That's how DNA works, right?
I wouldn't say that. The inside of your jacket is where you're assuming that I'm saying the DNA is at, or the outside. I'm not. I haven't tested the chair or your jacket to say that there's DNA on it.
Why don't we make it easier than a jacket? All right, my client's hanky, right? I use it. Hands are a little sweaty, nervous, right? And I want to be a gentleman again, and Ms. Schlacks, here you go to be able to use it, right? So my DNA, I wipe my nose, sorry. My sweat's on it. My DNA is on this. I'm telling you my DNA is on it, and I give it to Ms. Schlacks. Now, when she's here, she puts it on the table, and at the end of the day, she figures she leaves it on the chair. My DNA has made its way over to that table without me ever being at that table, right?
Okay.
It's possible.
Yes.
That is a thing that you have the transfer of DNA.
So are you saying the DNA is now on the table?
I'm saying that my DNA very well, in actuality, because I just touched it, my DNA very well could be on that table right now.
It's possible. It all depends on the friction, the length of time. If I'm pressing hard on something to leave my DNA on the item versus just gently tapping on an item, if it's just sitting on a table, it's not going to necessarily jump off the handkerchief onto the table. But if you apply pressure to it, then it's more likely to transfer the DNA from one item to another.
All right, now this T-shirt, you didn't get back 700 billion times. You got back 4.4 million, right? That's much lower.
You're not phrasing it the way that I did, and
Well, tell
I'm
me how you
making
phrase it.
comparisons. So I'm not saying the shirt has 4.4 million.
No. I want to make sure that we're clear because we're not talking about necessarily the shirt. Right now, we're talking about the swab of the compartment, right? So let me back up for the example. This may help out. The swab is done by one of the evidence techs here in Jacksonville and then sent to you, right?
Yes.
So they go in there, and in this example, right, I'm the tech, and I got my swab, and I go out here, and I have one swab for the front compartment. Now, this handkerchief, it's there in the front compartment. I'm swabbing. I move that out of the way. I'm swabbing here, I'm swabbing here, I'm swabbing the front, and I'm getting DNA. What I'm talking about is the fact that that T-shirt had his DNA on it. You can't rule out that the DNA transferred to the compartment, and that's why it comes back. You can't rule that out, can you?
No, I don't know how the DNA was on the compartment.
It very well could have been because there was a T-shirt that had his DNA all over it sitting in the front compartment.
I don't know how his DNA got on the compartment.
All right. So for the example that we use, that hanky, but now I've been over there, but that hanky, because I touched it, my DNA was on it. My DNA is now on the table, on the chair. It can transfer that way through an article of clothing.
Just because you touch it doesn't mean your DNA is on it.
But it could get on there.
Yes.
Okay. So,
Sum this up. This T-shirt has my client's DNA on it, right?
right?
I included him into a mixture.
All right, so you believe his DNA is on it.
Yes.
That T-shirt is rolled up in the front compartment, right?
Yes.
One swab is used for the entire front compartment.
Let me see.
When I say the front driver compartment.
And you're saying how many swabs they used?
Well, you already told us one swab.
I said I used one swab to swab the T-shirt.
No. The front compartment of the vehicle, you didn't swab it. It was given to you. How many swabs were used in the front compartment, if you know?
I can look. I didn't already tell you.
Okay, sure, please.
There was one swab that was used.
All right. So you got one swab. The T-shirt's gone. They're swabbing the front compartment. You can't rule out the possibility that the reason why the DNA is showing up in a mixture in the driver compartment wasn't because it came off that shirt.
I don't know how the DNA was deposited on the driver's compartment.
My question to you is, you can't rule out that it didn't come from that shirt.
No, I don't know how it was there.
So with all of your testimony here, you have no way of saying that Hakeem Robinson was ever inside of that vehicle.
No, I don't know that.
And the last question is the mixture that you, no further questions, Your Honor, I'm good.
All right, thank you. Is there any redirect?
Ms. Heisler, there was some discuss about all the hairs and I want to have you explain a common misconception to the jury, because they may see crime shows where crime analysts are able to provide DNA results after a commercial break. Is that the way it works?
No, it's not. I did look at the hairs under the microscope, and when I determine the suitability, I determine if they're suitable for DNA. I don't notate why they are not suitable. It could not be suitable because there was no root or because it's not a hair. I don't notate that.
And I want to, part of it is I want to explain to the jury that is this time consuming to do all this DNA analysis?
Yes, it is. It takes multiple days, weeks, months.
And in going through your reports, I know that your first report was authored May 29th of 2020. Is that right?
Yes.
And that your last report was authored July 19th of 2022.
Yes.
And you've been working on it. So, I mean, I want to give the jury an idea that this is not something that is done in 20 minutes or even a day, that this takes weeks, months, years for all the DNA testing that you're doing.
That's correct.
That's all the questions I have, yeah.
All right, may this witness be excused? All right, thank you, Ms. Heisler, you're excused. All right, are we wanting to call one last witness?
We have one last witness we can call. It should be relatively brief, albeit we have to go through some photographs.
All right, ladies and gentlemen, just for scheduling purposes, this will be our last witness of the day. Is everyone okay to hang tight here? Do you all need a bathroom break? You want to go forward? Everyone's good? Okay. I see hands going like this. All right, very good. Then State, call your next witness.
Call Dr. Robert Whitaker.
Yes, sir. Thank you. I don't want to publish until he's ready to go.
Okay. I'll do it after. All right, Dr. Pytek, if you'll come forward and be sworn. All right, sir, if you'll just be sure to speak closely and clearly into that microphone.
Doctor, go ahead and introduce yourself to both juries, please.
Good afternoon. My name is Dr. Robert Pytek.
What do you do for a living, sir?
I am a chief medical examiner.
What's that?
That's a role that I play in the District 4 medical examiner's office as the chief, overseeing the operations of the office as well as supervising the other pathologists.
So how long have you been the chief medical officer or doctor in the Fourth Circuit?
6 years.
How long have you been a medical examiner?
Since 1999.
Explain to the jury your education, training, experience that allows you to operate in that capacity.
Yeah, so after medical school, I attended a residency program in both anatomic and clinical pathology at the University of Kansas Medical Center. This was followed by a senior residency position at the Hahnemann University Hospital in Philadelphia, which was followed by a fellowship program at the Philadelphia Medical Examiner's Office in the branch of forensic pathology.
What's pathology?
Pathology in general is the examination of tissues and bodily fluids to determine a disease state within the body.
So we've heard things like sample, like a skin, potential skin cancer, to the pathologist? Is that what you're talking about with pathology?
Correct. A surgeon will remove a piece of tissue that gets sent down to the pathology, and the pathologist looks under the microscope and determines the disease process.
What is a forensic pathologist?
So a forensic pathologist is a subspecialty of general pathology. This has to do primarily with the determination of the cause and manner of death.
And do you have specific training in that regard?
Yes,
Are you board certified as a forensic pathologist?
I am.
Are you a medical doctor?
Yes,
And you're licensed to practice medicine here in Florida?
yes.
Approximately how many times have you testified as a board certified forensic pathologist?
It's been hundreds.
Have you been allowed to give your opinions on cause and manner of death?
Yes.
Your Honor, at this time I would tenure the witness as an expert in this field.
All right, any additional voir dire from Defendant Whitaker? And from Defendant Robinson? All right, thank you. You may proceed.
Thank you, Your Honor. So we mentioned cause and manner of death. Can you explain to the jury what a cause of death and then what a manner is?
So a cause of death is any process or injury to the body that causes the heart and brain function to stop. Manner of death, from the standpoint of a medical examiner, can be divided into 5 separate categories. It can either be natural, accident, suicide, or undetermined.
And is it your job to determine how somebody died and then how that death came to be?
Yes.
The uses of autopsies, explain to the jury why that is necessary for you to determine cause and manner of deaths in most cases.
In most cases, the individual comes into the office. There may or may not be a history. We have to do the examination, both an external and internal, to determine what's actually going on disease-wise or injury-wise.
And is photography important for that?
Yes.
And why is that?
Each case gets photographically determined and qualified and put in the autopsy report.
So, sometimes we think about medical records. Have you written a medical record report in this case?
I have written a postmortem report.
Okay. And so that's akin to a medical record, but you have hundreds of photographs that you're also able to refer to. Is it important to go back and refer to those photographs because 5 years later you may not remember everything?
That's correct.
Okay. And have you reviewed the photographs in this case as well?
I have.
So do you have your file with you, doctor?
I do.
And is it going to be in ME medical examiner number 2137?
20-0137, correct.
And the name of the deceased was Charles Quinton McCormick Jr.?
Correct.
And is that who you performed your autopsy on and rendered opinions about cause and manner of death?
Yes.
Your Honor, at this time the parties have entered into stipulation.
All right, ladies and gentlemen, when the parties agree that certain facts are true, that's called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that the body examined by medical examiner Dr. B. Robert Pytak on January 31, 2020, marked as ME number 20-00137, was the body of Charles McCormick Jr.
Thank you. And Your Honor, I think we have a Scrivener's error as to the date. Doctor, when was the date of your autopsy that you did in this case?
It was on January the 16th, 2020.
Okay, we're going to go through a series of photos, but just to begin with, I think it's obvious. Doctor, have you subsequently watched a videotape purported to be the shooting of Charles McCormick?
I have.
Okay. Regardless, were you able to determine what killed Mr. McCormick?
Yes.
And what was that?
Multiple gunshot wounds.
And was the manner of death a homicide?
Yes.
Okay, we'll wrap that up at the end. Now I want to go through the photographs. If you can explain to the jury these series of photographs and what they mean. And your screen, if you need to telestrate anything, you can use as a telestrator. We're first going to look at State's Exhibit 148. What's the purpose of this photograph?
This is the identification photo of the decedent.
And that is the unique medical examiner number of 2137?
Correct.
Do we know an injury to the left cheek of the individual?
Yes.
Now we're looking at State's Exhibit 149. What is this?
The front view of the decedent, still with the clothing on.
And is there a measuring stick there?
Yes.
And what is the purpose of that?
To get an approximately measurement of the height of the body.
And referring to your report, were you able to get a height and weight of Mr. McCormick?
Yes.
What was that?
The height was measured at 70 inches, the weight 143 pounds.
And 70 inches comports to 5 feet, 10 inches?
Correct.
And why is it important to show the body clothed, and then later we'll see photographs of the body unclothed?
Generally, in the entire scheme of things, when the body comes into the office, we get an as-is photograph. Then the clothing is taken off, and we get further photographs.
State's Exhibit 150, is this a photograph of the collection of that clothing?
Yes, it is.
State's Exhibit 151, is this Mr. McCormick after the clothing was taken off?
Yes, it is.
Do we note significant injury to his head and face?
Yes.
State's Exhibit 152, is that chin injury that we previously saw in the identification photo?
Correct. This is an entrance gunshot wound to the left cheek.
And how can you tell it's an entrance versus an exit?
So an entrance usually has a small abrasion margin surrounding the edges.
And so you can tell from your training experience and education that this is an entrance wound.
Correct.
And you can say that within a reasonable degree of medical certainty.
That's correct.
State's Exhibit 153, what are we looking at here?
This is the corresponding exit wound to that previous entrance wound.
And you can tell that based on your education, training, and experience.
Correct.
So the measurement things here, is that just to document the size of the wounds?
That's correct.
State's Exhibit 154, what are we looking at here? We're not going to dwell on this one, but what are we looking at?
This is an exit wound to the top right portion of the head.
So the nature of that significant wound, doctor, does that give you an opinion about the type of ammunition that was used to shoot, or the type of rifle or firearm that was used to shoot Mr. McCormick?
Yes, when I take a look at the entrance wound.
We're going to see that in a little bit, but go ahead.
Yes, and compare it to the exit wound. Certain types of ammunition produce characteristic wounds.
And what type of ammunition do you see from these photographs?
A high-powered weapon.
State's Exhibit 155, what are we looking at here?
This is an exit wound to the left top of the shoulder.
State's Exhibit 156.
This is the corresponding entrance wound to the left armpit.
State's Exhibit 157.
A little bit further down on the left is the entrance wound to the left chest.
158.
Here's a entrance wound to the left hip.
159.
There are multiple superficial lacerations on the left lower leg.
160.
There's an entrance wound to the top of the left foot.
161.
Corresponding exit wound to that left foot.
162.
Here's an entrance and exit wound to the medial portion or the side portion of the right leg.
163.
These are exit wounds to the right hip.
164.
A superficial laceration to the right arm.
165.
I believe this is a close-up view of an entrance wound to the upper left thigh.
166.
Here we can see entrance and exit wounds to the back of the left heel.
So we see one of them very clearly. Is the other one beneath the 4 on the ruler?
Yes.
On the white ruler? Say Exhibit 167.
This is again the bottom portion of the left foot.
168, is that entrance wound that we saw with the massive head wound earlier?
That's correct. This is the corresponding entrance wound to the back of the head.
And so is it very common for the entrance wound to be very small and the exit wound to be significant?
Yes.
Why does that happen?
The amount of pressure that goes through the gunshot, it creates a cavity and causes more damage on the exit than on the entrance.
169, what are we looking at here?
These were teeth discovered in the body bag.
So you document, photograph those, and collect them?
Correct.
170, what are we looking at here?
So here we are looking at an x-ray of the chest and the right arm and a portion of the left arm. Here we see a bright white metallic object.
If you could circle that, doctor, so we can see what you're talking about. Thank you.
Which corresponds to a bullet.
And you were able to remove and collect that bullet?
Yes.
Stacy Exhibit 171, what are we looking at here?
Here are other fragments in the right arm and just right of the right chest.
Circle those so the jury can see. Thank you. Next. 172.
Here we see another bullet fragment on the left lower abdomen.
Thank you. And then 173.
Here we see multiple fragments or actual bullet fragments in the right leg and portions in the left leg.
Thank you, doctor. 174, is that a collection of some of those items?
That's correct. These are the evidence envelopes that I created, documenting where each fragment was recovered from.
175, again, some of those items that were collected?
That's correct.
These are going to be fragments found within the body?
Yes.
Exhibit 176, can you specifically talk about what I consider relatively pristine bullet here? Is that the one we saw in the chest, below the clavicle, I guess?
That's correct.
I'll show you that in a second. I'll show it to you now. All right, we have one of them, doctor, the very, what I consider pristine bullet. It was taken in the cavity in State's Exhibit 12. Is that going to correspond to the to 170?
That's correct. That's the bullet recovered from the mid-chest.
And there are notations and documentations on the envelope to show it came from your office, meaning you collected during the office.
Yes.
Your office is training about how to preserve and collect it.
Yes.
And then I'm going to show you three other items that were collected. I don't think these are the evidence, but I'm going to show you what's been pre-marked. The State's Exhibit 9F. 9G. And 9E. So these three items, take your time to look at them, come from your office and were collected during the course of your autopsy.
Yes, they were.
Now, I would move these three items into evidence as their pre-marked numbers.
Okay, is there any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, then State's Exhibit 9E will be moved into evidence as State's Exhibit number 213. State's Exhibit 9F will be moved into evidence as State's Exhibit number 214. And State's 9G will be moved into evidence as State's Exhibit number 215.
Thank you, Your Honor. Doctor, approximately how many gunshot wounds did Mr. McCormick suffer from?
Total of 9 gunshot wounds.
And were all of them lethal?
Well, any gunshot wound can be lethal. We usually, when we talk about gunshot wounds, which are more serious than others, and in this particular case, the more serious ones were to the head and to the chest cavity.
So, like, for example, the one that goes through his foot may kill him, but it's unlikely.
Correct.
and the one that went through his head would have been much more serious, and the one that went through his chest would have been much more serious.
Yes.
The 9 gunshot wounds, was there any other explanation in your examination as to what ended Mr. McCormick's life?
No.
And so, within a reasonable degree of medical uncertainty, what was the cause of his death?
Cause of death was multiple gunshot wounds.
And what was the manner of death?
Manner of death was homicide.
Thank you, Doctor. I appreciate it. I have no further questions.
All right, cross-exam from Defendant Whitaker. Cross-exam from Defendant Robinson.
Yes, Your Honor, briefly.
Okay.
Doctor, good afternoon. My only line of questioning is with respect to height. Now, when you measure height, somebody that comes to you, they're laying down, correct?
Correct.
And as a doctor, that could be different than standing height, correct?
It may be, yes.
By small margin.
Correct.
And the reason for that is things like loss of muscle tone.
Correct. There may be some rigor mortis more pronounced than usual.
Also, when you're measuring that you came back at 70 inches, that's an approximation. That's why we have a round number instead of 70.3.
Correct.
And then finally, post-mortem, can there also be changes in the body that affect height?
Like I said, there may be some advanced rigor mortis, or there may be complete loss of rigor mortis.
In general, the changes, it could be somebody is a little bit smaller than they were when they were living and standing.
Usually it's just an approximation, so it's not a real definite measurement.
He could have been standing before he was killed. He could have been 5'9".
It's possible, I don't know.
Could have been 5'11". You don't know.
Sure.
But there's a range, and yours is just an approximation, not an accurate living height assessment.
Right, based on the body lying on the tray and the measuring device, yes.
Thank you so much, doctor. That's all I have.
All right, is there any redirect?
No, Your Honor.
All right, may this witness be excused? Okay, thank you, Dr. Pytak. You're excused and free to go. All right, ladies and gentlemen, it is 5:30 on the nose. We are going to recess for the day. I'm going to ask that you leave your notepads on your seats. We will lock them, secure them, and return them to you when we reconvene tomorrow. Again, we'll be here in courtroom 407 starting at 9 o'clock, where we will continue with the state's case in chief. I must remind you that during this overnight recess, you're not to talk about this case among yourselves or with anyone else, or allow anyone to say anything to you or in your presence about the case. And of course, again, if anyone attempts to speak to you, please notify me by giving a note to the bailiff. Additionally, please make every effort again that overnight tonight and tomorrow morning you do not read, watch, or listen to any newspaper stories or television shows that might be aired about this case. And that's because this case has to be tried by each of you only on the evidence presented in this courtroom, in your collective presence, the presence of the defendants, the attorneys, and this court, and only based on the facts and evidence that come out at trial and on the law as I instruct you in it. So please make every effort to follow those directions. And I'll just remind you again, if you do see witnesses or attorneys outside as you leave today or tomorrow morning as you return, you are not to engage them in any conversation whatsoever. So with that, I wish you a good evening, and you are now excused and free to go.
Mr. Ali, have you had time prior to today to talk to Mr. Kading about whether or not you will testify during the trial?
All right, y'all.
Yes.
I'll be back on tomorrow morning. I think this trial starts a little bit early, but it is on the East Coast side, so we won't be able to take anything I can do today, but we will watch and continue to watch this trial as it unfolds. Thank y'all so much for rocking out. If you haven't already subscribed to this channel, make sure you do that, and make sure you hit the like button on your way out the door. Have a good evening.